Okay. Hi, this is Renee Line, Chair of the Colorado Real Estate Commission. Today is December 2nd, 2025. It is 9 a.m. This is a public meeting of the Colorado Real Estate Commission, and we will now call this meeting to order. Let's begin by having Director Waters call roll
Renee Lind,
here.
Autumn Rubal,
Here.
Erica Doyle,
Here.
Erica Sanders,
Here.
Bernadette Bougerin.
It's Bulgarian in here.
Sorry, you have a quorum.
Okay, and David, did you want to do your CE presentation?
Thank you, Madam Chair. Excuse me. Everyone, I will be launching a poll here that should appear on your screens. For members of the public that are seeking continuing education credit for today's meeting, I would respectfully request that you complete the poll that has just been launched. If this meeting lasts for the required duration, a licensee may receive continuing education credit for attendance here today. You must attend for the required duration. And of course, if you have any difficulties either with this poll or afterwards, please do not hesitate to reach out to me at david.donnelly, that's DONNELLY @state.co.us about the continuing education credits. So with that, thank you, Madam Chair. And as licensees are answering that poll, you can proceed with the next steps in this meeting, and then I will take down the poll after another minute or so. Thank you.
Okay, next we're going to approve the meeting minutes. So can I have a motion to approve the board meeting minutes from October 7th, 2025?
Motion to approve the minutes from October 7th, 2025 Real Estate Commission meeting.
Do we have a second?
Second.
Okay, so we have a motion and a second. Any other discussion? All right, all those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes. The next item on the agenda is public presentation for issues not on today's meeting agenda. Does anyone have any other items to discuss? Okay, seeing none, we're going to move into hearing matters. And Erica, I believe you're going to.
Yes, I will be recusing myself due to possible actual or perceived comments from item A.
Okay, and I will be recusing myself as well. So Erica Sanders, are you doing the motion on the next hearing?
I am, but do I have the wrong agenda? Let's see. Okay, my agenda's off that I printed earlier because I had the rulemaking hearing first. But yeah, I'm definitely doing that. Let me just get my notes. Okay, so just quick question. Am I just starting with the introduction?
Yes, that'll work.
Okay, perfect. All right, well, we will now take up the hearing matter, case number RC 2023-0010, Colorado Real Estate Commission petitioner versus Justman, ER 1000-31318, respondent. Oral arguments were previously scheduled for October 7th, 2025, and have been rescheduled to be heard today on exceptions to the initial decision filed by both petitioner and respondent licensee. Present to assist the commission in reaching a final agency order are Melissa Phipps, Senior Advisor, and Sue Kim and Felice Haas, Assistant Attorney General as Adjudicatory Counsel. Thank you. Can you please make sure that audio is good for those individuals?
Mr. Pipes, I have requested that you unmute. Would you like to test your audio real quickly here?
That would be fantastic. Can you all hear me?
Absolutely. Thank you,
Yes.
sir, very much. And Ms. Justman, I've also requested you to unmute, or given you permissions to unmute. I see that you're still currently muted. So if you'd like to test your audio real quickly here.
Test.
Perfect. Appreciate it. Thank you so much.
Thank you. A hearing has been conducted by an administrative law judge. The commission has had an opportunity to review the ALJ's initial decision, exceptions to the initial decision filed by both the petitioner and respondent, and the parties' responses. The parties have been informed that oral arguments will proceed today, after initial matters, public comment, and possibly executive session. The parties have been informed that oral arguments will when called, each party will have 10 minutes to present arguments. The commission will then deliberate on whether to adopt, modify, or otherwise act on the initial decision and proceed to a final agency order and final discipline, if any. We may table the case to take the matter under advisement if needed. At this time, is there a need for executive session? If so, I invite a motion to enter executive session to discuss legal questions, options, or issues with counsel and to consider matters required by law to be kept confidential.
And since, I see she just muted. Sorry, Commissioner Line will be recusing herself, as she stated, for the substance of this discussion. However, we do need her vote to enter into executive session. So I think we may have lost her a minute too soon.
Okay. Do any of the other commissioners want to go into executive session to address any questions or get any legal advice?
I'm okay for right now. I think we have that option after testimony, should we have any relevant questions that pop up.
Okay. If no need to go into executive session, then I guess we can go ahead and get ready for oral arguments. I will now ask each party to identify themselves. Appearance for the petitioner, please.
Andrew Pipes on behalf of Rachel Justman, and I believe Rachel Justman is also present and will also be speaking on her own behalf.
Thank you. And then appearance for the respondent, please.
David, you may need to unmute Anthony Lawley.
Here we are. There you are, Mr. Lally.
Oh, hello. Can you all hear me okay?
Yes.
Yes.
Okay.
I
Thank you.
apologize about that.
No worries. No worries at all. Anthony Lally appearing on behalf of the Colorado Real Estate Commission.
Okay. And parties, please note that the commission members have had an opportunity to review the initial decision, the exceptions, responses, and the administrative record. Please recall that you tendered your evidence at hearing to the ALJ. The evidentiary record has been closed. You have identified your challenges to the ALJ's initial decision through exceptions in writing. Today is your opportunity to address the commission regarding exceptions and only the exceptions. No new additional evidence may be offered or considered. I understand that respondent may address the commission and share time with her counsel. I will allow only one speaker at a time. Commissioners, it's important for each of us to understand the position of each party as presented in the written exceptions and responses and as presented in today's oral argument. I will call for commissioner questions before each party rests from its argument, but may also allow commissioner questions at the end of both parties' arguments. I will ask commissioners to please focus any questions on what is necessary for the commission to reach a decision. As chair, I may make necessary and proper limitations to commissioner questions. Each party will have 10 minutes for oral argument. I will call the respondent first, followed by the petitioner. Questioning by commission members will not count against your 10 minutes. Melissa Phipps and David will serve as timekeeper. Please signal the parties when time has concluded. Let's proceed with the oral argument. For respondent, please proceed with your argument. Commissioners, please let me know if you have a question for the respondent's counsel. All right, we may proceed with the argument for the respondent.
Good morning, commissioners. Thank you so much for the opportunity to speak with you today. When I saw the AG initially didn't want that to happen, I was quite upset. I think one of the hardest parts of this has been feeling a bit misunderstood. I want to begin by acknowledging the seriousness of the issues before you and taking full responsibilities for the mistakes I made. I understand the concerns the division has raised, and I understand how my actions appeared. Some of the choices I made were influenced by fear of failing clients, fear of disappointing my business partners, fear of being overwhelmed by the responsibilities I was carrying. That fear led me to handle certain situations poorly, and I'm sincerely sorry for the impact of those choices. I want to share how I came into this profession. I moved to Grand Junction as a 23-year-old, newly licensed. I wanted more than anything to be a successful real estate agent and property manager. People often say to stay away from property management. It's higher risk, sometimes thankless, but I have always loved it. It's made me a better, more well-rounded professional. Over the years, I've poured myself into this work. I oversaw leasing for around 900 units, managed about 400 of those, annually selling around 10 million in volume, became a part owner, and then served as employing broker, all while raising a family. I share this not to excuse my mistakes, but to give some context for the level of responsibility I carried and how overwhelm influenced some of my decisions. I care deeply about my clients, about my team, about my work. And although I handled much of that workload well, I did not handle everything perfectly. This experience has been deeply humbling. It has made me confront patterns of avoidance and fear that I didn't fully understand before. I'm a better, more grounded professional because of this process. I am not running from my mistakes. I am learning from them in a meaningful way. I'd like to address the proposed penalty. I understand and accept that consequences are appropriate. I also recognize that revocation would disrupt the continuity of service for my clients and the operations that I'm responsible for. My hope is to be allowed to correct the issues directly and continue providing the level of professionalism I know I'm capable of, rather than being removed from the work entirely. Respectfully, I do feel that revocation may be more severe than the violations themselves reflect. My mistakes did not come from intentional harm, but from overwhelm and some poor judgment during a very demanding period. Discipline is necessary, but a penalty short of revocation would still hold me accountable while allowing stability for the people and systems that depend on me. I'm not asking to be excused. I'm asking for the opportunity to continue in this profession, to demonstrate what I've learned, and to practice with greater transparency and rebuild with integrity. I want to say that I respect whatever decision you make today, and I appreciate the seriousness of your role and the standards you uphold for our industry. Thank you very much for listening and for considering both the accountability I owe and the fuller context of who I am and who I am working hard to become.
Yeah, thank you, Ms. Justman. And this is Andrew Pipes, representative. I'm an attorney representing Ms. Justman in this case. And um, yeah, I appreciate her words, and I wanted just to add a little bit of context. Now, I know, as Commissioner Sanders just informed us, that this body has received our exceptions in writing, and I certainly won't belabor or simply repeat what this body's already read. I presume you understand our position. And I think it's the context is important here because when Ms. Justman highlights the fact that she had a lot on her plate and she was trying to follow all of the rules. Um, you know, I think this case came down to two separate kind of issues or themes, if you will. One of which is this concept of a designated brokerage. Now, as you read in our exceptions brief and in the initial decision from the ALJ, there's nothing wrong with a designated brokerage. And what a designated brokerage is when there's a single brokerage working on both sides of the transaction. Right? Now, that is explicitly legal, and the ALJ identified that on page 14 of her initial decision, that this is a perfectly legal business model. Right? Now, through reasons that are somewhat vague and are kind of highlighted by a single individual whom this body actually voted to revoke his real estate brokerage license um, for improper conduct. There was testimony that the way that Ms. Justman performed this perfectly legal business model was improper. Right. And it essentially centered around this idea that, well, Miss Justman didn't disclose that her brokerage firm was also working for tenants. Miss Justman was working for the landlord. A different broker at the same brokerage firm was working for tenants. And that was the crux of about half of what this case is about. And what's confusing about all this, which is where I think Ms. Justman has found some consternation in all of this, is that the commission actually has stated that this concept does not require disclosure. It's Commission Position 22. Um, so Ms. Justman set up a perfectly legal business model, which is permitted under Colorado revised statutes, right? Followed the commission position statements that disclosure was not required, and then was subsequently prosecuted and is now being punished for those actions. Now, again, I think as Ms. Justman told you, she realizes she didn't do everything perfectly, and she didn't. And I'll tell you that as well. There are steps that she could have taken that would have been more advisable in the moment. However, I think when you look at the big picture and what Ms. Justman was attempting to do and the way that she was conducting her business, um, we believe that revocation, which is the harshest punishment this body can levy, is 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 too far. It's improper. Um, and then the other kind of central aspect or theme of this case, right, is who her managing broker was. Now, the backdrop of all this, as you know, is that in 2018, when Ms. Justman was just entering the real estate world, she had a case where there was a dispute over a security deposit and went to hearing, found that Ms. Justman was in the wrong. So as a result, Ms. Justman was required to be supervised by a supervisor that was approved by the Division of Real Estate. And so when she had her final agency order issued, she did just that. She had a supervising broker notify the division that, hey, I'm aware of her terms of probation, and I will be her supervising broker. And the division accepted that. And this was in 2018. Hmm. Fast forward 5 years, and the division and the attorney general levy a notice of claim, a notice of charge rather, against Ms. Justman, saying, well, your supervising broker wasn't competent enough, so we feel that you didn't uphold the terms of your probation. This is 5 years later. The division decides to revoke their approval of her supervising broker. Now, whether or not her supervising broker was or was not competent is really sort of somewhat beside the issue here. The idea is that Ms. Justman was trying to follow the terms of her probation. She did everything that the commission asked her to do. And she may not have done it, she may not have gotten an A+ on the test but she took the test. Right? She followed the rules. She tried her very best to comply and learn and grow within the system and following the rules. And so, one thing I want to leave this body with when it goes back to deliberate is there appears to be a vague set of rules that I'm not sure are being applied evenly in this particular case. I think Ms. Justman has done her very best to comply and will continue to do her best to comply with all regulations, including commission positions and statutes, in an effort to grow and be a better broker. And we don't think revocation is an appropriate punishment.
Okay, thank you so much. I appreciate that. And for petitioner, can you please proceed with your argument?
Good morning, commissioners. Your task here today is to answer 4 questions. 1, are the ALJ's factual findings supported by evidence in the record? 2, did the ALJ correctly find that respondent, a repeat offender who the commission previously disciplined, violated counts of licensing law? 3, did the ALJ, administrative law judge, err in determining that respondent did not commit count 2, which alleged that respondent converted or diverted security deposit funds, the same conduct that she was previously disciplined for? And the 4th question is, did the ALJ recommend appropriate discipline? The answer to each question is yes. Yes, the ALJ's factual conclusions are supported by evidence in the record. Yes, the ALJ correctly found that respondent violated licensing law. Yes, the ALJ erred in finding that we did not establish that respondent diverted funds. And yes, the ALJ recommended appropriate discipline given the egregiousness of respondent's conduct. I will focus my limited time here on count 2, the diverting of client funds issue, but I'm happy to address questions on any of the issues raised on exceptions. But before I get into that, I want to first address a couple of things highlighted in respondents' oral argument while they're fresh on everyone's mind. Starting with discipline. It's important to remember that the ALJ's recommended discipline, which was license revocation, fines, and public censure, is the same discipline that the commission directed our office to pursue. It's also important to remember that this proceeding, as it was indicated by Commissioner Sanders, is not a trial. Respondent statements here, my statements here, opposing counsel statements here are not evidence. The parties had their day in court, and respondent was able to call and question witnesses, introduce evidence, and testify. To the extent that respondent raised some of these concerns at trial, especially her background and that it was an honest mistake, it's unclear that those were raised, but even if they were raised, the ALJ clearly was not persuaded in reaching the decision it did. License revocation is a severe sanction, but egregious conduct warrants severe sanctions. Respondent's multiple licensing violations included her failure to comply with a commission order. This specific violation is especially egregious and shows that respondent is incapable of being regulated. As the other side kind of highlighted, the commission's order merely placed respondent's license on probation and imposed specific requirements respondent must follow to practice. These requirements were clear, they were not convoluted, and respondent failed to follow them. And then respondent appears to instead blame everyone but herself for failing to comply with this order. She, in her briefing, blames her supervising broker for not properly supervising her. She blames the Division of Real Estate for not catching that her selected supervisor was her employee. She blames the commission for, quote, an alternative understanding of the words and phrases contained within the FAO, and using that quote, alternative understanding to discipline respondent. Respondent's blame shifting tactics are even more galling when considering the context surrounding the commission's order. This order was a second chance. It was designed to rehabilitate respondent so she could be a compliant and productive real estate broker. Ignoring these requirements shows that respondent has no interest in reforming her ways, despite what she says here today. And as the ALJ noted on page 15 of her initial decision, license revocation is the only disciplinary avenue available when faced with a broker like respondent who is uninterested in changing her ways. And while I focused much of my discussion on respondent's failure to obey a commission order, it's also important to note that respondent committed other serious licensing violations. These other serious violations underscore the egregiousness of respondent's conduct and shows that she is a danger to the public. Given this fact and respondent's lack of accountability, disinterest in rehabilitation, and prior disciplinary history, the commission's only choice to protect the public is the discipline recommended by the ALJ: license revocation, max fines, and public censure. There's also some discussion on how the licensing law requirements were vague and how respondent attempted to comply in good faith. I want to briefly note that there is no factual findings supporting this argument. The ALJ's decision is devoid of any discussing regarding vagueness or respondent's good faith compliance. It's not discussed in the findings of fact, it's not discussed in the conclusions of law, and it's not mentioned in the disciplinary recommendation. And this omission is telling. It shows that the ALJ did not find respondents' excuses credible, and you shouldn't find them credible either. I'd like to now turn to count 2 and the ALJ's decision that we did not establish it. As I noted earlier, count 2 alleges that respondent violated licensing law by either converting or diverting security deposit funds without prior authorization. The commission can overturn this legal conclusion if it has a reasonable basis in law. And here, there is a reasonable basis to overturn the decision. The ALJ erred in its analysis. The ALJ only addressed the converting aspect of count 2. If the ALJ addressed the other component of this claim, whether respondent diverted funds without prior authorization, then the ALJ would have concluded that respondent did commit count 2. The ALJ found as fact that respondent, without prior approval, took a portion of a security deposit and used this amount to pay a property maintenance invoice. These actions are a textbook example of diverting funds without prior authorization. And in fact, respondent admitted as much during her testimony at trial and in her written closing briefs. Given the substantial evidentiary support, the commission should find that respondent committed count 2 and reverse the ALJ's decision on this count. I will also note that if the commission does find that respondent committed count 2, then it should also increase the imposed fines by $2,500 to reflect this violation. The ID contemplates max fines for respondent's conduct, and if there's another violation added, that would increase those max fines. As my time comes to a close, I want to circle back to what I said at the beginning. The commission has 4 questions to answer, and the answer to each question is yes. Yes, the ALJ's factual findings are supported by evidence. Yes, respondent violated licensing law. Yes, respondent committed count 2 by diverting security deposit funds without authorization. And yes, license revocation, max fines, and public censure is warranted. If there are any questions, I'm happy to answer them. If not, thank you for your time.
Thank you very much. Commissioners, Please let me know if you have any questions for the petitioner's counsel or to the respondent. I guess we could just open up questions for both, to be honest. Does anyone have any questions? I do. If no one else does, I do. Okay.
Same with your questions.
All right. So my question, which would be for the petitioner regarding count 2, was there any evidence to disprove the software issue?
The ALJ found that there was no intent that the money was moved around because of the software issue. Our position is diverting funds without prior authorization includes both accidental and intentional. And it's clear from both the factual findings that the ALJ had, including in respondent's own testimony at trial and her positions in the closing briefings, that these funds were diverted without prior authorization, and that this is a violation of licensing law. Specifically, I believe it's 12-10-217-1I as in igloo.
Okay, thank you very much.
And Commissioner, do I have an opportunity to respond to that question just briefly?
Yes.
I think just to answer your question bluntly, no, there wasn't. In fact, the individual who levied that complaint, I don't know if the answer was refused to testify or was not called to testify, but there was no evidence from her from the complaining witness at all. So the only evidence that was presented at the hearing was from Ms. Justman, who testified kind of to the effect of it was a software issue when there was a turnover.
Thank you so much. I do have one more question. This would be for the respondent. Well, it's kind of layered questions actually, but this is in regard to count 5. Does Caprock or the respondent have any ownership in the PPS company?
Yeah, I can explain that. It's a little convoluted. So Caprock, the entity, does not. And this was a fair bit of confusion amongst with the ALJ. The entity has zero ownership in PPS, and Ms. Justman has zero ownership in PPS.
Okay.
The overlapping ownership is with some of the other owners of the Caprock entity, who are the owners of PPS.
And did Caprock or the respondent benefit financially at all from PPS?
Negative. It was only the other members of Caprock, but Caprock, the entity, and Ms. Justman get no. And that was kind of exacerbated at trial. I think there was one line to the effect of, if PPS were to make $10 billion in revenue, how much money would Ms. Justman and Caprock make? And the answer is $0.
And then my last question,
Commissioner?
kind of along the same line,
May
is
I have a chance to respond?
yeah, okay, I have one more that you might want to respond to, if they're all related.
Oh, okay. I apologize for interrupting.
No, that's okay. My last question in regard to those questions is the respondent related to, I understand that Sites, maybe, or Bishop, are the partners at Caprock, but they also are the owners of PPS, and I want to know if there's any actual relation in terms of, family relation.
Yeah,
within
the answer is no. The only relation is that they work and own Caprock, the entity, together.
Okay.
There's no familial relationship.
Okay. Thank you so much. That was all my questions. If you want to go ahead and proceed to answer those all too, or respond to those all.
Thank you, Commissioner. Just briefly, the obligation to disclose conflicts of interest include actual and potential. And it's undisputed, it's found as fact that Caprock had some overlapping ownership with PPS, that being Daniel Bishop and Eugene Seitz. That overlapping in ownership, we contend, creates a potential conflict of interest where one owner and broker may feel incentivized to recommend that their clients use a property maintenance company that is basically a part of the umbrella of Caprock. We think that's a conflict of interest. We think it needs to be disclosed. It was highlighted in investigator Jay McLean's testimony at trial, and the ALJ also thought it needed to be disclosed. Thank you.
Thank you. Okay. Are there any other questions from any of the commissioners? Okay, well, thank you, parties and counsel. This concludes our oral arguments. David, are you able to please cut the audio and visuals for parties and counsel? That would be great.
Madam Chair, we're trying to bring Commissioner Line back so that if you want to go into executive session, you will have enough for a vote for executive session.
Gotcha. And sorry, let me just see where that would be.
Commissioner Sanders, just on a procedural note, if I may. I
Yes.
think the question is just exactly as you had posed to your fellow commissioners earlier, which is if executive session would be helpful or requested at this time or a later time,
Okay.
or at all.
Yes, thank you so much for that procedure. So to all of the commissioners, would you like to enter into executive session for any legal advice in regard to this case? Or would you like to continue to the open meeting discussion?
I think we can go to open meeting discussion still and keep moving forward. I don't have anything.
Okay. All right, well, it doesn't look like there is a request to go into executive session. So I guess procedurally, are we okay to just go ahead and start deliberating?
Yeah.
Okay. All right. Well,
And Eric, I apologize. I'm going to interrupt really quickly. I am having some technical difficulties on my end. All the screens are frozen, and sometimes everybody's words are like 3 minutes behind. So I'm going to log off really quickly and log back in.
Okay.
Okay.
And so we'll wait till she can get logged back in, and then we'll go ahead and continue the discussion.
Perfect.
And did we get Commissioner lined off at this point? Because I know we were going to call her in, but I guess we don't need to for that vote.
She hasn't rejoined.
Okay, thank you.
I'm back. Can you hear me?
Yes.
Yes.
Okay. Hopefully that helped. I apologize. Thank you.
Well, you sound fine to us, so we couldn't tell the difference. Okay, well, the commission may now deliberate, and I invite the commission to discuss the matter. Would any commissioners like to open the discussion?
So I still think there's an issue with being supervised by somebody that's can't really make any decisions for you.
And actually, you know, what I'm thinking, I'm sorry to interrupt, Bernadette. I just had this thought that because there are 5 different counts, it might be helpful that we have our discussion kind of around each count. That might be a better way
okay.
forward because there's a lot of layers here. So why don't we, if you're okay with that, why don't we just go ahead and start the discussion, but let's start with the count one, and then we'll just kind of continue that way. So everyone will have an opportunity to speak in regard to count one, count two, three, four, et cetera. So in regard to count one, is there anyone that wants to open a discussion on that? And this is regarding violation of the 2018 final agency order.
The thing that I thought was interesting on this, and I went back and refreshed my memory this morning before our meeting because it was a lot to take in. It looked like the supervising broker at that point overseeing supervision of Justman was actually lacking access to pertinent information that would actually allow her to do her job. So I thought that that was very interesting and warranted discussion.
Yeah.
Yeah, she had no idea that it was even what she was coming into on that.
Well, my notes on that is that the the ALJ found, based on what was determined to be credible evidence in the record, that the respondent violated that order, the FAO order. And so evidence that I kind of made note of is that Ms. Curtis delegated supervision of the property management on 2 occasions to the respondent. Ms. Curtis didn't have access to the database and had to refer, and Ms. Curtis, by the way, is the employee. She didn't have access, or the manager, she's supposed to be the supervisor. She didn't have access to the database and had to refer to the respondent to answer most of the operational questions, which really put the respondent back into almost a supervisory role. And then Ms. Curtis, who again is the acting managing broker, herself signed a stipulation and FAO admitting she didn't adequately supervise. So my thought and opinion on it is I felt that the ALJ's findings were sufficient. There's no new evidence to refute that, really. So I really didn't find a reason to change that anything in that count. Did anyone else
I
have
agree.
thoughts or any differing opinions on that?
I agree with you on that. When I read over it, I had the same feelings on that. She didn't have access to everything, and she'd have to keep going back to her. So I agreed completely with you on that one.
Agreed.
Okay, so we all agree in regard to count one, violation of the 2018 final agency order, which was 12-10-217-1M. We agree that the count has been established.
Yes.
Yes.
Okay. All right, so let's start our discussion on count two, which is converting and diverting funds. Does anyone want to start discussion on that count?
I think the question that I have, sorry, I'm rereading everything just to make sure that everything is really top of mind and fresh, but I know that mistakes happen. I'm just curious, like in a situation where a mistake maybe is encountered or identified, is there a precedent that we have judged on in previous files? Because I want to make sure that there's continuity and consistency across the board. And once these mistakes maybe were identified, was there any movement on Justman's part to at least make it known that she was aware she made a mistake and reached out to at least just be proactive?
I mean, the notes that I have on that is that so I asked a question. Okay, the ALJ found that the evidence and the explanation that the software issue, they found that to be credible based on all the evidence that the ALJ looked at. So the reason I asked the question, was there any evidence to disprove the fact that it wasn't credible, was just really to determine if that should be something that would be added. And since there wasn't anything new to suggest that, that it was known or it was purpose or whatnot, I just kind of sided with what the ALJ decided. I just put in reviewing statute, these are just my notes. So in reviewing statute 1210-2171I, there's no clear definition of intent versus inadvertent or accidental, which makes me interpret that as something that would be determined on a case-by-case basis. So in this case, since there's not a very clear definition in this case, the ALJ found that there wasn't enough evidence to prove a violation for count 2. Therefore, if it was truly a software issue, if the ALJ accepted that as credible, then, and it happened based on my notes from all the evidence that I read, it happened one time and was corrected. So it seems to me that the ALJ's decision to dismiss count 2 is appropriate because it doesn't seem right to uphold a violation in the case of an isolated random software issue, especially in the sense that there doesn't seem to be a very clear definition on intent versus accidental. So that's just kind of my notes on that. So in my thoughts, I really, I felt that the ALJ's decision to not, I guess, enter violation on count 2 was sufficient. Any thoughts on that? What are your thoughts on it? Do either of you think that they should be a violation?
I looked at it.
No, you go ahead, Bernadette. Apologies.
I looked at it, and I didn't see where it said kind of the same as you. It didn't, I think everyone agreed that there really wasn't anything on that too. Almost everybody agreed that there really wasn't anything on that on the second violation. It didn't prove it. So I'm sticking with a no on that one. I just have on my note, I said no on 2.
Okay. Autumn?
Sorry, I'm rereading. I'm going back and forth between the October and December file just to make sure that I don't have any other follow-up questions.
Okay. I know you did have a follow-up question, and that is a question that Sue, is that a question you may be able to answer in executive session? She had a question in regard to how that has been just maintaining consistency and how this has been addressed in the past. Is that something that can be discussed in executive session? Is it appropriate, inappropriate?
Well, I'm not sure that it is necessarily legal advice. I could turn to Melissa here if she has any historical information that can be responsive to that question. Melissa, if you've got anything.
I hate to defer further, but I guess I don't have anything to add. I don't know if Director Waters or Penny Elder has anything that might be relevant.
I think at this point, I would suggest, Madam Chair, going off of just the briefing and the already very full record. The parties have already argued each of their respective sides and cited their reasons, including record evidence. And I would suggest going off of the issues as identified by them and the language of the statute itself, which is listed for you in those documents as well. The question of intention was addressed by the ALJ, which was part of the parties' arguments here. And you will find my opinion on it in the memo under count 2. If you'd like some further explanation of that, that would be a topic for executive session, but specific to Commissioner Rubal's question. I think you have what you have, and that's pretty much it. So the question of the statutory language, though, is back to the, if it's helpful to read through, I can.
No, that's helpful. I appreciate the clarification. I just want to make sure that we're talking about all the angles here. And just going back to the October file, I see your recommendation in black and white and would move to agree with my fellow commissioners.
Commissioner Sanders, if you had a question, and certainly not a legal interpretation of the statute, but if you had a question about the consistency of application.
It was actually Commissioner Rubal's question. I just wanted to make sure we didn't overlook her question.
I'm sorry.
So I just wanted to make that clarification, but you can continue.
Yeah, and I can tell you that it has consistently been applied, whether it's an error or an intentional. And often when the commission sees intentional acts, they add the additional violation of dishonest dealing. But they do consistently apply mistakes or errors in a system as the violation.
Okay, that's helpful. Thank you.
Thank you.
Madam Chair, if I could just interject for a second here too. As you ordinarily do, the question of whether there is enough information, factual evidence that was established at trial, you have the findings in your initial decision. The question is whether that nonetheless establishes that the licensee converted funds of others, diverted funds of others without proper authorization. And that's the statutory language. As usual, if you do decide that a violation has been established, you can consider other things as mitigating or aggravating circumstances, including stuff like refund, cure, the proactive steps, if any, amount, etc.
Okay. Does any of that information change the discussion at all? And if we could all kind of discuss if we feel the count has been established or if we're going to continue with the no. I think for me, based on just kind of what I said, based on the information we had at the time, based on the evidence that we had, based on the questions, I'm going to kind of stick with the no. That would be my vote, I guess, in this.
I'll second that.
And then where's Bernadette? I don't see her anymore. I know she's there. I just can't see her on my screen. Bernadette, are you a yes or a no? You there, Bernadette?
My computer internet just dumped, I guess. And so I just realized I wasn't on for a second, and now I'm back.
Okay. Are you a yes or a no on count 2? Has it been established, meaning that there should be a violation, or has it not been established and we're going to leave it at no?
Leave it at no.
Okay. So count 3 is violation of duties to landlord, which is a violation of 12-10-217 1M and 12-10-4041. Does someone want to begin the discussion on this count? And I know this is the count that discussed the tenant listing fee and conflicts of interest. And I guess what I
Again,
have on this one is she acting as a landlord agent on this? That was like one of the things to determine. But does anyone want to start, or would you like me to start it?
Sorry, I'm bouncing back and forth between December and October files just to make sure that I'm not missing anything.
Okay.
Okay, I think I'm caught up, ready to discuss.
Okay. So what are your thoughts? Do you think that this account has been established?
I mean, based off of what I'm reading, the commission has proven count 3.
Or
But we
the
can unpack that.
okay. Yeah, I mean, my notes just say she was acting as a landlord's agent. The tenant fee was undisclosed. There was no services for that fee. The fee is above and beyond the agreed listing fee. It did cause harm. There were evictions, bad reviews, harmed reputations, created hardships for tenants. And those fees, I have a note that those fees range anywhere from $700 to $1,200. Um, I have notes that her interest was placed above public and client as she allegedly stated 3% wasn't enough money. And then I put on here that I felt the ALJ's decision is appropriate based on the evidence presented. So overall, I think that the count was established.
Yeah, I would agree.
Any thoughts on this one, Bernadette?
We established that she was an ownership in that, in Caprock. So
Well, this is that's the next one. This is count 3.
wait a minute. No, this is, I have count 3 up.
Okay, the duties of the landlord.
I have that up. So I think it was also proven on that. I think that I agree with you on the, it did cause harm. So I did agree with that one.
Okay, so we all agree that the count has been established?
On my notes, I put really vague notes on this when I wrote this. And I just put keep it the same as what I put
Okay.
on my little note here.
Okay. The next one was count 5, which is failure to disclose conflict, 12-10-217-1M, Rule 617. Sorry. This is where I asked a question if the respondent had any financial benefit from the PPS, which is that was the, I guess, like company that they would use for maintenance and things like that, I believe. And so really the questions I asked was there ownership in PPS? No. Did Caprock or the respondent benefit financially from PPS? No. Is the respondent related to either of these parties? No. This was a tough one because it was funny, like I looked, I reviewed this file twice, and the first time it was like I had one idea. I had 2 different results, I guess. From when I first looked at it until now. And so I'm kind of like, I hope we can just have a discussion and come to a collective opinion, because on one hand, I think that because there was no financial benefit, I don't know that it could be considered a real conflict of interest. If there was any financial benefit, it would be. Um, so if my notes are just like, if no on all those questions, it may not violate Rule 617C because there's no duty to disclose an alleged, no, there wouldn't be a duty to disclose. And then I also had a note that there was an alleged affiliate business arrangement disclosure. I couldn't find it in the file. I don't know if any of you guys saw anything about that.
The files were, especially going back between October and December, I mean, you could dig for days on that and still not find everything you needed. I
Yeah,
agree with your line of thought at this point. The thing that kind of does it for me is the words potential conflict of interest.
yeah,
And if there is that potential, why wouldn't you err on the side of caution and just disclose it?
yeah. And that's kind of the other thing, because like my initial reaction was this was a clear conflict, but then again, when I looked over this file for this hearing, it's like I kind of saw it a little differently.
Mhm.
And I think that that's going to be the key. I think maybe going back to um 12, 10, 217, 1M. I'll pull those up real quick because I think it's going to really be the language, right?
Yeah,
Is it potential conflict or is it a known conflict?
yeah.
That's the question. If it's a
But I
potential
think
conflict, then it's a violation. If it's a known conflict, I mean, I don't know. It's not a conflict in terms of finance. So,
I think that's a
but
good place to start. Let's pull that up and see what the
yeah.
interpretation is, and then we can discuss it at that point. Bernadette, do you have any initial thoughts while Erica pulls that up?
So, okay, so they said that she disclosed it via telephone, just in conversation. It wasn't
Yeah,
in writing.
not in writing.
Right.
Um,
So we won't count that.
and so,
And I just, I think what would have sold me a little further is if there was an affiliated business arrangement that had been signed, because then I would feel like, okay, but there was a disclosure, but I just couldn't find it in the file. Therefore, I don't know if it ever I'm assuming it wasn't provided.
no, I don't, as far as, oh, go ahead, Sue.
Please, Commissioner, go ahead.
If you have an answer to that question, it would be helpful. The
It was
affiliate
not
business.
cited in the record. It's exactly as Commissioner Bugarin has stated, that there was evidence of a verbal communication and not in writing.
Okay.
And for clarification, procedurally, this charge comes under a rule violation under 217 sub 1 sub M. And the rule you're looking for, 6.17, is duty to disclose conflict of interest.
Mhm.
And if you have it in front of you,
Yeah,
but
I'm trying to get there right now.
there's some front matter and then two subsections. Subsection A is brokerage firms and brokers have a continuing duty to disclose in writing any known conflict of interest that may arise in the course of any real estate transaction. And then sub C is a brokerage firm or broker engaged in property management services has a duty to disclose in writing any known conflict of interest that may arise in the selection or use of a business or vendor that provides services applicable to lease transactions, including property maintenance. The brokerage firm or broker is required to disclose any ownership, financial, or familial interest associated with the selection or use of a particular business or vendor. So I think the commissioner's questions were twofold. One about the in writing, and that is part of your rule. One is and the other one was required, known or required, and your rule has both. A
Yeah.
known conflict of interest that may arise in the selection or use of a business or vendor.
So the
Okay.
rule violation is that they didn't put it in writing. She said it verbally, but didn't put it in writing. So it's still a rule violation. With that, I think it's proven on that one.
Yeah. I'm okay with that.
Agreed.
That I just had a little note that said she disclosed in verbally, not in writing. Stick with it is what I put on mine.
Yep. I agree. Like I said, I was literally going kind of down the middle on that one. And then our last count, which is count 6, is unworthiness to act as a broker, 1210-217 1Q. Any discussion about that count?
I think when looking at all of these together, it kind of puts it gives you the answer.
Yeah.
I think it kind of, it's like the sum of all these is what gives us that. I think unworthiness is a terrible word. I don't like that word, but when you look at this and you say all these different things, like it all adds up to negatives.
Yeah. Any thoughts, Autumn?
I think Bernadette brings up some excellent points, and I agree.
And my notes say that there was sufficient evidence to support the violation, that you had that listing fee that was undisclosed, which, there should be an understanding that those types of fees should be disclosed. What was interesting in my notes too, from reading over this, was that the ALJ didn't rule incompetent. However, while I agree the respondent is knowledgeable, she did display some incompetent behavior when it came to some of this stuff. And then the respondent's idea that the tenant fee shouldn't be disclosed is an example of that incompetency. And so, I think the reality is when you have a scenario where you violated an order, right? And then you have all these other counts of violating duties as a landlord that has been proven. You have the count of, violating or failing to disclose conflict of interest. So it's 3 counts, and then you have, even though we didn't rule against 2, you have 3 counts basically that suggest if those 3 counts are valid, then there has to be a level of incompetency, right? So therefore, I would say that has been established. So is there anyone that disagree? Either of you disagree that it's established, or are we all in agreement that
I think
that
we're all in
particular?
agreement.
Okay. All right. So now the question is the discipline, and these are just kind of my notes on that. The ALJ imposed a fine of $2,500 per violation. They recommended public censor. The ALJ points out options other than revocation could be considered based on her knowledge. My notes also state that probation didn't work. She violated a 2-year probation already. She already took an ethics as a result of previous discipline. And so far, based on what we have in front of us, the less severe discipline hasn't worked. And the last violation, she continued to supervise. Coupled with, and that's been established, right, that she continued to supervise. So coupled with the previous discipline really supports revocation, but I do have notes that, we could consider a suspension, but it would need to maybe be a little lengthy. I think that she brought up some good things that, we should at least discuss. For one, she seems to be remorseful. She mentioned, having a big book of clientele that will be affected as well. So I don't know if that softens. I think revocation honestly was supported, but when you look at the other aspect of how it kind of affects the whole ecosystem of clients and everything. Does it make sense? I think we just need to discuss it.
Mhm.
Yeah.
I put a note to myself to look and consider less than revocation. I put a note to that. Listening to her today, I did feel like she was remorseful. I guess I didn't know what other, like, I guess maybe suspension. I don't know if it didn't play a part, like when you mentioned, how it affects others, like her book of business, like that. That doesn't weigh on my decision with this. I don't know, maybe it's the human side of it that I just feel like even if you give her this isn't giving just a second chance. This is, more 2.5, 3, you know what I mean?
Yeah. And I think we have to
Chances for it.
consider previous cases too.
Yeah.
Like,
I see that when she first started, but I guess part of it that, like, I don't like the way the supervisory role was put the last time. Like that does bother me, that they thought that almost like I'm going to pull one over their eyes, you know what I mean? Over the commission's eyes and say, hey, I'm just going to put somebody in this. Like they put somebody in that spot specifically to be a managing broker to oversee them, but didn't let them have all those access to everything, like a little deceptive at the same time. I feel like there was some deception in more than, a couple places. Why I put consider less than revocation. Like I see why it was suggested. Like I totally see that. So I don't know. Let's discuss it and see what something sways it, because I can see both sides of this.
My thoughts are she's been at this since 2018. When she was 23 years old, she was licensed. That was 7 years ago, going on almost 8 years. So she's now in her 30s. Looking at the litany of violations that have happened, I don't have a distinguished timeline over the last 7 years. And also the words that have come up several times today were public endangerment. So I think that these are things that we have to take in total totality before we make this determination, because what I don't want to happen is, let's say that we advert revocation and 2 meetings from now, she's on here with another violation. And I know we can't future think like that, but it is something that we need to consider and discuss.
Yeah.
For as long as she's had her license, it's been a series of those since getting her license.
Yeah.
So
I mean, my thing is I always am cautioned when there is a violation that's violated. And so kind of what I mentioned, like the stipulation was violated. And I agree with you, Bernadette. That's how I took that as well when I read it. I took it as it was being deceptive. It was like, hey, I'm not able to act in this role on paper, right? So on paper, you're going to do this, but I'm really going to be kind of behind the scenes. That's how it felt to me when I read that, which is definitely deceptive. The other thing is, if you really look at everything that she's being accused of, it really could um, make revocation make sense, right? Um, so, and then I thought it was interesting that like she took ethics already too, and some of the stuff still came up. So, um, so obviously, like the education piece wouldn't be helpful. We know that probation wouldn't be helpful. The only other option would be suspension. And I do know that well, I guess I don't know, but I know that we, as this body of commission, have had discussions about suspensions because I don't think like a 3-month suspension would be suitable. So you'd be looking at a longer term suspension. And I know with these discussions in the past, it just kind of made more sense to do a revocation because it didn't make sense to do like a suspension for like 6 months, a year. Does that make sense? So,
Well, she's been under a suspended license for the past, well, since October, or was it before that? I apologize. I don't remember the specific dates.
I don't know that I have the.
To my knowledge, she has not had an active license.
One moment here. In terms of licensing status, what you have most clearly in your initial decision is just a licensure as of 2010. And the final agency order, not by stipulation, but by final agency order, the probationary period that started in 2018. And your Exhibit 47 shows the end of the probation in October 2020. 2020, I'm sorry, February 2021.
So she got her license in 2010.
So,
Oh, so that's interesting. I had her getting licensed at 2018.
You know what?
Is the date of the final
That's when-
agency order? Oh, sorry.
That's when the
Got it.
final
Okay.
agency, yeah.
So
that
she's
was
had
the
her license
probational
much
period.
longer than 7 years. Okay, that
Yeah.
is very good to know.
So she had it for 8 years, then went into the final agency order in 2018.
Okay.
and Sue, since you have your notes up, when was the violation of count 1 like established, or when was that? I don't know how to say it, but when was that referred, I guess, as a violation of the order?
Ah, one minute. I believe the evidence in your record shows it was from an audit, but one moment on that. Here.
I do
Yes.
recall an audit. I just don't remember what year that was. And
I did remember reading that this all stemmed from, because I was like, how did this all come to play? But it came from an audit. Let me see if I have it up here. And was that audit part of that final agency order from when you know how we'll say to do an audit after they've, when they're already
oh yeah, was that part of the discipline?
as part of the discipline? Was that what it was for? So it's not like, was it like, surprise, surprise, there's an audit, or is it, she knew this was eventually coming?
Let me refer you back to the initial decision at page 4,
Yeah, I'm
paragraph
looking there now.
24.
Mhm.
And this was not a contested fact, but it says that the investigator in 2020 initiated an audit. And I think that's the paragraph you're looking for.
July 9th, 2020.
Okay, so it happened. Okay, I see. Okay.
Okay.
And so putting the dates together, that was
But she
while
was
probation was still pending.
So it sounds like because I'm just reviewing this again, but it looks like her license was restricted between 2019 and 2021. But the audit happened, or this, now we can say maybe fact that she was still performing some supervising role happened in 2020. So kind of in the middle of, I'm trying to find that.
That's right. They said in this that she kind of thought that she was like pulling the wool over their eyes because it took, a few years for them to realize that who she was being supervised by. And I want to say that person that was supervisor had also just decided to, I think, to leave. I think think there's a fair amount of deception here.
I mean, I'm comfortable.
I made my decision.
What is that? Revocation or something different?
Revocation.
Okay.
I'm sad because I don't like to take that, but I think there was a lot in this one.
Autumn, do you agree with that?
I know, I'm kind of like, I can weeble wobble back and forth. It's just, I know that our obligation is to public safety, and in light of everything that we've just discussed, I am leaning towards revocation. However, hearing opening testimony, and I did feel that there was
Remorse.
maybe a lot of lessons learned here.
Yeah.
I don't like to take people's livelihoods, but, you know, counter argument to that is this individual has had opportunity after opportunity after opportunity, and yet we continue to have a lot of different violations. So, I mean, it's not with pleasure at all, but I am leaning towards revocation.
Yeah, and I really share your sentiment as well, because I felt that there was a sense of remorse. I think it was at least good to hear from her directly. But to Bernadette's point and your point, public safety has to be priority. And I definitely don't like taking people's livelihood. But in this scenario, I think if we saw this same case 3 times, we would probably say revocation all 3 times. So looking at it like that, then I'm also gonna just kind of go with the revocation and just leaving that there. Which means now that we've had this discussion, we really haven't made any changes to the ALJ's decision. But I am glad that we really talked through it, because we didn't make any changes. Count one, we established there was a 2,500. Well, the ALJ recommended a $2,500 fine for that. Count two was not established. We went with the ALJ's determination on that. Count three was established. That would be another $2,500 on that. Count five, which is the one I was kind of teetering, but ultimately agree with the rest of you commissioners that was established. So $2,500 on that one. And then we all were definitely in agreement that count six. So I don't know if I said those counts right. Count three was a 2,500, count five was 2,500, and then count six, 2,500. And then it sounds like we just felt like the revocation was the option. But what I would hope that she does is, after this year, and really reflect on all the things that have happened, and really come back to the commission after the year with a really strong letter appealing to kind of allow her to get relicensed, and then come back and try to, do this with a just fresh slate. So that's what I hope that she will do. Because I think that maybe there is some remorse. I think there was a lot of lessons learned here. So that being said, we are agreeing to revoke. Okay, give me just 1 second to find our motion, okay?
Yeah.
I agree. I think if she comes back, I mean, maybe not doing property management. I don't know. The
Or just
property management.
do it better.
Yeah. It just.
Okay.
Commissioner Sanders, if I can
Yes, I'm
suggest.
sorry. I'm flipping through this trying to find the motion.
Yeah, I think there are 2 ways you can tackle this. But also I want to make sure that if there is further discussion on the evidentiary support for the findings of fact that were challenged that you all have an opportunity to do that. And of course, if executive session is needed for that, I would be happy to engage in that if you have a motion for that. Otherwise, if there was any further clarification needed because of the exceptions filed by both parties, it would be to address the division's corrections to the initial decision, and as well as the findings of fact that were challenged by the licensee here.
Okay.
The commission has already discussed each of the counts, challenged count by count, so I think that is clear, and also the proposed penalty. If there was more discussion on either aggravating or mitigating circumstances to adjust the fine, I think the revocation piece has been fully discussed, but just wanted to point to those various aspects. If you would like, I can try to summarize what I think I've heard, or it may work better to just go piece by piece with maybe addressing the division's exceptions first with the modifications to the initial decision, which were more in the line of corrections that the licensee did not oppose, and then the findings of fact that were challenged by the respondent, and then a single motion to basically reaffirm the violations count by count. I'm not sure if I'm clarifying anything here, Madam Chair, so.
Well, no, well, what I'm wondering is, we definitely need to motion regarding the corrections, because those were agreed on both sides. And then on the findings of fact, since we really, throughout our discussion, ultimately didn't make any amendments to the ALJs, aren't we able just to do kind of one motion to accept the basically accept or adopt the ALJ's findings?
Erica, you can. The sample motions are on page 14 of that might be helpful.
Oh, that's part that I'm missing. I only
Yeah.
printed out the page 7.
Yeah, because it gives
That
you
would be the
under findings
problem.
of fact, it's A or B, or it
Okay.
gives you other than corrections made. I move to adopt the initial decisions findings of fact in their entirety.
That's so funny.
I
I
was
thought that's
really
7.
black, 'cause I know I saw that.
Okay, but I have actually a version of that here on page. I have a version of that. So but I
Okay.
just want to make sure I didn't need to like go through every single count, and we could just kind of keep it simple. Okay. Sorry guys, let me get that back in front of me. All right. Okay, so first, actually I can make that motion. Is that right, Sue?
Yes.
I'm just all confused. Okay. I move the commission to modify language in the initial decision as stated in the petitioner's exception. Do I have a second?
I'll second.
Okay. Any opposed? All in favor?
Aye.
I
Aye. All right.
One
Second.
housekeeping matter,
Yes.
Madam Chair, if you don't mind. Uh, one of the corrections, as you saw, was to the name Wilden. And just to make sure that it's the commission's desire to correct that wherever it appears, even if it's beyond the ones that were named in the petitioner's exceptions, if that's okay.
Yes. I believe the intent would be to make all the corrections.
Thank you.
Okay, in regard to the findings of fact, other than the corrections made, I move to adopt the initial decision findings of fact in their entirety.
I'll second.
Any opposed? All in favor?
Aye.
Aye. And then I do have one more motion. I would like to invite a motion to direct the adjudicatory council, I got the word right, the adjudicatory council to draft the final agency order reflecting the commission's determination. and move to delegate authority to, I guess it would be Melissa Phipps to sign the order on behalf of the commission. And I also direct staff to bring the draft for the commission review at a future meeting. It's a long motion, but
Well,
let
I
me know
think
if you need
backing
me
up
to
a
reread
second,
it.
I think it's one or the other. You can either delegate authority to staff to sign the
Oh,
order, or
sorry.
you can review it as a commission and sign it jointly. And I would also suggest, if that's okay, to incorporate the previous discussion to adopt the ALJ's conclusions of law as to each of the counts and the recommended discipline as well, including revocation, fines, public censure as discussed.
Okay. As commissioners, do either of you have a preference or a thought on whether we want to delegate the authority to sign on behalf of the commission, or do we want to review a draft at a future meeting?
I think in the past we've delegated to staff, but
Yes.
okay.
Well, I think a lot of times we delegate the authority to Melissa to just
Yes.
sign the order on our behalf. Are
Correct.
we in agreement with that?
Yes.
Okay, I'm gonna try this motion. Bear with me.
It's a lot. Got it.
And I'm gonna do my best. So motion to direct the adjudicatory council to draft a final agency order reflecting the commission's determination, which is to uphold the ALJ's, which is to adopt the initial decision findings of fact in its entirety for counts 1. No, I'm slow. Hold on. Counts 1, 3, 5, and 6. And delegate authority to Melissa Phipps to sign the order on behalf of the commission.
I'll second.
All in favor, or any opposed? All in favor?
Aye.
Aye.
Aye. All right, a final order reflecting the commission's decision will be issued in due course. A copy will be mailed to the parties by commission staff. Thank you so much for just allowing me to get through that.
You did great.
Is there anything else that we need to do, Sue? Procedurally?
I think that takes care of it. I just wanted to clarify, it's an adoption. The commission has voted to adopt the findings of fact and the conclusions of law and recommended sanction as discussed. And you've also delegated authority to prepare the order and have that signed by Melissa Phipps. And
Yes.
if that's everything, that is in conclusion of the matter that I'm here for, and I will excuse myself with my thanks to the commissioners.
Thank you for all your help, Sue. We
Thank
really
you.
appreciate you.
Happy holidays.
Yes.
Likewise. Bye-bye.
And now I guess we can bring our chair back in and I can maintain my position as vice chair.
Thank you for handling that, Commissioner Sanders. You did a great job.
Oh, thank you.
Okay, the next item on the agenda is a matter of Sherdine Cornish, case number RC 2025-0023. The matter is before the commission today for review of the initial decision and issuance of a final agency order. Present to assist the commission in reaching a final agency order are Melissa Phipps, Senior Advisor, and Marsha Waters, Division Director. An initial decision upon default was issued in this matter on October 15th, 2025. Neither party has filed exceptions to the initial decision, and the matter is now before you on the commission's own motion to review the initial decision. The commission needs to deliberate on whether to adopt, modify, or otherwise act on the initial decision and proceed to a final agency order and final discipline, if any. Ms. Phipps, can you please provide a brief overview of the issues to be considered by the commission?
Yes, thank you, Commissioner Line. The issues were fully described in the memo that was provided to all of you in the pre-meeting materials. But just to summarize briefly, the initial decision that was issued in this case, that recommended the discipline that was requested by the commission in the notice of charges. And that was that the respondent complete the following coursework: 8 hours of electives, 6 hours of contracts, and 6 hours of legal issues, and the imposition of a civil penalty of $500 plus the statutory surcharge. However, due to an error that was contained in the motion for entry of default, the ALJ also recommended that the discipline be stayed subject to respondent's reactivation of a real estate broker's license, and that it shall be paid and completed prior to a request for reactivation. As discussed in the memo, because of that language regarding reactivation was included in error and the reasoning behind it isn't supported by the factual record at all in the case, it's division staff's recommendation that the commission issue a final agency order imposing the discipline as recommended in the initial decision, but excluding the language regarding the stay of the discipline pending license revocation. The commission can accomplish this by adopting the proposed FAO that was included in your meeting materials. Happy to answer any questions you guys may have.
All right, thank you. Any questions for Ms. Phipps or anyone like to initiate discussion?
This is Erica Doyle. I'm sorry, my video is not working again. I'm going to try one more thing very quickly. Nope, still not working. So I'm just going to turn that off for the moment. My apologies. In my review, it did appear that there was an error with the ALJ in that the discipline be stayed and subject to the respondent's reactivation of a real estate broker's license. Her license is currently active, so there's really no possibility that this could be carried out as recommended. I recommend we correct the action. I can make a motion, but we can certainly, I would like to hear the other commissioner's position on this.
I agree with you.
I agree.
I agree.
Okay, do you want to go ahead and make a motion?
I motion to modify the initial decision in the following manner: to adopt the disciplinary recommendation. The respondent shall complete the following coursework: 8 hours of commission-approved elective continuing education credits, a 6-hour or more commission-approved course and contracts, and a 6 or more hour commission-approved course with current legal issues, fine of $500 with statutory surcharge imposed. But rather than having the disciplinary term stayed, require both terms to be completed within 2 months of the date of the final agency order issued in this matter.
Do we have a second?
Second.
Any further discussion? All right. All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes. And then someone else like to make the other motion about directing division staff? Otherwise, I can do that. So I'd like to invite another motion to direct division staff to draft a final agency order in accordance with the terms decided upon here on today, with the authority to make any non-substantive errors and to delegate authority to Director Waters to sign the order on behalf of the commission. Do we have a second?
Second.
Yep.
Okay, any further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes. A final agency order reflecting the commission's decision will be issued in due course, and a copy will be mailed to the parties by commission staff. That concludes today's hearing matters. We can now move on to policy matters, and I'll turn it over to Director Waters to proceed with those.
And actually, commissioners, this is the portion of your meeting for the rulemaking hearing, and Melissa will read the rulemaking script while I provide summaries.
Just want to check and make sure David's still here and ready when we get to the, okay, great. All right, good morning. I'm Melissa Phipps, Senior Advisor for the Division of Real Estate. Could you please take roll call, Director Waters?
Bernadette Bugarin,
Here.
Renee Lind,
Here?
Erica Sanders,
Here.
Erica Doyle,
Here.
Autumn Rubal.
Here.
You have a quorum.
Thank you. Today is Tuesday, December 2nd, 2025. It is now 10:41 a.m. This is a permanent rulemaking hearing pursuant to the Administrative Procedure Act found at Section 24-4103 of the Colorado Revised Statutes to hear oral testimony related to proposed amendments concerning the rules regarding real estate brokers referenced in the Code of Colorado Regulations as 4 CCR 725-1. Parts 1 through 4 of Title 12, Article 10 of the Colorado Revised Statutes authorizes the Real Estate Commission to promulgate and amend these administrative rules. This permanent rulemaking hearing is being conducted pursuant to the process as set forth in the Administrative Procedure Act. During this hearing, the Commission will hear testimony in regard to proposed new rules 1.11, definition of a client, and 6.27, informed consent requirements. The renumbering of existing rules 1.11 through 1.62, amending Rule 2.11 with respect to service member and service member spouse credentialing, amending Rules 4.2, 4.3, 4.4, 4.5, 4.6, and 4.7 regarding continuing education requirements, and amending Rule 6.17 regarding a broker's duty to disclose conflicts of interest and license status. Here with me today are the members of the Real Estate Commission, Director Marcia Waters, Deputy Director Sarah Halloran, Education, Communication, and Policy Manager David Donnelly, and Irina Groni and Gina Simonson from the Attorney General's Office. The public record will consist of all testimony and any written information submitted within the allowable timeframe. Therefore, in addition to considering all the public comments today, the Commission has had an opportunity to review all written materials to make the final decision on the proposed amendments. The public record will close at the end of this hearing. Let's now have Director Waters explain the proposed new Rule 1.11.
So the proposed new Rule 1.11 creates a definition of a client, which is defined as a person, persons, or entity that has engaged a real estate broker for the performance of real estate brokerage services.
Thank you. Now, Director Waters, can you please explain the proposed amendments to existing rules 1.11 through 1.62?
So if the Commission adopts the definition of a client in the new Rule 1.11, then the existing rules 1.11 through 1.62 will need to be renumbered. Those rules were filed for that purpose, and there have been no substantive changes to those definitions.
And please explain the proposed amendments to Rule 2.11.
In 2025, federal law modified the requirements for a service member or a service member spouse to become credentialed in a jurisdiction where the service member is transferring due to military orders. The proposed changes to Rule 2.11 reflect those changes and ensure conformity with federal law.
Thank you. Can you please explain the proposed changes to Rules 4.2, 4.3, 4.4, 4.5, 4.6, and 4.7?
The proposed modification to Rule 4.2 would require licensees to complete the annual commission update course by July 1st of each year. This was an administrative recommendation that was made as a result of the Commission's sunset review. The proposed modifications to Rule 4.3 are to clarify the expectations of how the annual commission update course is to be taught. The proposed modifications to 4.4a is to clarify what qualifies as the instructional material that must make up the 50 minutes of instruction per 1 hour of credit. The proposed changes do not intend to prohibit student questions or discussion, which would appropriately fill the remaining 10 minutes of the 1 hour of continuing education. The proposed addition to 4.4b is to clarify how the eligible topics for continuing education must correlate with Colorado law and regulations, and which topics are not eligible for CE credit. The proposed addition to 4.4D is to clarify the expectations for education for the employing broker level of licensure. One of the proposed changes to 4.5 clarifies that a broker cannot take the same course more than once during the license cycle for CE credit. This does not prohibit a broker from taking a class in the same subject matter with a different course certificate approval number. The other proposed change to this rule clarifies that instructors can only receive CE credits for teaching one course per year. The proposed change to Rule 4.6 is to clarify that CE credit can only be provided for completion of a course within the period of time that the course is approved by the Commission for CE credit. And the proposed changes to Rule 4.7 is to clarify what information must appear on the course affidavit, certificate, or transcript.
Thank you. Director Waters, can you now please explain the proposed changes to Rule 6.17 and the proposed new Rule 6.27?
The proposed revisions to Rule 6.17 address the potential conflicts of interest that an employing broker may encounter when the brokerage firm is representing both sides of a real estate transaction. The proposed new Section D establishes the disclosure requirements that must be made to clients of the designated brokers if one or more of the clients agrees to having their confidential information shared with the employing broker. The proposed new Section E would prohibit the employing broker from receiving confidential information about the designated broker's client if the employing broker represents the other side of the same transaction. The proposed Rule 6.27 addresses a critical legal requirement that a broker must obtain informed consent from their client before disclosing a client's confidential information, even to their employing broker. This has been a legal requirement ever since the designated brokerage framework was enacted by the Colorado legislature. This requirement was previously reflected in paragraph 5.3 of the listing contract that allowed a client to simply check a box to allow their broker to reveal confidential information to their employing brokers for the purposes of receiving supervision. Although easy and efficient, and actually I'll correct that, there was no checkbox, it just was a blanket waiver. But although it was easy and efficient, it doesn't comply with the licensing law's requirements. Sections 12-10-402 sub 2, 405 sub 2, and 407 sub 3 of the Colorado Revised Statutes all prohibit disclosure of confidential information without a client's informed consent. Although this legal requirement has been in place many years and will remain a legal requirement even if the proposed rule is not adopted, the Commission is proposing the rule to provide guidance and transparency precisely because it has been overlooked for so long. 12-10-403 sub 6 of the Colorado Revised Statutes, which establish the designated brokerage framework in Colorado real estate practice, a legal framework that assigns a specific broker within a firm to represent a client exclusively, thereby insulating the rest of the firm, including the employing broker, from that brokerage relationship and any fiduciary obligations that go along with it. 12-10-408 sub 2 of the Colorado Revised Statutes, which requires the designated broker to disclose that the brokerage relationship exists only with the designated broker, does not extend to the employing broker or to any other brokers employed or engaged by the employing broker who are not so designated, and does not extend to the brokerage company. Why this rule matters is under Colorado's designated brokerage model, the employing broker is not automatically a party to the fiduciary relationship between the designated broker and the client. The structure is designed to protect client confidentiality and avoid conflicts of interest within large firms. However, it also creates a controversial question. How can an employing broker fulfill their statutory duty to supervise without access to potentially confidential client information? That answer lies in informed consent. While the employing broker has supervisory obligations, the employing broker is designated to represent a brokerage, and the requirements to supervise do not override the client's right to confidentiality. Therefore, any disclosure of confidential information, even for supervision, must be done with the client's informed consent. This proposed rule seeks to, 1, clarify that informed consent is required before a designated broker may share confidential client information with their employing broker. 2, define what constitutes informed in this context, ensuring that clients are not simply signing boilerplate forms, but are truly aware of what information may be shared and why. And lastly, to balance the employing broker's duty to supervise with the client's right to confidentiality in accordance with both the letter and the spirit of Colorado law. We understand that this proposed rule generates many questions and concerns about its implementation, practical, operational, and legal questions. We want to ensure that any rule adopted is both legally sound and practically workable. If no rule is approved, the statutory requirements remain. I do want to point out that there is a typographical error in the proposed rule. The language should state lease rate, not leased rate, within the quotation of 12-10-405-2A.
Thank you for those explanations, Director Waters. At this time, we will start with the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing, if applicable. Finally, please limit your testimony to only the proposed new rules and rule amendments and do not duplicate testimony. Should the Commission or any of its representatives have a question regarding your testimony, we will ask when you have finished your testimony. If you desire to provide testimony, please raise your virtual hand so division staff know who to call on. Turn it over to Mr. Donnelly to monitor whatever volunteers we have to speak.
Thank you, Ms. Phipps. Rebecca, I have selected you to or asked you to unmute, and so and I see you're unmuted, so you have 3 minutes to address the commission. Thank you very much.
Hi, can you hear me?
Yes.
Okay, great. So my name is Rebecca Pildingsrud, and I am with the CE Shop, and we are an education provider of pre-licensing and continuing education. Thank you, commissioners, for the opportunity to speak today. I'm here to respectfully request one key change to I want to make sure I get it right, 4.4A4. And that is that the commission instead recognizes discussions, activities, quizzes, and exams and Q&A as creditable instructional time across classroom, synchronous online, and asynchronous education. And this is the standard everywhere else. And for more than 60 years, adult learning research and traditional higher education have defined instructional time to include discussions, problem solving, and assessment, not just lecture. No college, university, or accrediting body defines instruction as a lecture only, and yet the current draft rule would move Colorado in that direction. I would also misalign Colorado with ARELO standards, which is the national body that sets some distance education standards for real estate, and the division is also a participant in and a member of. ARELO requires interactive engagement for every learning objective and counts discussions, activities, and assessments toward course hours. And importantly, no other real estate regulatory agency in the nation uses a definition this strict. Programs in appraisal, mortgage loan origination, home inspection, and real estate education itself across all states credit interactive activities as instructional time, and Colorado would become the outlier. Adults don't learn effectively through passive lecture alone. They learn by doing, by discussing, applying scenarios, practicing decisions, and asking questions. Removing those elements from creditable time would lower instructional quality and undermine the very purpose of continuing education, which is to improve real-world professional practice and consumer protection. So I respectfully ask that the commission adopt a definition of active course instruction consistent with higher ed standards, adult learning research, and ARELO, which clearly includes discussions, activities, quizzes and exams, and Q&A as creditable instructional time when aligned to objectives and properly tracked. Colorado should remain aligned with national best practice, not become the only state in the country to exclude the core elements of adult learning from instructional time. Oh, I'm almost out of time, so thank you very much.
Thank you, Rebecca.
Does any member of the commission have any questions for the speaker? All right, I see none.
Very good. Again, thank you, Rebecca. Jordan, I've asked you to unmute and you can address the commission.
Good morning, commissioners. I'll be very brief here. I echo Rebecca's sentiment about the proposed rule 4.4 Just a quick anecdote for all of you. I do a lot of teaching, and one of the classes I teach is a negotiation class. Another is a trust accounting class. And the feedback that I get, including from division staff who have taken these classes, is that the activities offered during those classes, in the negotiation class, it's actually a negotiation where the parties negotiate with each other to try to resolve a problem. And in the trust accounting class, it's an activity where groups will actually perform a full monthly reconciliation of their trust accounts. Those are the activities that I get the most positive feedback about. So both division staff who have on occasion taken those classes and students that take those classes tell me that they get the most value, the most learning from those activities, because those activities cement the concepts that they receive in lecture form. And so I would urge the commissioners to include those types of activities as instructional time for CEs offered to brokers. I won't repeat the same notions that Rebecca just articulated, but I wholeheartedly support her comments. So thank you.
Any questions for the commission for Mr. May? Okay, I don't hear any.
Excellent. Anita, you're up next. I've asked you to unmute.
I have a voice condition, so I apologize for being hard to understand. I wanted to say from a licensee attending continuing education classes that I think that I gain and other participants gain tremendous value that goes beyond the lecture, beyond the printed content from the question and answer sessions, and that I think it also provides important feedback to the instructors regarding the quality and structure of the courses, so it's mutually beneficial. But I wholeheartedly suggest that you continue to recognize the benefit of the Q&A aspects as a critical learning piece. Thank you.
Thank you, Anita.
Any questions from the commission on that, for that speaker? No, ma'am. Thank you.
Excellent. Up next, we have Scott. I've asked you to unmute. Gotcha. Scott, if you're speaking, we can't hear you yet.
Oh yeah, no, sorry, I got muted. I got muted when I unmuted. Thank you, Mr. Donnelly. Scott Peterson on behalf of the Colorado Association of Realtors. We have comments related to three specific rules. First of all, proposed rule 45G. And we're asking for, I guess, clarity and potentially changes to the proposed rule. As it's currently drafted, this would seem to only allow an instructor of an approved CE course to receive credit for teaching one course per year. Currently, as an example, if an instructor was to teach a 4-hour ACU course and a 2-hour Redlines course during the same calendar year, they would be eligible to receive 6 hours of CE credit towards their own continuing education requirements. In the current draft of the proposed rule, it would appear that the exact same activities would only yield either 4 or 2 hours, depending on which class the instructor decided to utilize during a calendar year. If this is not the intent, the proposed rule should be modified to clarify that an instructor can receive CE for teaching different classes in the same calendar year. If it is the intent, I would ask the commissioners what possible logic this proposed rule has. This is unnecessarily punitive to instructors who should be incentivized to develop appropriate course content that is eligible for CE approval, and then to teach that content to real estate licensees. This proposed rule will accomplish the opposite of that goal. Proposed rule 617D, we would encourage the commissioners to not adopt proposed rule 6.17D. It completely and unnecessarily reverses many years of clear established policy to the contrary without any changes to the Colorado statute or commission rule necessitating the proposed change. It fails to recognize any distinction between an actual conflict of interest and a potential conflict of interest in describing the mere existence of having two independent designated brokers on different sides of the same transaction as an actual conflict. The Colorado Brokerage Relationship Act has never been interpreted in that manner, and in fact has been explicitly interpreted in exact opposition to this rule. This proposed rule will create confusion and cynicism among consumers as they are engaged in an established brokerage relationship with a Colorado licensee who, based on the buyer or property that the consumer might select, must now be told that both brokers have an actual conflict of interest in the transaction if they happen to share the same supervising broker. Finally, proposed Rule 6.27. Each of the commissioners is well familiar with CAR's opposition to proposed Rule 6.27. We share that sentiment with every single other stakeholder and industry participant we have spoken about regarding the informed consent rule. While your clear intentions of adopting 6.27 seem preordained today, and that you have already passed Commission Position Statement 31 and removed paragraph 5.3 from the exclusive right forms, the justifications for such a drastic shift in longstanding policy has never been clearly provided to the industry. I hope it has been justified to you through numerous and very lengthy private executive sessions with your attorneys and division staff. It was made very clear by the public stakeholders of the division stakeholder meeting that this makes no rational sense. Numerous stakeholders have been clear since before the February 2024 commission meeting that this makes no sense, and it doesn't make sense for supervising brokers who are obligated to supervise. It doesn't make any sense for associate brokers who require supervision. And most alarmingly, it doesn't make any sense for real estate commissioners who want their brokers to be appropriately supervised. I'll end there and happy to answer any questions. Thank you.
Do any of the commissioners have questions for Mr. Peterson?
No, ma'am.
Thank you. Seeing none.
Excellent. Thank you, Scott. Let's see. Up next, we have Diane. I've asked you to unmute. There you go.
Yeah, I would like to, I agree with the speakers that spoke on questions and answers during instruction, during training. And they brought up several issues, but one issue that was not brought up is confusion. Whenever someone is providing information, it can be confused. Students learn differently. Everybody learns differently. And one question can clear up an issue for many people in the class. So that's an issue, and I do hope you consider adding that question and answer period back into instructions. That's all I have.
Thank you, Diane.
Any questions from the commission for that speaker?
Oh, by the way, I am a licensed realtor.
All right, thank you. We can move on to the next, David.
Very good. Let's see. We've got Doug. I've asked you to unmute.
Thank you, commissioners. This is Doug Barber. I've been teaching real estate for decades and have studied a lot about what makes people pay attention in class and what doesn't. And I can tell you that if we are stuck with only lecturing, people will get lost in their phones or their computers, unless you want to ban those from classrooms, in which case we'll probably have to start serving alcohol to get people there. So I really want to encourage you. I'm fine with getting rid of introductions and breaks as part of the time count, but you really have to have question and answer and group activities that get people engaged, because not everybody learns the same way. We've got kinesthetic learners, auditory learners, and people who will not pay attention and get the information if we don't teach to all the teaching methods like the Real Estate Educators Association and Arello suggest. So I really want to encourage you to leave in the group activities and leave in things like pre-quiz exercises, where we have people, I mean, even the real estate commission annual commission update class, we have a quiz. So it's important that we have these other options to reach students in a way that they like to be taught. And I would encourage you to leave that stuff in. I do agree that having the ACU taken before halfway through the year is the way to go on that one, though. So thank you.
Thank you, Doug.
Any questions from the commission? All right, I hear none, David.
Very good. Up next, we've got Damien. Damien, I've asked you to unmute.
Thank you. Commissioners, my name is Damian Cox. I'm an attorney that represents many brokerage firms concerned with the changes to Rules 617 and 627. And while it appears the adoption of these new rules is a foregone conclusion, I want to be absolutely clear. The removal of paragraph 5.3 from the listing contract and the adoption of the commission position statements in October, and now these proposed rules collectively represent a complete reversal of two longstanding commission policies. If there's any doubt, simply review the red line commission position statement number 22 or compare former Rule 63G with the proposed Rule 627. At the stakeholder meeting, we learned that this reversal is being driven by the Attorney General's office under the guise of legal advice. This shift comes after 30 years of consistent interpretation by previous AGs, previous directors, and previous commissioners, interpretations that coexisted with multiple rulemakings and revisions to commission-approved forms. We are now expected to believe that all of these predecessors, including past AGs and their staff, were incompetent. While licensees and the public received 3 minutes to voice concerns, the AG's office has spent hours in executive session, drafted confidential memos, and employed opaque processes to push its own policy. These methods are not only inappropriate, they lack transparency and are fundamentally undemocratic. We heard at the stakeholder meeting that the reversal is justified because some employing brokers misuse confidential information, but the rules you are now being asked to adopt do nothing to address that misconduct. Instead, they punish broker associates if they disclose too much while seeking guidance from their supervisors to help their consumers. We were also told at stakeholder meeting that there was a survey in which some employing brokers claimed they do not need confidential information to supervise. I am left wondering if those employing brokers misunderstood the question or whether they simply lacked the competency required to be an employing broker, particularly given the confidential information includes motivating factors, stigmatized property, and, quote, anything material about the consumer. There is an old adage that half of all lawyers are wrong. Over the last several years, you have received extensive written and verbal comments from at least 20 real estate attorneys, all stating that this policy reversal is not only harmful to the industry, but also harmful to consumers. Despite this breadth of expertise, the Commission is relying instead on the advice of 1 or 2 assistant attorney generals that have never actually practiced in the industry. Their justification is not based on changes to statute or law, but rather a reinterpretation of 30-year-old statute that they now believe does not explicitly allow confidential information to be shared with supervisors without informed consent. If this is the new standard, there are many other rules that will likewise need reevaluated. Regardless of today's vote, I urge the Commission to direct division to seek legislative clarification or amendment to the statutes so this policy can go through a legislative process instead of being decided unilaterally by the AG's office. Thank you.
Thank you, Mr. Cox.
I could just put a pause on things for 1 second. I think we may have lost Commissioner Doyle. I think she's having technical difficulties. But while we give her a second, did any members of the commission have questions for Mr. Cox? All right. Okay, I see none. Sorry, just trying to stall for a second to get her back.
Ms. Phipps, I'm actually going to chime in with you actually for a moment here too. I believe that Commissioner Bernadette is also having some technical issues right this moment. So if we perhaps, I mean, we've been at it for about 2 hours. Maybe would it behoove us to take a few minutes break in order to get those IT issues resolved, or just spitballing here?
That would be helpful. Thank you.
I think a break would be good. Thank you.
Very well, let's do that. And when would you like to reconvene then?
About 11:20. It's 11:09 now. How about 11:20? That give people time to take a break and for them to get their computers back on.
Excellent. And Mr. Cox, I still have you as unmuted should the commissioners have any questions when we reconvene then, okay?
Right,
Just want
thank
to let
you.
you know.
Thank you.
Thank you.
Thank you.
Hello? Testing?
Yes, Bernardo, we have you. We are currently in recess, but your video and your audio are coming in great.
Perfect. Thank you so much.
Can I test that too, David?
Erica, yes, your audio and video are both operational right now too.
Sorry,
Excellent.
our whole internet went down.
Not a problem at all. It happens.
Okay, well, it looks like we've got Erica back and we've got Bernadette back as well. So let's see. Do we have everybody else? Autumn, Erica?
I'm here.
Okay. All right. Well, it looks like we're good to go, David.
Well, thank you, Commissioner. Damien, if we've still got you, I believe that where we were was at the point of whether or not any of the commissioners had any questions for you.
And I'm still here.
Excellent. Thank you, sir.
Right, I see or hear none, so.
Thank you.
Thank you. David, you want to find our next speaker?
Yes, indeed. Thank you. All right, let's see. We've got Robert. I've asked you to unmute. Still showing that you're muted right now, Robert. But it's possible that Robert is not, in fact, back from break just yet. Just throwing a theory out there. But commissioners, I'm not seeing any other hands at the current time. If there are any other members of the public that would like to address the commission, please select that raise hand icon from the Zoom platform and we can recognize you. Oh, here we go. Telda, I've asked you to unmute.
Hi there. Can you hear me okay?
Yes, ma'am.
Okay. The name is Theda McDonald. Actually, I am with Distinct Real Estate, employing and managing broker. We've been in business for almost 9 years and have a smaller group, but over the years, I've been in a supervisory role and not being able to guide our agents would be just a mess for our people trying to get through the transaction. So many times it's strategy. It's what's going on with it. How do we get through it to avoid more litigation, more claims with our E&O insurance? These are all things that we take pride in. We guide our agents correctly, and we have legal counsel if we can't get there. So at some point, if we're taking that right away from us, I don't understand how we as employing brokers are supposed to do our job to train and supervise our agents. So I do hope that you relook at this. As Damien and Scott both have said, this is something that's extremely important to all brokerages and agents alike. There's a lot of new agents out there that need guidance. And actually, even myself, as a experienced broker for many years, we sometimes strategize on how to go about certain transactions. So this is why we have our brokerage and why we're able to do what we're doing. So I hope you reconsider that. Thank you so much.
Thank you.
Thank you. Any questions from the commission? All right, seeing or hearing none, turn it back to you, David.
There wasn't a hand, but it went lower. So I'm going to call on Robert one last time, see if we can capture their attention. But again, not seeing anything. So Stacy, I've asked you to unmute. Stacy, you're still showing as muted. There you go.
Okay. Can you hear me?
Yes.
Thank you. Hi, everyone. Stacy Schalk. I am a licensed real estate broker in Colorado, and I would like to just agree with the testimony regarding the proposed changes to Rule 4. I do also believe that you have to balance time in class with the time away from work for a day. And so dealing with breaks not being part of time can be a challenge when you're looking at that. But I do think that, a 4.5 hour class would be okay if you did not include the breaks. But when you get to a full day class, then you're looking at more like a 10-hour day for agents to be away from work. So I do think you need to think about balancing that. In addition, I think 6.27 informed consent, I agree with the conversation. I understand challenges with managing brokers, having to deal with designated brokers representing different sides of the transaction. But I also think that it is a function of the way that the profession has been created, that you're going to come into that situation and the managing brokers have to take their role seriously and protect both the consumer and their agents and make sure that and I think that is how most managing brokers behave. I also believe that Rule 6.27 is really poorly written and it's hard to understand. So I would suggest that if you don't change your mind on that rule, that you would at least rewrite it so that it's easier to understand.
All right, thank you. Any questions from the commission for the speaker? All right, seeing or hearing none. David?
Excellent. We've got Jen. I've asked you to unmute.
Hello, this is Jen Hall. I'm just speaking on behalf of me, but I just sat through 2 hours of the previous session discussions talking about a broker whose license was rescinded. And it strikes me that in 5.3, as we're trying to maybe limit some oftentimes what brokers are privy to, part of the discussion of that prior topic was that there was a managing broker who did not have full access to everything transpiring. And I find it interesting that we're reprimanding on one hand because of that, yet removing the ability in the next breath. So I definitely think that's something that should be considered, where these two choices are in contrast to each other and contradict each other.
That's it. Thank you. Any questions for the speaker?
Not a question, just a brief comment. That particular case, the managing broker, the previous managing broker lost her license, or her license was disciplined, and then she was being managed by another managing broker, but she was still handling all the supervisory roles. So I just want to make that clarification.
Yeah.
It wasn't the same situation whatsoever. But
I
thank you so much.
I understand that. Can I give a follow-up comment to that since I had a short time? I understand that that's the case. However, I think what we're missing here is that part of what was specifically discussed is the on paper managing broker was not adequately capable of managing because she lacked information. So I think it does apply. That's it. Thanks.
Thank you.
Well, commissioners, I am currently not seeing any other hands. So maybe last call from the attendees today. Megan.
Good morning. I just wanted to hop on here. My name is Megan Bello. I'm broker owner of Motion Homes Group. I've been licensed in the state of Colorado for 10 years, and I love helping my agents make money in real estate. It's been a huge passion of mine to help them sort of navigate this crazy world that is our industry. And I really want to chime in and add my voice to the voices of Scott Peterson and Damian Cox of the rule of the this, and I'm sorry I'm shaking, I've never been on one of these before, the supervised rule. I I really don't think it's in the consumer's best interest for the commission to be putting obstacles in place for my brokers to be speaking to me freely. I think the freer that a broker can speak to their managing broker, the better the transaction and the better it is for the consumer. And I think that these proposed changes would be really, really not good for the future of real estate. And as a young broker who is the future of real estate, who has every intention of being here until I sell my last house on wherever I go from, please reconsider. Please listen to the industry leaders that we put our trust in as the people, as the little guy, as just your managing broker that I use this. You can hear my kids in the background. I'm a single mom. Please reconsider. I'm adding my voice to the voices of that of Scott Peterson, Damian Cox, and many others I didn't get to write down. Thank you.
Thank you, Megan. Any questions for Megan? All right. Mira, I've asked you to unmute.
Good afternoon, everybody. My name is Myra Smallwood with Remax Royal Gorge in Canyon City. Thank you for your time. I, too, would like you guys to reconsider 5.3. The importance of an agent being able to go to their broker and disclose things to them is unbelievably helpful for the file, for the consumer, the sellers, the buyers, whichever party they're representing. I believe that by limiting that, it definitely sets us up for challenges and maybe some legal risk. Not only that, as a licensee who has the opportunity to be an employing broker, because I have my license set up that way, you'd be hard pressed for me to take on new agents and not be able to advise them correctly. So I think we're gonna have a lot of agents out there who are gonna have a hard time finding somebody who will take them on when we can't properly negate a file with them. So I would ask that you would please reconsider that. And then when it comes to education, I would have to concur with everybody. Everybody learns differently. And I can take the same class twice with two different instructors, but the class time conversations that take place with the different students is what's most impactful, because we learn so much verbally by explaining things that we sometimes often hear differently. So if you guys would reconsider both, I appreciate it. Thank you.
Thank you. Any questions for the speaker? Very good. Sonda, I've asked you to unmute.
Thank you. Sonda Banka, Sunny Banka, most people know me as, and I have had the honor of holding a real estate license in Colorado since 1980. And I've been an instructor for various different real estate companies since 1998. And I want to chime in on all of the things that have already been said. Having been an instructor, people do learn differently. They do need to be reinforced. They do need a break. I think, they do need activities. They do need participation to learn, to just stand there and read slides. I hate to say it, but just about anybody could do that. But that said, I've also had the opportunity to teach pre-licensing since 1998 for a couple of different companies. And I know what we're teaching, for students to pass or licensees to pass, future licensees to pass the state exam. And as an employing broker, and I've been an employing broker since 98 as well, as an employing broker, they need that guidance. I think the public is expecting that they're getting that guidance, regardless of how many years. I've got a gal that's been with me 10 years, and I think in employing brokers, it's our duty to be able to guide them and help them. And yet I see that that's being taken away. And yet I know from an instructor perspective, there are a lot of things in real estate school that they are taught, but there's a lot of things that they don't encounter. And in my case, it's my name and my company that's on the line. I would say if you've got brokers that are breaking the rules, maybe they need disciplined. Maybe that becomes part of the broker, training to get a broker license, but to punish every broker out there and not employing broker and not allow them an open opportunity that has been there for, I hate to say it, probably 45 years that I'm aware of, for them not to have that opportunity to train and work with their agents and to be a resource to their agents, I think that's problematic. I think we're setting ourselves up for a problem. And I thank you. And I thank you all for all you are doing.
Thank you. Any questions for this speaker? All right. Thank you. Let's see. We've got Jared. I've asked you to unmute. I see that you are unmuted, but we can't hear you yet. Now you're muted. And back to unmuted.
Can you hear me now?
Yes. Thank you very much.
This is Jared Nixon. I'm the broker owner for Coldwell Banker Mountain Properties in Durango. And I just wanted to give a little background. I'm actually a previous real estate commissioner. I served 2 terms on the commission from 2015 through 2021. And to my knowledge, in the 6 years that I was on the commission, we never once heard a complaint that was in regards to the proposed, Rule 6.17 as far as supervisory issues. And my concern has been, I'm just going to echo what, Scott and Damien and several people have said. I see a conflict here on how we can be, it's a requirement for, agents that are licensed for, under 2 years need a high level of supervision. And if we're taking the ability away for people to have confidential information in that, I just see a conflict there and I don't see how that works. But again, just wanted to provide a little bit of background, and also speaking to another commissioner, in the 6 years that she served on the commission, she never recalled a case coming before her where there was an issue with a conflict with a supervisory, with an employing broker, complaint regarding this. So my thoughts on this are, I just don't think that it is necessary that this change happen. And I would encourage the commissioners to take a hard look at this, because I think it's going to open up a lot of issues down the road. Thank you.
Thank you, Jared. Any questions for Jared, commissioners? Hearing none. Salem, I've asked you to unmute.
Hi there.
Hello.
Hello. Thank you so much. I couldn't say it better. My name is Salem Webb. I'm with another small brokerage, very similar boat to Megan Bells, who spoke a few minutes ago. And I just wanted to echo the sentiments that have already been very well spoken, better than I could put it into words, by Scott Peterson, Damian Cox, Theda McDonald, Stacy, Jen. If I missed anyone, I'm sorry. Every time they said something, I thought, yes, thank you so much. I couldn't agree more. We have such a duty to our clients, our customers, and the consumers to protect them. And I feel really strongly that the best way to do that is to be able to have open dialogue between associate brokers and their managers. There is so much value in the ability to brainstorm, whether you're that new broker in the under 2-year mark that needs that high level of supervision, where as the managing broker, it's my license that's on the line. If they make a mistake, buck stops with me. I have to make sure that they're being trained properly, that they are going to be an amazing agent for decades to come, and that our customers are getting the very, very best that they can. And that means that I have to be intimately involved in that process so that we can have those open conversations. I respect where 6.27 is coming from. We want to protect those customers at all costs. And I don't feel that the way that this was written, I feel like there's unintended consequences and severe fallout that are going to cause the opposite of the intent. So if we could revisit that, I just entreat you, please, please, please don't pass it as it's written, keeping in perspective that managing brokers need, it's so important that we are able to help our agents and rewrite with fresh eyes what was intended by 6.27 rather than what the outcome will be of the current words on the paper. So that's all. Thank you.
Thank you. Any questions for this speaker? All right, thank you, Sam. Well, commissioners, we have once again caught up to all of the raised hands, so there are no remaining hands at this time. Until now. DeMarcus, I've asked you to unmute.
All right. Thanks, guys, for actually hearing me. My name is DeMarcus Johnson, EXP. So I'm just kind of curious about the 6.72. Is there a way that we can get that shown on the screen? Because, like, from the way that I'm understanding it, is I don't necessarily think that you guys are saying that we can't communicate back and forth, just that the disclosure has to be there. And if that's incorrect, can someone please advise me as to what the actual intent of this ruling is, please? Thanks.
Well, DeMarcus, I can't speak directly to the intent here. That's outside of my role here. However, I am sharing the screen currently. I can't fit the entire rule on the screen. However, I do have at least the better portion of the first part here available for viewing.
So okay, so this is specifically pertaining to when their brokerage represents both sides of the deal, correct?
Okay, that's 6.7. The proposed changes to 6.7 that you're discussing. So basically, the proposed change is if both sides of the transaction are represented by the same brokerage, and one of those clients, just one, wants to waive their confidential information and allow that to be shared with the employing broker, then there would need to be disclosures about the potential conflict just because both of those brokers are within the same firm. And we do have a lot of consumers that are very confused by brokerage relationships. And when they see two brokers that are employed by the same firm, they get confused thinking that both brokers work for them, or that one broker that was supposed to be their designated broker has somehow shared their confidential with the other designated broker representing the opposite side to their detriment. So that is the reason behind this proposed part of that rule. It's all about consumer disclosure and allowing them to make an informed decision before their confidential information is shared with anyone other than their designated broker.
Okay. Well, in that case, I'm absolutely going to go on record and follow with everyone else and say that that would absolutely be to the detriment of the public. I don't even think that the public is aware of the questions that they may or may not even have. And us as licensed brokers, it's inherent on us to make sure that we clarify all of those issues, even if we are unsure if it's an issue or not. Thank you.
Thank you, DeMarcus. If commissioners have any questions for DeMarcus? All right. Thank you again, DeMarcus. Diana, I've asked you to unmute.
Good morning. Thank you. Can you hear me?
Yes.
Thank you. Good morning. My name is Diana Mendez, and I'm an attorney that represents real estate brokerage firms in the state of Colorado. I did just want to echo the concerns of my fellow colleagues and some of the industry leaders we've heard from today and on other meetings, but I also wanted to raise an angle that I don't think has been talked about, because I think that the interpretation that the AG is pushing for with respect to this informed consent coming out of the brokerage relationship statute really ignores the basic tenets of statutory interpretation in Colorado. The brokerage relationship statute at 1210-401 explicitly states that it governs relationships between real estate brokers and the sellers, landlords, buyers, and tenants they work with, so brokers and the public, not their internal firm operations. Colorado courts interpret statutes by their plain language and purpose, and the confidentiality provisions in 1210-404 and 405 I read as to protect clients from disclosure to outside parties, the public, others outside of the deals, and not from supervision within their brokerage firm. Colorado and statutory interpretation frowns upon readings of statutes that would result in an absurd result. And so considering that Colorado law mandates that employing brokers supervise associate brokers and review contracts to ensure compliance, if we remove the ability for employing brokers to do that and now place this informed consent requirement in place, we would have kind of an absurd result in interpreting the statute, which means the Colorado law is expecting employing brokers to be supervising and reviewing and discussing these matters with their broker associates, but we're taking a position that they can't do that without informed consent. Someone can't give informed consent if there is no option to say no. And so the idea that there is some way around this informed consent or some way that a consumer can say, no, I don't want you to share this information with my employing broker, and that consumer can either go somewhere else where there would be the same conundrum or hire a lawyer, I think it really does just kind of lead to an absurd result, and that statutory interpretation, probably those principles haven't been followed. So I don't think that there's a Colorado court out there that would interpret the statute to essentially make supervision illegal unless you get informed consent, which is really just a farce if the client ultimately has to give it so that brokers can appropriately supervise. So I think this has gone a little bit off track, and that statutory interpretation really hasn't been considered. And I just wanted to add that point. Thank you.
Thank you, Diana. Any questions for Diana, commissioners? All right. Once again, thank you, Diana. Stacy, I've asked you to unmute.
Thank you. My name is Stacy Lenner, and I'm the managing broker at Your Neighborhood Realty out of Woodland Park. And I don't want to repeat what everyone else has said, but I do want to point out that there is no harm in taking some time to revisit this and explore what might be a better option for 6.27 and beyond. I do want to say that changing the language as far as the red line contracts are concerned ahead of a vote here at this meeting, I think was preemptive and gives us all cause for concern that decisions are being made without true stakeholder input in spite of having a stakeholder meeting. It is not a good look in our perspective as your licensees. My job as managing broker is to protect our clients. And I can only do that if I know what truly they need. When a broker brings me into a conversation, I need to know what's most important to that client in order to help them navigate the best decision going forward. I really think there would be no issue or harm or problem in revisiting these rules and taking a harder look at, do we need to remove 5.3, or maybe we just need to extend the language in it to be more of an informed consent track? Thank you for hearing me.
Thank you, Stacy. Any questions for Stacy, commissioners? All right, not seeing any other hands of individuals that haven't spoken at this point. So I don't know if it's I'll leave it up to the commissioners, but I would propose a last call. And again, no hands at this time.
Okay. All right, well, thank you all for providing your testimony today. That ends the testimony portion of the hearing. We can now move to consider the proposed new rule 1.11. Do I have a motion concerning the adoption of the proposed new rule 1.11?
Motion to adopt 1.11.
We have a
Second.
second?
Okay, it is moved and seconded that proposed rule 1.11 be adopted. Any discussion? Right, hearing none. The question is on the adoption of the motion that the proposed new rule 1.11 be adopted. All those in favor say aye.
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 Okay. Those opposed say nay. Okay. Motion carries and the proposed new rule 1.11 is adopted. Okay, we will now consider the proposed changes to existing rules 1.11 through 1.62, which solely renumber the rules. Do I have a motion regarding the adoption of the proposed amendments to rules 1.11 through 1.62 to renumber those rules?
So moved.
For clarification, is it not 1.63?
It's my understanding that 1.62 will become 1.63.
Okay.
Is that correct, Director Waters?
That's correct.
Okay.
So
There is a
the-
motion, I'll second.
Okay. It is moved and seconded that the proposed amendments to rule 1.11 to 1.62 to renumber the rules be adopted. Any discussion? Right? Hearing none, the question is on the adoption of the motion that the proposed amendments to renumber rules 1.11 through 1.62 be adopted. All those in favor say aye.
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 All those opposed say nay. All right, hearing no nays, the motion carries and the proposed amendments to renumber rules 1.11 through 1.62 are adopted. We will now consider the proposed amendments to rule 2.11. So I have a motion concerning the adoption of proposed amendments to rule 2.11.
I have a question. And point of order on this one, can we have some clarification before we have a motion on the table? Or do you want a motion first and then the discussion? I just have some questions on these.
So usually you do a motion and a second and then ask questions.
Mhm. Okay, go ahead. I'll motion to accept the changes.
I'll second.
Okay. I have a question on 2.11 license portability. There was a question in the stakeholder meeting about this. I found it valid. What Colorado specific information is required for the service member or spouse to have knowledge of prior to issuing a license in this instance? Do they have to take the Colorado portion?
No, that would be in conflict with federal law. So they have to show us their military orders that they will be coming here. If it's a spouse, they have to show us their marriage certificate. They have to go through fingerprinting, but we can't require any Colorado specific education. That would be in conflict with federal law. And I will tell you, anything in conflict with the federal law will get us into trouble with the Department of Justice. I am aware of this from firsthand.
And then Mike, I had a question on this too, but it was really simply, there was B was a little concerning to me, some of the stuff that was crossed out, but I was wondering if this is completely based on federal law and if any changes would be allowed or I'm assuming based on your response though that this is coming straight from Fed law.
I'll give you some background. We had a complaint filed against us about how one of these portability licenses was managed last year. And so the attorneys representing us and the ones that have been speaking with the Department of Justice have carefully reviewed the proposed changes to make sure that this aligns with the changes that happened this past year with the federal law. Once they demonstrate to us that they have a military order sending them here and that they are either a member of the military or the military spouse, they do their fingerprints, we have to issue, and they have all of the rights as anybody else that has gained a license through kind of the regular standing. So if they get divorced at some point, they're still entitled to that license. So this language has been carefully reviewed by the attorneys that have represented us in the Department of Justice issue.
Okay.
Just to comment, I understand it's federal, but it sure seems odd to me that they wouldn't be required to take the Colorado test if they're going to practice in Colorado to know all the ins and outs of Colorado. It's going to be much different than another state, but that's just how it is.
I don't disagree with you about those concerns.
Okay.
But once they have that license, they have to comply with Colorado law. So if they are not competent to prepare our contracts and they get in trouble for that, you have the jurisdiction over that license to discipline them. It's very reactive.
So just a question on most things, you have federal law and then state, and state can be more restrictive, I thought. So couldn't we require that? You're saying we can't, but I thought state could be more restrictive than federal.
I think at this point, that would probably be a good question for your attorneys. It is my understanding on this one, we cannot be more restrictive.
Yeah, my concern is that B says, and it will, prior to the strike through, it said the service member or spouse must remain in good standing with the license authority that issued the broker's license or equivalent. So it's kind of concerning that they could come over with like discipline issues as well.
The federal law even allows them to only be licensed for a day before they come over.
And that's great.
But so the one thing that I will point out, the one thing that we have kind of put in place is that through this portability, they can't be an employing broker. They can come in as a broker associate or as an independent, but they can't come in as an employing broker, supervising others when they don't have any experience specifically with Colorado law.
Could we change that so that they couldn't be an independent? Because if they're an independent, there's no one supervising them and they're not going to know Colorado law. Can we change it so that they have to be an associate?
I don't know if you can make it that more restrictive. Again, this is where you all come in to address practice issues on the back end when they don't comply with Colorado law.
It seems that we should be trying to put stopgaps in place so we don't have to deal with them later. That if we say you have to be, an associate, you have to be under somebody for 2 years, that seems like that would help solve a future problem.
I don't know that you can restrict them to being an associate for 2 years, though.
Okay, so is
that a question that should we ask our attorneys in the executive session? Because I agree with Renee on that piece. It makes sense, but
as do I. And I mean, that would at least give them a couple of years of exposure and training potentially with their supervising broker.
So can we, any ones that we have questions on for executive session, can we put aside so we could do executive session once?
Absolutely.
That'd be great.
Okay. So let's put this one aside.
Okay.
Good call on that.
Mm-hmm.
And just procedurally, I don't know, Director Waters, if you can answer this for me. Do we need to change our motion to table that for the moment, or can we just move on to the next one?
I think you can just move on to the next one.
Okay. All right, so it looks like that takes us to the proposed amendments to Rule 4.2. Do I have a motion concerning the adoption of the proposed amendments to Rule 4.2?
I have a question. I know you said we're supposed to make a motion, discuss afterwards. It seems like that's opposite of what we normally do. Maybe we're doing it wrong, but I would prefer to have some discussion first. On this one, I think it's a great idea that we do this, but I think we should make it effective with 2027. I think if we put it into place for 2026, not everyone's going to know about it. For those people who take ACU at the end of the year, they're not going to know to take the ACU before it. So I think maybe we should put it a date in here, like if we put it in the ACU for 2026, that this rule is going to become effective in 2027. That way it gives people a heads up. Otherwise, we're going to have a lot of people who don't know that this is in existence, and they're still going to take their ACU later, and they're all going to be in trouble. So can we put dates in here, or make, as far as when to make it effective and et cetera?
So in the proposed revised line, if you want to say starting in 2027, we
Okay.
can do that.
Yeah.
And then we can add this to the ACU class for 2026. That way everyone knows for 2027. So, okay, so we're just gonna say in 2027, okay. And then are we actually, I just have a question too, will the ACU be available after July? I mean, I guess it would still have to be, because some people could get their license. What if you get your license on July 2nd?
So for brand new licensees, they don't have a continuing education requirement that first year of licensure.
Okay, what about other people, like say they forgot or they messed up, they know they messed up, but they still need to take ACU? Is it going to be available between July and December?
No, if you haven't completed it by July 1st, then you would be out of compliance, but there are other alternatives, like they can do a reactivation course, they can take the exam. There's alternatives for when you miss the ACU.
Okay, so it's just not going to be available, period, after July 1.
No, it wouldn't, because you wouldn't be able to get credit for it.
Right, but don't we still want people to have the information? I mean, they missed it. Hey, something came up. I missed it. I still need to take it. We want them to be educated. We know it's not going to count. And in essence, when they sign up for it, they know they could get a letter going, hey, you messed up, but don't we want them to have the education?
I just chime in. I think that a lot of people in that scenario, for one, they could go, usually like the online schools will have those types of courses available. But also, I mean, not getting credit for it, I think you're not going to have a whole lot of folks that are taking it after. So maybe they'd have to utilize one of the other options, like an online option or something. But to Marcia's point, I think in those scenarios, and that happened to me once, where I actually took the class but lost the certificate. I had to take broker reactivation. It was very expensive. It sucked, and I never did it again. So I made sure I kept all those certificates. But the reality is they have other options, So I think, but I love the thought process of starting this in 2027. So they have all year of 2026 to
Figure it out.
prepare for this taking place in 2027.
Okay, so should we just do a motion?
I can do a motion. Yeah, I can motion.
Can we do a motion to approve it with the change? Just saying
Yeah.
we're gonna, okay, or just say, I motion to approve the change to 4.2A with the inclusion of in 2027 before the rest of the change.
Yeah. I motion to approve 4.2A1 with the change that beginning in 2027, the annual commission update must be completed by July 1st of each calendar year.
Second.
Okay. It is moved and seconded that the proposed amendments to Rule 4.2 be adopted as further amended by the commission today. Do we have any more discussion about it? No? Okay. All those in favor, say aye.
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 All those opposed, say nay. Okay, hearing no opposition, the motion carries, and the proposed amendments to Rule 4.2 are adopted as amended today by the commission. We will now consider the proposed amendments to Rule 4.3. Do we have any discussion then first about the proposed amendments to 4.3?
I had a question, just it starts off with any deviation, and I just was wondering what that was referring to. Any deviation from the established curriculum. I'm
Like,
not,
what was the purpose? Was there people that were
yeah,
changing the curriculum? I mean, I guess is
yeah.
that kind of your
What is that
question, Renee?
referring to?
Yes, that has been the concern, that they have deviated and taught topics that were not part of the annual commission update course.
Gotcha. Okay. Okay, well, I'll make a motion to accept 4.3A.
Second.
Okay, it is moved and seconded that the proposed amendments to Rule 4.3 be adopted. Any further discussion necessary? Okay, hearing none, the question is on the adoption of the motion that the proposed amendments to Rule 4.3 be adopted. All those in favor say aye.
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 All those opposed say nay. All right, the motion carries and the proposed amendments to Rule 4.3 are adopted. We will now consider the proposed amendments to Rule 4.4. Does the commission have any discussion regarding those amendments?
Yes.
Yes, go for it.
Yes.
I think I can't say, I can speak for myself. I agree with the testimony that we received on this, that, I mean, I know how I learned. So, I agree that the group discussion, the activities, the quizzes, the exam and question answer session are very crucial to education. I was curious as to why this was recommended, was a recommended change, but, so maybe that can be answered, but I on my end struck through group discussions, activities, quizzes, exams, questions, and answers so that it would actually be included.
I think we should just strike all the changes, remove all the changes.
And you think we remove from instruction on?
Yeah, I don't think we need that. I don't know why we've got all this clarification, because we need all that stuff. So I would just remove all the changes and not do it.
Point of reference of why we are recommending a change here.
Commissioners, we're recommending this because we have seen course submissions where it's like 1 hour of question and answer, and they want CE credit for that. Well, if the students don't have any questions, you're giving them an hour for not doing anything at all. The division totally recognizes that there is value in group discussions, kind of practical activities, the question and answer portions, which you can actually kind of build into the rest of your course materials. It's when you are allotting large chunks of time of, we're going to spend an hour doing question and answer, and you end up, I've been in those classes myself where I'm like, just don't answer any questions, I want to get out of here. That causes a problem for us in managing those course approvals, because there's nothing kind of built-in guardrails to ensure that there's actually an hour of question and answer occurring.
Wouldn't that just fall under whoever's approving the courses? And if somebody sticks in an hour of that, you can just say, no, this isn't approved. We'll approve it for 2 hours, but not for 3. Can't we just approve it at that level?
So this helps us, though, to direct them to a regulation that says, no, you can't have an hour for just a question and answer session.
But it's if we just leave it how it was, it says the course must be at least 1 hour, containing at least 50 instructional minutes per 1 hour. That's pretty specific. So I'm not sure why, so if I don't know. I just think I'm not sure why we need to change it, because it's pretty specific that it's 50 and 10.
I do have some comments on this as well. Some of them were asking to specifically add the language and to include it so that it's bringing it in line with some of the instructional guidelines from around the state. So I do see value in having that on there. And so I did write some of this out, changing it to read, the course must be at least 1 hour increment in length, containing at least 50 instructional minutes per 1 hour increment. Instruction time is the amount of time devoted to the actual course instruction and includes group discussions, interactive engagement, activities, quizzes or exams, or question and answer sessions. It does not include acts such as introductions of speakers and breaks. So that we are specifying that those interactive activities and group discussions that are so beneficial are noted in the description, and can't be eliminated later.
I agree with that too. I like the way you did that one. I also think you need to have class and breaks. Short breaks help long-term memory. People learn differently. Um, Cramming is only for like just cramming stuff, I think is just short-term memory. If we want them to learn this stuff and then not end up back with us, I think having it as little breaks in there. But I do like that it does need to say that explain what that instructional time is, because they can't be coming in with a question and answer for an hour and want CE credit for that. That's not fair either. I mean, that's not doing.
So can we, Erica,
Erica, can you
actually
read that? Oh, I'm
said
sorry.
it well.
Yeah.
Yeah.
Can
Erica,
Can you read that
said
one more time just so we could like jot some notes?
The course must be at least 1 hour increment in length, containing at least 50 instructional minutes per 1 hour increment. Instruction time is the amount of time devoted to the actual course instruction and includes group discussions, interactive engagement, activities, quizzes or exams, or question and answer sessions. It does not include acts such as introduction of speakers and breaks.
I like it. But I don't know. I couldn't write it all down. So
okay, Erica can make a motion then.
Okay.
And then, yeah.
I motion on 4.4A4 to edit the language as follows. The course must be at least 1 hour increment in length, containing at least 50 instructional minutes per 1 hour increment. Instruction time is the amount of time devoted to the actual course instruction and includes group discussions, interactive engagement, activities, quizzes or exams, or question and answer sessions. It does not include acts such as introductions of speakers and breaks.
Okay, second.
Second.
No, I seconded it.
Okay, I was like, I don't know. Sorry.
All right, it is moved and seconded that the proposed, let's see how to phrase it, that the proposed amendments to Rule 4.4 be adopted as amended by commission motion today. Does that seem like a fair motion?
Yep.
Yeah.
And Commissioner Doyle, can you email me your language?
Yes.
Thank you.
Okay, so on the adoption of the motion that the proposed amendments to Rule 4.4 be adopted as amended today, all those in favor say aye.
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 All those opposed say nay. All right, that motion carries and the proposed amendments to Rule 4.4 are adopted as amended today. We will now consider the proposed amendments to Rule 4.5. Any discussion about the amendments to 4.5?
Can I get some clarification? They only discussed 4.4A5 or
Yeah.
4.4A4. So there's 4.4A5, 4.B1, and that's it for that one.
Yeah, we haven't gone through all of them, Melissa. That
Oh,
was
they're
just
all
that was
separate.
a 4.4A4, but we still have to do A5.
Okay, so then we need to withdraw that.
Well, let's go through them. I mean, if 5, no one has any. If that looks okay, we may be good to go. That's approved. And does anyone have any questions on B1?
I do. Yes.
Okay. Well, let's go through the questions before we need to go back and amend stuff.
Yeah.
Okay. So we had a request to add course topics of negotiations and anti-bias fair housing on the list of applicable topics. And I thought that was a very reasonable request to add those in.
Now, I'm sorry, real quick.
Where are you?
We're on 1, I think. We haven't got there yet because I have a question there, but we're talking about
It was 1.4B1.
Oh, B1.
Okay.
So
I think what you're talking about comes later in 2. That's going to be like E. That's gonna be E, I think.
Let's just look at the verbiage on B1, that first paragraph.
So the commissioners, that list of approved topics, starting with real estate law and ending with any other subject matter as approved by the commission, that's straight out of the statute.
Right, it's just the underlined part in that first part of 1.
Right. But what you're talking about, Erica, is coming in E.
In E. Okay, great.
Yeah.
Thank you.
Okay, so 1, are we good with 1?
Yes.
Okay. So now you're at 2E, and
Yes.
you
And I
want
have the same question as Erica. So, but I'll let you go ahead and go.
Okay.
what?
That was, sorry, just seeing if we could add those 2 in there.
I'm not following, I guess
Well, I'm just double checking that is, because my notes, I clearly had the numbers incorrect. So I want to make sure I'm adding them into the right one.
And I can tell you what my notes said on that. I agree. So it says instruction focus on prospecting, communication skills, techniques for marketing, including staging, branding, social media use, unless directly tied to regulation compliance. I also added negotiation in there because I think that part of negotiation could be discussion regarding integrity.
But this is under
Yeah,
that they will
eligible.
not qualify.
Yeah, so we don't want to add it
Yeah.
into the
We don't,
section.
yeah, like what I'm
Eligible.
asking is, my concern is when you say communication skills,
I think that needs to remain in
that
there.
falls under, to me, that falls under negotiation.
Yeah, I
Which
think we
wouldn't
should
be allowed, which I think
remove
would
it.
be, yeah, so that's what I'm saying is that
Okay.
the communication piece would suggest that you cannot have negotiation courses, which I think would be important because a negotiation course would potentially have training on integrity through compliance. You know what I mean? So I struck through communication skills.
I did
I don't
too.
know what other courses the division was thinking under that category, but I think that for sure I know negotiation is a popular one that I think would benefit the industry. But maybe there were others in that category that.
Well, communication skills are used in everything. So I think that communication skills should just be removed from that. Just strike it out and remove
Yeah.
it.
I think there's something that they're thinking of as far as breaking down that communication skills. If there's a specific top, maybe they can get a little bit more specific with that, but I would take it out as well.
Yeah.
Okay, so I guess we are going to have to amend our motion because if we're going to remove that, let's keep going, see if there's anything else we have to amend.
Okay.
Anybody have
And
questions on F?
I don't think you have to amend your adoption of 4.4.A4. Your next motion is going to have to deal with 4.4A5 and then the parts of B.
Okay.
Okay.
B and C.
So E, we're going to change. F, does anyone have a question on F?
No, none on F.
G, we good there?
I do have a question on that.
On G, what's your question?
The concern I have there, marketing or promoting a product or service. Well, in my mind, product or service could equal finance services. Like, I think even one at the stakeholder meeting, someone brought up, reverse mortgages. That's a really important thing, for agents to understand. Another thing I thought of is like home warranties. It's part of our contract, so it would be helpful to have insight about that, right? So it was so vague, and I just was concerned that there would be some things within that category that wouldn't be allowed. And that was really the concern that I had, is just the vagueness of it.
Real estate finance is part of the statutory acceptable topics.
Mm-hmm.
What we're trying to address is like an hour-long infomercial about electronic lock boxes. Like that's not appropriate for CE credit. That's not doing anything to really kind of improve or enhance a real estate broker's knowledge of their license practices.
Although it does equal safety, and we get complaints on individuals accessing properties. Not saying because not everyone's going to use them, but I don't know. I think like in-home warranties would kind of fall under that too. So I don't know. And I can't say that I produced anything better. I didn't rewrite it, but that was the concern. I think that there are some services that would warrant CE credit. Does anyone else have thoughts? Am I on an island?
I guess it would just be on a case by case, but I mean, I'm a fan of education, so I don't want to limit it too much. You know, as long as it's not for self-promotion, but if these are geared, you know, some of them where it's talking about, again, we go back to communication skills and marketing if it's on the seller side, but not so much on the self-promotion. As long as we are looking at them on a case by case basis and it's for the consumer, I'm okay with a lot of it. And I would not want to eliminate the opportunity for those licensees to gain education in those areas.
So, Marcia, is it safe to say that, let's say, for example, you had a home warranty company that wants, you know, our CE credit to talk about home warranties, like maybe some little known facts, like for example, there's home warranties that will cover new construction when there's a deficiency in like the builder's home warranty. Those are very valuable pieces of information. That so if someone had that course, they could proposition the commission, and the commission under B1 V as in Victor could still approve that course.
They could look at the course content and see if it would meet the standards.
Okay.
Okay. But an hour long to sell somebody a product, I don't know that that is going to rise to continuing education.
So do we change the verbiage? I mean, basically, you know, no infomercials, or, you know, is there something else we could put in there?
I mean, and it may not be, you know.
I think that's the whole purpose of the marketing or promotion. If it's just instruction on different types of products, I think that is what would set it apart and probably fall under the statutory topic of any other subject matter as approved by the commission.
Okay.
Okay,
So with that, I guess we could just leave it, no changes. Thank you.
And then we have D.
I didn't have any.
Anybody have anything on D?
So I'm just trying to figure out where we were adding in negotiations and anti-bias fair housing on the list of eligible topics.
We're not adding it. That's not we're not adding anything to it. The list of topics there is what Marcia said is already there.
So why would that have been denied as courses for CE and requests to specifically have that in here?
So I'm not sure why it would have been denied, but I think it would fall under the category of any other subject matter as approved by the commission. Fair housing is obviously something that real estate brokers should be trained in. That speaks to the license law, and negotiation is a part of like what you have a license for.
Okay. Well, I just had it. All right.
No, that came up. I remember that came up in the stakeholder meeting. Yeah. Well, so I guess we need new motions, huh?
Well, no, Marcia said we can just leave that motion. The motion we had to start with is fine, and now we need a different one that we're going to do everything else from 4.4A5 on down to 4.4D. Right?
Oh,
and
Peggy wins. Peggy wins.
What?
Oh, Myra, you've got you're unmuted. Okay. So we just need to make a new motion, right, from 4.4A5 to 4.4D, that we approve everything as written with the amendment that we are removing the words communication skills from 4.4B to E.
That's quite the motion. Okay.
Yeah. So that's
I'll
my
take a
motion.
shot at
Somebody
it.
second it.
All right. Okay. Motion to approve 4.45
No, 4.4A5
A5. Yes. Motion
to
yes.
4.4D.
I'm gonna say it separately just so it's easier.
Well, okay, I already made the motion.
Oh.
Yeah, so I made the motion.
I'm sorry, can you clarify? Can someone start that over?
All right, move to approve the changes from 4.4A5 through 4.4D as written, with the amendment to remove the verbiage communication skills from 4.4B to E. That was the one we were changing, where the communication skills, we're removing that verbiage and we're approving the rest of everything.
Okay, second.
Okay.
Okay, so see if I can now repeat this. Not really. The question is on the adoption of the motion that the proposed amendments to 4.4.A.5 to 4.4.D as written, with the amendment to 4.4.B.2.E.
Yes.
Okay. All those in favor say aye.
Aye.
Aye. All those opposed say nay. Okay. Hearing no opposition, that motion carries.
Okay.
Okay, and unless I hear otherwise, I think we're now ready to move on to 4.5.
Yep.
Yes.
All right, so let's now hear if there's any commission discussion regarding the proposed amendments to Rule 4.5.
Okay. I do have discussion around 4.5B.
No, G, we don't have a B.
We do.
4.5B
Okay,
is
yeah.
no course may be related, sorry. No course may be repeated for credit in the same calendar. Well, they cross out calendar year and license cycle. It's more of a question. And I know that we got a lot of stakeholder input on this. And I agree with some of it and not others. I think really the main concern is when we're looking at contracts, obviously people want to be able to take those annually. I think it's really important to be able to take contract classes annually. I know that there's courses I like to take annually, like for example, whenever I see a trust and probate course, I take it. I've probably taken that course, I don't know how many times, because I always find little nuggets. But I don't always anticipate needing credit for every single time either, right? Like in fairness, but I do think that there are some classes like contracts that people need the ability to take every year. So I'm just wondering when that contract class comes out, just confirming that it would be it would be a different course. I mean, my thought is it would be a different course every year, but I just want to, before we approve or not, I just want to make that clarification clear.
So with contracts, each year there's different courses. So it's the 2025 contracts, the 2026 contracts, those are reviewed differently. This also speaks to each course is issued an individual approval number. So you would not take the same course with the same approval number. Like if it's a 4-hour course, you wouldn't take that course 3 times in your license cycle, right? Because you're just repeating the same exact course over and over again. And again, like the whole purpose of continuing education is to learn and expand kind of your professional practices. So we want to make sure that the 12 hours of elective credit aren't just made up of one course with the same approval number being repeated over and over again within that 3-year license cycle.
Okay, thank you. Yeah, and I do agree that it's important to have like rounded education. So there are some courses, but I'm guessing that to Marcia's point, people that we take like those long 4-hour courses every year, I mean, there goes your there goes all your CE between, you're not really learning anything else. So thanks for that clarification, and I don't have any other questions about
Okay,
it.
but we do have courses like fair housing that you could take every year, which is a benefit. And that wouldn't have a different number each time. Courses like if you do the line by line contract course, that doesn't need to be updated. So that could be the same one in multiple years. You might want to take that one. Not just a contract update, but you could do a line by line contract class. So there are some classes that I think some people would benefit by taking every year.
Well, but do you think that realistically, think about like ethics, right? I mean, do you need to take ethics every year?
But a lot of people probably do, but that's another time.
For credit, right? So I see the need for a little bit of balance there. Even to your point, fair housing, I think that is something that should be in your license cycle, absolutely. But I do think that you will have so many agents leaning on these same classes that they're never getting they're not learning anything else other than these same classes. So I see both sides. I think ultimately I'm kind of leaning towards accepting the change, knowing that a lot of these are going to have different course numbers.
Commissioner, if I may, I apologize for the interruption, but we are also talking about a situation where there are a multitude of different instructors that offer similar courses. So a fair housing course taught by instructor A and the same course content being taught by a different instructor at a different provider may actually be very beneficial as well. Rather than taking the same course over and over again as well. That would lend itself to different interpretations, different experiences, different student body as well, which brings their value to the course as well. So I think there are a myriad of different discussion considerations there when we're talking about this repeating of coursework. In our experience, the vast majority of instructional providers, when they have new content, if new laws come down the pike, for instance, they do reach out to us with a new course or for a new course approval, excuse me. So, and as Director Waters indicated, that would in and of itself trigger a new course approval number, and therefore it wouldn't be flagged in our systems for a repeat under 4.5B.
That should help answer my question and my thought too, because I wondered if we during that license cycle, if there's a course and we made some changes, if there's some changes to a law or something, they might want to take that course again, and it might be called the same thing, but it goes by a specific course number, correct? And so it's some of the information might be the same, but it will have the updated information, but new course. So okay, then that answered, I think, David, you answered my question with that too.
Okay, so when an instructor updates a course, do they put it back through and they just get a different number? David, is that how it works?
Very commonly, yes. Particularly because in many of these situations we have an instructor saying fair market or fair housing in 2025 could be a name of a course. If new laws are passed affecting or warranting a change in 2026, that very commonly. I can't say unequivocally in every scenario. However, the vast majority of them, they would submit a new course for 2026 fair housing.
But do they have to, or can they still teach under the old one and just update it with changes? Do they have to submit for a new course number?
We do have a requirement here in Chapter 4 that our course content does need to remain current, but they do not oftentimes reach out to us and say, "Hey, I'm going to change the last 45 minutes of my 2-hour class with this information." As part of the course approval process, they submit outlines to us. And so if there's some minor tweaking going on, that really wouldn't warrant an update to us. However, if a substantial chunk of a course would change, that certainly would warrant a reapproval or a reconsideration in that situation. Yes.
Okay, so from that standpoint, I think we should just leave it calendar year, because if somebody submits a course and one section is legislative updates, then they can change those legislative updates each year because that's part of the outline, and the course is going to change each year, but it won't have a different number. So I think that it should be calendar year, not license cycle.
And I think, I don't know, I'm okay with license cycle based on what we just discussed, that they're going to be submitting in the cases where those courses that you want to be repeated, they're going to have new course numbers.
But they're not all. That's what David is, you're submitting an outline, and one bullet point in the outline could be legislative update. And so you're going to change that as you go through, and you wouldn't have to resubmit for another course, but the content will change during that section. So it should be calendar year, not license cycle.
What if it didn't change and you can just take the same exact course and there was no change?
Okay, but legislative updates do change every year.
But they don't, but that's just one course, right? You're not looking at all the other courses.
There are a lot of things that change every year. So that's why people are taking some of these courses every year, because there are parts of them that do change each year. So I think we just leave it alone and have it calendar year, not license cycle.
I would be okay going back to the calendar year. I, again, just really want to encourage the education. And even if it's the same class, you do get benefits going to different instructors or taking it again. They don't say the exact same thing every time. You pick up little pieces of information that you can add to your skill set. 3 years is a long time to wait to try and do that again. And I think that just more education. I always want people to take more education. I know this doesn't preclude them from taking that class if they want to, but when you have the opportunity to get that CE, that's one more reason for somebody to say yes to taking that class. Also, the amount of work that goes into these classes for the instructors, I'm so thankful that we have instructors that do that effort, put forth that, and to have to go back and ask for more I don't know, to resubmit that class again and again, just to be able to take the change or get the change number on there. It's just a little onerous and potentially expensive. So I don't know. I think I would lean towards keeping it as a calendar year, just to really drive home. Take the classes, take them again and again. If we're giving them some CE that's a little extra, I'm okay with that. Unless Marcia were to tell me that this is incredibly abused over and over again.
And before we go any further, am I missing her? But I don't see Autumn. And I've scrolled through and I don't see her. I just want to make sure.
She's there.
She's there.
She is?
Yeah, I'm here.
Oh, why aren't you? Okay, now I see you.
Well, you know what's
I
interesting?
went through back and forth, and I could not find you.
I turned my video off for a moment because the afternoon sun just comes in glaringly and you can't even see me. So that's
I'm sorry. I just wanted to make sure you had a point of view, and then and I didn't see you. So
yeah, I actually agree with what Commissioner Doyle is sharing with. I think that is probably a really good idea, unless of course it is brought to light that it is being abused.
systemically.
So I don't think I'm the one to talk on CE compliance issues because I don't deal with the compliance audits. That's kind of David's team. He can probably speak to how often they see this as an issue.
To speak absolutely candidly with all of you commissioners, we do see it, although you use the word systematically. I don't believe that we're seeing it so pervasive in that respect that it repeats all of the time. I mean, I think that there certainly are some considerations about if I take the same class, I might be refining my skills or my knowledge. However, if I'm taking a quiz, I know the questions, I know how to pass that exam. I think there are a few other considerations like that. And one other reference that I'd like to make was to Commissioner Lyon's comment, which is just a bullet point or something to that extent in an outline. Again, I think our team does really go through these course applications with a fine-tooth comb, and we really do want to make sure that there is educational value there. So something like legislative updates, as an example, wouldn't be something that would be satisfactory for course approval if we were talking about something that was 25 minutes, 30 minutes, or whatever, in any more substantial amount of time like that. That would require additional information. Maybe it's what bills we're talking about, how it affects the practice of real estate, things of that sort. So it wouldn't just be a bullet point, but rather that would sounds to me like that would be more of a substantial change, and certainly could be easily rectified by saying, here's my course with 2025 legislative updates, and here's my course with 2026's course or legislative updates. So I think it could easily be rectified. We do see a tremendous volume of course applications. However, that's our job to process those, and we're happy to process those. And the more information that we can receive from our education providers regarding the course content, the better we can feel that in fact we're carrying out the commission's directives of ensuring that there is value in these continuing education courses. So I would encourage certainly someone, if they have changes like that, to seek a new course application, or to submit a new course application and seek a new approval, because we do have this rule that approves them otherwise for 3 years. The exception to that 3-year approval rate would be if I'm only offering a course in an in-person, maybe conference setting, where we're having our conference next weekend, and that's the only time we're offering it. So we're not going to, we wouldn't extend that course approval for the duration of a 3-year period. Similarly, I don't think that we should be considering a legislative update from 2024 in 2026, because I'm crossing my fingers that they are already up to date on what happened in 2024, whether that was in 2024 or 2025. So, and we do see a lot of education providers reach out to us to retire stale courses, out of date courses in that sense.
All right, thanks, David.
Thank you, David.
Thank you.
Thank you.
Okay, so should we move on to G? The next one with changes is G, and there were a lot of comment on this. Credit will be awarded for only one course taught per calendar year, and I think that should be once per course per year rather than one. I mean, what if someone teaches 10 courses and they're only getting CE for one? Shouldn't it be once per course per year?
Well, and I had a question too. I was just wondering what the reason behind this rule was.
So that the instructors are actually taking other classes and not just relying on what they teach. They're expanding their knowledge by taking other courses.
Gotcha.
in some situations, commissioners, other states have limited it to a certain amount of those elective credits, for instance. That could be another consideration here. Would be that of those 12 elective credits that are required in a licensing cycle, that credits could only be awarded for up to a certain amount as well. That's perhaps another consideration.
So could we maybe consider 2 courses? I think 1 is pretty low. And I think
Can
it
we
would be a
just,
good idea to at least allow a couple of courses being taught for
so
credit.
we could remove that sentence at the end that got added. We could just take that out because it says teaching multiple courses or different courses within the same calendar year won't result in additional credit. Can we just take that out?
So I think you leave that, but you change the number 1 for sure. And
Well, because if we took that out, that way they'd at least get credit for each numbered class they were teaching, correct? Because they're
Yeah.
issuing a number for each class. So if they're teaching class with this number, they get the credit for that one. If they're teaching this credit numbered class, they get that one, which
But
I
that's
think
not,
is reasonable.
it says they only get 1 course per year. It
well, that's
doesn't
what I'm
say
saying.
that-
We change that.
So it should be 1 per course per year. So if they teach
No.
more than 1 course, they would get credit. Once per course per year,
Well,
up to 2 or 3 or whatever you want, up to.
well, they would get the same credit as the attendees. Is that correct? So if they're teaching a 3-hour course, their credit is 3 hours. Is that right?
Yes, but.
So
but
if they
like-
taught 5 courses for 3 hours, do you see what I mean? So I think limiting it makes sense, but 1 is way too low.
Okay, what do you think?
But what I'm saying is they get what if they teach 5 different classes,
Right.
they get the credit for each different class that they're doing. They couldn't teach the same class.
Yes.
So
Once
like
per course.
all the credit, all the
I mean, I'm okay with it because if they went and I mean,
So if they taught 5 3-hour classes, they would get 15 hours, which would take care of their elective course credit, and they wouldn't be learning any subject material from a different instructor. That's what we're trying to address, is that they're not getting all of their elective credit just from teaching. On the appraisal side, so the appraisers say that basically half of their elective credit can come from teaching, but the other half has to come from being a student.
Well, why don't we
Can we say that?
like that?
Educational.
because I guess I made an assumption that could be completely out of line, that they're going to classes to learn the information they're teaching us.
Well, ours would be half because
Not
they're required to
necessarily.
take ACU, and ACU is 4, and they're required to have 8 each year. So ours is already set up that way. You have 4 hours of ACU, and you could have 4 of what you're teaching. So it's already kind of set up the same way as far as the 50%.
Well, ACU is required, so everyone. I don't know. I like how the appraisers do it. I like the idea that you get half of the credit for what you're teaching.
Yeah, I like that too.
Can we change the last sentence, the proposed change, to basically just say an instructor can receive up to 6 hours of continuing education based on the courses that they teach?
Up to 6 hours per year?
No, total.
That'd be through the
12 hours
license
of
cycle.
elective credit for a 3-year license cycle. So that would give them half of their elective credit would come from teaching.
Okay, I'm missed something. If it's up to 6 hours per 3-hour cycle, you're not getting, that's only 2 hours per year you could get.
No, it's a whole cycle. So if
The cycle's 3 years.
if you take an 8-hour course, right? That counts towards, you only have 4 hours of credit left, right? The 8 is subtracted from the 12. So they could take 2 courses to get to 6. They could take one course to get to 6. They could take 3 courses to get to, you know what I mean? So either way, it's going to be for the cycle.
But that's what I'm saying. A cycle's 3 years. And if you're only getting 6 hours credit, you're getting 2 hours each year of the 3 years. That's not much credit.
I don't think everybody views it as they're taking their 8 hours every year. They take their, hopefully, not always, hopefully they take their ACU every year.
Right.
And then it's like, oh, I got 12 hours I got to complete, which they could do in that final year.
And I think what most agents do is they, depending on what curriculum they want to learn, it may be a 4-hour class. It may be an 8-hour class. I mean, it could be a 2-hour class. It could be a 3-hour class, but you have 3 years to kind of complete that, whether you do it all in 1 year or you split it in all 3 years or you do it in 2. That doesn't matter as long as at the end you have, your 12 hours. But that's my position. I like the idea of half of the credit.
Yeah, I'm okay with that.
I'm okay with a half credit too on that.
Same.
Okay, but that's not what was Marcia said up to 6 hours. So are we talking, okay, is that what you mean? We're gonna do it?
It has to be half of elective. It can't be half of.
Right, so not the 12, the 6.
Yeah, it has to be
Okay,
half
so-
of elective.
So Marcia, how is that? What is the verbiage on that then?
So I think you'd have to change part of the existing sentence, starting with however credit will be awarded for only one course taught per calendar year. I think you would have to say, however, an instructor will only receive credit for up to 6 hours per license cycle for courses taught that were approved for continuing education credit.
Okay, however, an instructor will only receive up to 6 hours. Say that, what was the rest of it? I'm trying to write it down.
An instructor will only receive up to 6 credit hours for instruction.
For a license cycle.
Per license cycle.
Okay.
Did I write this down okay? However, instructors will only receive up to 6 hours of credit towards courses
At the 12.
they taught. That doesn't sound right. It doesn't flow
So
well.
how about this? However, an instructor will only receive up to 6 credit hours for instruction per license cycle.
Okay.
Yeah, thank you.
Wait, repeat that again so I gotta change what I initially wrote.
Do you want me to read the whole thing with the beginning of the sentence too?
Sure.
Would that be helpful?
Yeah.
Instructors may receive continuing education credit for teaching an improved continuing education course. However, an instructor will only receive up to 6 credit hours for instruction per license cycle.
Okay.
So we're taking the part out about the awarded one course, et cetera. We're just taking that out.
Correct.
Okay. Okay. And are we taking out the part 2 about teaching multiple courses, et cetera, within the same calendar year? We're gonna take that out too and just have this?
Yes.
Okay.
I hope I wrote this right. I'm gonna try to make a motion, but correct me if I get
Well,
this.
we're not making a motion yet. We're still going through stuff.
Oh yeah, you're right. We haven't finished this section.
So are we done with, well, actually, that's 4.5. It's just those, so it's just those 2 things in 4.5. So we can do a motion then.
Let's see. Yeah. Okay. Motion to approve 4.5B and 4.5G with the following update. Instructors may receive continuing education credit for teaching an approved continuing education course. However, Instructors will only receive up to 6 hours of instruction per license cycle.
No, they'll
6
receive
hours, 6
up to
credit
6
hours of instruction per license cycle.
for instruction. They're up to 6 hours for instruction per license cycle. But B, I thought we were keeping that calendar year. I thought we decided we were keeping calendar year,
Oh.
not changing it to license cycle.
No, because I think, Renee, it may be unique to you to view it as your.
Well, I thought other people wanted that too.
I would like it to change to, I think it would be appropriate to change it back to calendar year.
Yeah.
I don't think we really came, I don't think.
Yeah, I don't think we came to a conclusion.
Yeah.
I don't think we had a conclusion on that.
No. So why don't we just do a little quick vote on that? And that way we could just do one motion, and maybe Renee, if you wrote that other motion correctly on G, you could read it. But
Okay.
So I was okay with license cycle. And I know Erica was calendar year.
I prefer calendar.
Renee, calendar year.
I prefer calendar year.
Calendar year, and then Bernadette?
I thought license cycle was good too, but I could go either way with that, really. I could see it.
So overwhelmingly,
cycle.
Calendar year.
The group is saying calendar year.
Okay, so I make a motion for 4.5 to 4.5B to remain calendar year, not do the change, and for 4.5G, instructors may receive continuing education credit for teaching an approved continuing education course. However, an instructor will only receive up to 6 hours credit for instruction per license cycle. And we are removing the additional sentence that was put in there at the end.
Second.
So having had a motion and a second, the question is on the adoption of the motion. The proposed amendments to Rule 4.5 be adopted as amended today by the commission.
Yes.
Okay, all those in favor say aye.
Aye.
All those opposed say nay. Okay, that motion carries, and the proposed amendments to Rule 4.5 are adopted as amended today by the commission.
Okay.
Right. Moving on now to consider the proposed amendments to Rule 4.6. I'll open it up to discussion amongst the commissioners about those proposed changes.
4.6. Oh, D. Okay.
I didn't have any questions in for that section.
No questions.
My question was, why do we even need this? It's kind of, I don't even know why we need this verbiage. I'm not quite sure what we're gaining by adding it.
To clarify to the licensees that they can't have continuing education credit when they take a class that's been expired.
Okay, but wouldn't they know that?
They don't know a lot about continuing education, unfortunately.
It's got to be written because somebody tried it. That's the only reason it would be there. Somebody thought they were going to take expired courses for credit.
Okay, and then we've got the word commission. We have the word commission in there, and the commission doesn't approve the license period, do they? I mean, isn't it the division? It's a division approved period, isn't it?
We do it on your behalf through a delegation. If you guys want to start reviewing all your continuing education courses, we're more than happy to let you do that.
No, I'm just talking
That's a
about the
hard
approved.
task,
It says approved period.
You'd have to meet more than once a quarter.
I mean, I've never approved the period for this that I know of. That's why I was questioning why it says commission instead of division.
Well, I'd like to make a motion to approve 4.6D.
Second.
Right. Having had a motion and a second, the question is the adoption of the motion of the proposed amendments to Rule 4.6D be approved. I don't know if I said that right, but to approve the proposed amendments to Rule 4.6D. All those in favor say aye.
Aye.
Aye. Those opposed say nay.
Nay.
Okay. Having only heard one vote in opposition, that motion carries and the proposed amendments to Rule 4.6 are adopted. All right, moving on to proposed amendments to Rule 4.7. Is there commission discussion about the proposed amendments of 4.7?
Yes.
All right.
My questions were E and F, which E says, essentially, without reading the whole thing, is that the provider is going to have to like monitor activity, breaks, etc. And then F says, well, F I don't really have that big of an issue with. I guess I'm just trying to understand the concern here, and really how they are going to monitor that. I guess that's the thing. There's a lot of courses that are online. How do you really monitor whether people are paying attention or not? There's a lot of courses in person. I don't know. How do they achieve this?
Okay, these people are adults. We're treating them like 5-year-olds. I know some of them act that way, but it's too much to ask an instructor to do all this stuff. Because some people take notes on their computer. So what are you going to do? The instructor's got to walk back and look at their computer and see what they're writing. If they're playing solitaire, if they're writing, and they're going to write down, oh, they took a break and oh, they did this. I think we're really getting nitpicky, and I don't understand. It's too much to ask an instructor. You could have 50 people in class and you got to keep track of who goes to the bathroom and who's sleeping and who's working on their computer. They're going to do the best they can, but if someone's not getting their education, they make a mistake, it's going to come back to us. But I just think this is way too much to ask an instructor who could have tons of students in there to keep track of things.
Yeah, I think they can maintain like records of the name and stuff, but I agree with that. And I'm wondering, I mean, if someone is teaching a course and through that instruction realize, hey, this particular student has walked out 10 times and each time they're out 10 minutes, they haven't maintained attendance in this class. In that scenario, won't they just not give them the certificate?
Commissioner Sanders, if I may, I think you've actually hit the nail on the head with this one. These proposed rule changes actually are written in favor of providers, so that providers actually have a rule that they can cite back to a student in the event that they are electing to deny credit or refuse to issue credit. It bolsters their argument rather than just saying, I'm the big meanie teacher. They have regulatory authority by which they can reference and say, I was required to do this. You did not comply. So it's just the other side of the same coin here, from just a different perspective to consider there, because we certainly have the student perspective, but we also have the provider perspective in this situation.
And then how let's say, in regard to the instructor, making sure is it just their word, or are they having to submit something to the division to ensure that these steps were taken? I guess give a little bit more insight on that side of it.
What we could do in this situation is include this language so that it is disclosed to the providers. There isn't a certification per se, at present, other than them, a course provider saying, I have read the rules and understand the rules, and will agree to comply with them. So, but there isn't an attestation or a certification as such after the fact.
And we don't need to submit anything to the division to demonstrate that. That's the part that I think we're getting into the weeds, if like they also have to submit reports to the division that everyone, was in class. That's where it just gets to be a lot. So
In the event of an audit, Commissioner Sanders, we do request the attendance records. So pursuant to point F there, but no, we don't say give us a recording showing the faces of every single individual or something to that extent. But we will audit attendance records and see if an education provider has elected to not issue credit for anyone. And furthermore, we also do audit courses ourselves. And in those situations, when we see perhaps it's someone driving down the road or asleep in their bed, they may be on camera, but they're clearly asleep. Those types of situations, we do reach out to the course providers or the course proctors, as the case may be, if they have a specific designee that is acting as a proctor, and let them know. We want to coach them. We want to say, hey, it looks like so-and-so might not be paying so much attention. You might want to consider reaching out to them. So again, we really encourage this coaching approach that allows us to have develop a relationship with the course providers in order to encourage this higher quality of education.
Okay.
We also receive complaints about instructors. So if somebody wanted to complain to us about, well, Marcia didn't give me credit for this class, we can reach out to the instructor, find out, well, yeah, you didn't get credit because you were on video sleeping or having your hair dyed. That's why you were denied.
Okay. Thank you for the clarifications. All right, well, I guess I'll make a motion. That's fine. I don't, you've answered my questions. I don't have a problem with those at this point. Does anyone have any issues with any of the other areas of that section?
Who's actually in charge of the instructors? Are you in charge of the instructors, David?
Yes, we have a long list of those both education providers, which are traditionally maybe considered a school, and then also the specific instructors, because I might submit a course for commission approval, but I might have me or two of my colleagues as the potential instructors. So we review the qualifications of each individual instructor as well. So we do get down into the weeds in that to make sure that each instructor does have those qualifications.
Okay, so you're saying you could have multiple instructors assigned to one course. So because H says that you have got to give 30-day notice before the next course offering, and if there's any changes, I mean, so if somebody gets sick and can't teach the course and they call up somebody else and they teach it, that's not a 30-day notice. So I'm just kind of confused about this 30-day notice, changes to the provider name, contact, instructor, because you could have somebody, who's sick or something else comes up and all of a sudden they have to change it. The course is being taught, but the instructor has changed.
We're asking for that additional time there in order to simply vet a new individual. If I've submitted a course and indicated that I'm the sole instructor and I'm sick, but I would like my colleague to offer to instruct the course in my stead, I would be required to submit their information to the division in order to ensure that they are qualified to teach that course. The 30 days is there only because we do need time to process these. We receive many on any given day, and so it does take some time there. However, so the second alternative here is if I have submitted a course for application and both myself and you are the instructors, we don't say on Tuesdays Commissioner Line teaches it, and on Wednesdays David teaches it. Whatever day the course happens to fall on, we would have basically a blanket type approval for any instructor that has already been reviewed is permitted to teach this course.
So how could we change this one on H then? How could we change it? Because you're saying it's really the 30 days is to vet a new instructor. So do you have a recommendation on how we could modify H that is talking, because you're saying it's really for new instructors. Do you have a recommendation to modify this?
I have a question on that. When they submit the course, when they submit it, are they also submitting them or a list of instructors that will or can teach the course, or is it does it ask who is going to be teaching this?
Yes, we do collect the information on all of those instructors at the time of the application. As well, we do receive occasional requests saying, "Hey, I'd like to add another instructor to teach this course," and so we can then modify that in those situations. Now, and that's where this 30 days comes in. If I'm saying, "Hey, I want to add someone else to be an instructor," and guess what? They're teaching the course in 3.5 hours. That's really not going to be an appropriate amount of time for us to actually ensure that new proposed instructor has the requisite qualifications to teach that course. So that's why we're asking for some additional time there. There's another factor to this subsection H of the rule, and that's also that when a course provider moves around, let's say I'm teaching at brokerage ABC and I move to brokerage XYZ, we are very concerned about who's maintaining those records for purposes of verification. See subsection H or F above. We want to make sure that we can find that information should we need it for the purposes of an audit or the purposes of directing a licensee to where to reach out in order to obtain a certification if they have misplaced it, for instance.
Okay, so we could add in there before that last part of any changes to provider's name, we could also add a new instructor or any changes. Is that because you're saying it's both? So you're saying you need 30 days to add a new instructor. So should we change that in a manner acceptable to the commission to add a new instructor or of any changes to provider's name, contact, etc.?
I believe that would certainly satisfy the purposes behind this proposed rule. Yes.
Okay. Okay. Okay, anybody else have any other questions?
None from me.
So it looks like we're keeping everything the same, except we're adding that clarification about new instructors to H. Is that what everybody agrees on? Before we,
I don't have a problem with it.
okay. Anybody else have any other changes? That was.
Are you just inserting the word new in front of instructors at the end of that sentence?
No, after commission, we're putting to add new instructors or any new changes to. So we're adding to add new instructor or any changes.
Okay.
Because it makes sense you'd need 30 days to approve a new instructor. So
I think that's fair.
okay, so I'll make a motion then that we approve the changes in 4.7 with the amendment to 4.7H, inserting after the word commission to add new instructor or, and then any changes to the provider's name, etc.
Second.
I'll second.
Oh, Eric already second.
Yeah, I
Oh,
second. Yeah.
I didn't hear you. Sorry.
No, that's okay.
All right, where's Melissa? We lose Melissa?
Melissa was muted, sorry.
Oh, okay.
There.
It has been moved and seconded that the proposed amendments to Rule 4.7 be adopted with the additional amendment to Rule 4.7H discussed today. All those in favor say aye.
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 All those opposed say nay. All right, that motion carries and the proposed amendments to 4.7 are adopted with the additional amendment to Rule 4.7H. Okay.
So before we get into all the rest of it, could we take a break to go get something to
Yeah.
eat?
I have to use the restroom.
Yeah. So how much of a break does everybody need?
15 minutes. Shut down some food.
Yeah, 15 is good.
So 1:30.
1:31.
1:31.
All right.
All right.
Thank
Okay.
you.
Yeah. Okay, it looks like we're still missing, oh, there's Erica. Okay, it looks like we've got everybody. Although, do we have Melissa?
I am here. Are you guys
Okay.
ready to dive into Rule 6.17?
I would assume we can put that on executive discussions.
So we have 617 and 627. Do we want to go into
Oh.
executive session now? Or
Sorry,
do
you guys couldn't hear me. I was on mute.
do-
I was saying that I do have a question, whether we do executive session or or not. But when we have the initial discussion, if we could initially just have a conversation about 6.17 and 6.27, because they're so closely related, and I think it's going to be hard to dissect one without the other. And then we can kind of come back to each rule and go from there. But I would like to discuss them as a collective, if that's okay.
Works for me.
I have a statement that I'd like to say on them in combination, and I'm happy to do it now.
Do we have, I don't feel that I'm kind of ready to dive in, so I don't feel the need to go to executive session. But if there are commissioners that feel that that would be appropriate, then just let us know and we can do that before we all dive in.
I want to hear Erica's statement, but
Yep, let's go for
it.
Okay, I've written out my comments, and following today's additional public feedback, I feel that they still stand. So please bear with me for the next few moments. First, I want to thank each person that has taken the time to participate in the public feedback in the stakeholder meetings regarding the topics of informed consent and supervision. I want everyone to know that I've listened to you. I've listened to the division, to the AG, to my commissioner colleagues, and to every public comment, both spoken and written along the way. The issues have been moving through the process, and I have been hopeful we would see a reasonable rule that could be drafted, improved, ultimately giving clarity to both consumers and practitioners alike. Nobody is opposed to consumer protections, and I was particularly thankful to hear those that were specifically addressing the consumer experience with their commentary. We are dealing with several intersecting issues whereby licensees must comply. Supervision must be provided, yet confidentiality must also be maintained in accordance with the statutes. And the contracts cannot have a blanket waiver of confidentiality. I have been a proponent of drafting new written guidance to address these issues so licensees know how they should move forward with what was being discussed. I would like to thank those that have worked so very hard on these drafts. I can only imagine how much work they put into this. However, even with all this effort, and though it is not without merit, I am not seeing that the clarity and guidance I was hoping for has been achieved. In fact, unfortunately, I believe the current proposal has added more layers of confusion to an already complex transaction. Simply stated, this Board of Commissioners can and should continue to discipline any licensee that doesn't handle this information accordingly on a case-by-case basis. As such, I would propose the following. Remove the proposed addition of Rule 6.17 D and E in their entirety. Remove the proposed addition of Rule 6.27 informed consent in its entirety. Revert CP 22 to its former state, and repeal CP 31 in its entirety. I am, of course, interested in hearing my other commissioners' opinions. That's all.
Thank you. I wrote mine is maybe a little lengthy here. But I would like to read mine as well. Okay. Well, I'll just kind of talk about it. I don't want to read this whole thing, but so of course I've been part of this conversation since April, but I know this has been like a 2-year or more situation. There's been a lot of concern from the division, and over the past several months, but especially the past 4, we've heard each of you, the division, the stakeholders, the consumers, and truly appreciate all the time that has been taken in providing your thoughts and your perspective on this issue as it relates to informed consent. And in listening to everyone, One thing that is certain, there is definitely a clear dichotomy in opinions on the issue of informed consent. And I just want to note that, because I know this came up earlier, but while we made a decision to promulgate a rule, at least from my perspective, we did so with the intent to move the conversation forward and engage the stakeholders, which would be the industry, consumers, in order to help promulgate a rule that satisfies both the industry and the consumer. So we know that the division's biggest concern was that 5.3 didn't go far enough as it related to informed consent. Also, based on multiple complaints, we understood that managing brokers have breached confidentiality in some scenarios. From the industry standpoint, we understand that the biggest concern is supervision. And largely, stakeholders believe that 5.3 should be reinstated in the contract. There's also strong feelings regarding the unavailability of a form to provide the informed consent, and many believe that this will cause additional barriers that will lead designated brokers to avoid seeking advice from their managing brokers. And I just want to say this has been very challenging, I think, for all of us. And overwhelmingly, I think the issue that has us like knocking our head against the wall is supervision. And so I really took some time, did a really deep dive in the statutes, in all of them from 12.1210, 217, 1210, 222, 6.3, 1210, 404, 56, and really when you put all those together, to me, the way that I interpret that is that supervision really shouldn't be part of the conversation. We should be able to supervise. And I'm just going to kind of break this down a little bit if you just bear with me here. So 12.10.217.1 and R, 12.10.222 mandate supervision and warns that failing to exercise reasonable supervision over the activities of licensed employees could result in disciplinary action. Rule 6.3 requires reasonable supervision, which would include supervising licensee activities, reviewing and maintaining transaction files, compliance review, oversight, auditing, and corrective oversight. And since this is mandated by statute, can we really require informed consent to perform a legally required duty of supervision? Because that would require consent to perform a duty that the law already requires managing brokers to perform. And so I think it's also important to note that in my research, and it's very interesting because we had actually someone testify to this today, and I wrote her name down, and I apologize, I don't have it, but she was a real estate attorney. And in my research, a lot of what I concluded was similar to what she said. And it's important to note that informed consent applies to disclosures to an outside party. I really think that's the interpretation of it. Whereas supervision arguably isn't disclosure to an outside party. Instead, it's a transfer of information to an inside party. And if that's the case, disclosure shouldn't be required for the purpose of supervision. So ultimately, I am going to propose that we remove, sorry, let me get the 6.17D, because if the act of supervision doesn't require informed consent, that would include all acts of supervision, whether there's management on both sides of the transaction or just one side of the transaction. But then follow me a little longer. I apologize. There's a lot of cars on this train, but just bear with me. On the other side, I think that there is a need for protection. And I want to propose a solution that I think would resolve some of the concerns that the division has, but also allow the supervision. I don't know, I'm getting an echo. Can you guys hear me?
Yep.
Okay. And so what I am proposing is that we remove D, but kind of moving into informed consent. I actually think we leave informed consent. However, informed consent really should be, in my opinion, required in situations that are more high-risk consumer-facing activity. An example of that, when a managing broker is on the other side of the transaction, that is consumer risk. When confidential information is being relayed to a third party, that is consumer risk. Therefore, I'm recommending that we remove the supervisory layers that we put on this, but still leave informed consent only in instances where a managing broker is a party to the contract, because at that point, it's beyond supervision. And at that point, the managing broker it's created a conflict of interest, which I think would need some protection. So that consent would be written. It would be specific. It would display the risks. When you're providing confidential information to third parties, that can harm the consumer. Give you an example. Builders, some of them, there's some out there that require the listing contract in order to pay you. That is confidential information. That is a seller. That is not something that they should have. I think having the protection in place is going to help our industry so that we can protect our clients when we need to, but also allow us the ability to supervise without all of these layers and restriction. So I have developed, just as a talking point, some corrections, we'll say, to the or possible amendments to the current rule that I just would like to present. And then, we can get your opinions on it. Is it okay to have a couple more minutes? I know I'm taking a lot of time.
You don't have any time restriction.
Thank you. Sorry, I just got to find it here. I may have closed it. Okay, nope, here it is. Okay, so as I mentioned, I'm proposing that we strike through D altogether, but that we leave E, which states if the employing broker supervises the designated broker that represents the opposite side of the transaction and the employing broker represents the other side of the same transaction, the employing broker is prohibited from receiving confidential information about the designated broker. I would like to leave that there. Under informed consent, I would change the first sentence to say, a broker representing a buyer, seller, landlord, or tenant, or acting as a transaction broker must obtain informed consent of a client before disclosing any of the confidential information for any purpose to any third party. The client's informed consent must be in writing, must be voluntary, specific, and made following the broker's full disclosure of the risks involved and the alternative options available. There's another big chunk of an addition that I added. And again, this is subject to, I'm not an attorney. This is subject to, and we can discuss this in executive session, how to clean it up, but this is the gist of it. For purposes of this rule, access to client documents or communication by an employing broker or supervisory broker for the limited purpose of compliance review, internal auditing, quality control, risk management, transaction oversight, or statutory supervision shall not constitute a disclosure of confidential information. Such access is considered an internal function of the brokerage firm and does not require separate informed consent, provided that the employing broker does not affirmatively communicate the client's confidential information outside of the designated brokerage structure or use such information to the detriment of the client or for benefit of another party to the transaction. Confidential information may only be shared with the employing broker to the extent reasonably necessary for supervision or compliance. The employing broker or supervisory broker shall not influence, direct, or attempt to guide negotiation strategy for either side of the transaction when serving in a supervisory capacity. So thank you for your time. I'm out of breath. That was a lot. But would love to hear from the rest of you and we can all talk about our different propositions here.
Erica, I just want to say thank you for putting so much time and thought into that. I really appreciate your approach.
And that was Attorney Diana Mendez who
Thank
brought
you.
that up.
Yeah.
Yes.
Yeah.
I think that this is something that I think could potentially propel these discussions moving forward because it has been almost 2 years, I think, from my knowledge. But I'd be eager to hear what our state attorney has to say about these modification suggestions.
I'd like to thank Erica Doyle for what she said and how she said it, and I support what she is referencing.
Thank you both for putting so much time into that. It's obviously you took a fair amount of time to go over that. A lot of food for thought there. So I'm looking forward to be able to chat about this in executive session as well.
Okay, I'm taking that to mean that we're wanting to go into executive session now to discuss. We've got 2.11 we need to discuss as well. And then we've got, so let me grab this. This is Commissioner Chair Renee Line. This is a Colorado Real Estate Commission meeting being conducted on December 2nd, 2025. The time is now 1:48 p.m. I move the commission enter into executive session pursuant to Colorado Revised Statute, Section 24-6-4023A2 for the following purpose: to confer with counsel, to receive legal advice on specific legal questions regarding the following meeting agenda items. That would be Chapter 2, 2.11, the licensure requirement, as well as Chapter 6, 6.17, and 6.27. We have a motion, or I'm sorry. Yeah, a motion and a second.
Motion to go into executive session.
Okay. All right.
Second.
Second.
Sorry, I got kicked out.
Okay. All right. Okay, we will now turn off mics and video and move to executive session.
Okay, sorry, I had to grab a charger.
So, we're missing Bernadette. Okay, while we're waiting for Bernadette to come back, I just need to say that before we went into executive session, we made a motion and a second. Everyone nodded in approval, but I didn't take a formal vote, but everyone did approve going into executive session for the record. And
I'm here. Thank you for your patience.
great. Okay, Melissa, do you want to go back to 2.11 so we can get that taken care of?
So Melissa had to step away, so
Okay.
I will be Melissa here really quickly.
Okay.
Until we'll probably get through this before she rejoins, but do you have a motion regarding the adoption of proposed amendments to Rule 2.11?
I believe we had made a motion. We had a motion and a second, but then we had questions. So we did have a motion to approve it. Looks like Erica Doyle made it. Erica Sanders second is what I've got written down.
Okay.
And
so
go ahead.
The question is now on the adoption of the motion that the proposed amendments to Rule 2.11 be adopted. All in favor, please say aye.
Aye.
Aye. All those opposed, say nay. The motion carries and the proposed amendments to Rule 211 are adopted. So that brings us to Rule 6.17. The question is on the adoption of the, Do I have a motion concerning the adoption of proposed amendments to Rule 6.17?
I don't know. Do we have any more discussion on it? Or do we want to make?
Certainly could. I know I presented my thoughts on it, but we didn't really continue that conversation. So let's just start where we ended. So I proposed removing the requirement of the informed consent when you have a managing broker that is managing associates within the same firm. And then I propose to keep managing broker, informed consent with managing broker who is on one side of the transaction and they are also on one side of the transaction and they're designated brokers on the other. So that's where we left the conversation. I think we should pick up where we left off, have a public discussion and go from there.
Okay.
And just to clarify, you propose to delete the proposed D, but keep proposed E.
Correct, yes.
Okay, then we also had another proposal getting rid of all the proposed changes in 617 DE and 6.27.
Yes. And then if we could publicly hear from the other commissioners and just give your thoughts on what was proposed.
And can we do one rule at a time? We'll get to 6.27 next, but if you can just focus on 6.17.
Okay.
So for 617, I think we should get rid of both D and E.
I agree.
Autumn, Bernadette?
I mean, I agree that these two paragraphs have been the source of much discussion.
Yeah.
But I also appreciate Commissioner Sanders' attempt at defining this with some maybe guardrails that give some clarity.
I I kind of like Commissioner Sanders' suggestion. Um, I know you guys have put more time into this than even before I came on the commission. And I see this as, but I see that we got to do something with it too.
Well, can I ask a quick question? So if we do end up modifying this in some regards, striking some, modifying in others, what are the next steps? It sounds like it's going to be on next quarter's agenda. Does it go
well,
through public process again for feedback, or what does that look like?
So if today you decide either to get rid of D and E and that vote passes, or you decide to get rid of D but keep E and that passes, then you've adopted that rule with modifications and it does not come back at the next meeting.
Got it. Okay. Thank you.
Is there any more discussion on D and E?
My concern with modifying E at this point is that we would not have the public feedback for the potential changes that would be on there. And so I would still go with removing D and E on that, although I do appreciate what you put into that, Erica.
Thank you.
That makes sense too.
Yeah, and I appreciate that perspective. I disagree. I think that that both of those were part of the conversation. I think generally the stakeholders, and matter of fact, I mean, I know some stakeholders agreed with just getting rid of D. I do think that the employing broker supervising a designated broker on the opposite side of a transaction is a conflict that should be like disclosed. And if you look at this rule, it's duty to disclose conflict of interest and license status. So if you kind of just look at that, even separate from 6.27, it still kind of makes sense for it to be there. And I do think that we've had some stakeholder feedback and they definitely have had an opportunity to review it. But that's just me defending my position. So definitely open for conversation.
So Erica, playing devil's advocate on E, I mean, isn't this represented in other areas of rule? I mean, this seems like it's kind of standard operating procedure.
It's not.
No.
Sure.
Okay, interesting. All right, thank you for clarifying that.
So does somebody want to make a motion?
Well, if I motion, you know what it's going to be.
Well,
And you can make that motion.
well, okay, I motion to remove 6.17 D and E.
Second.
Okay, it's been moved and seconded that the proposed revisions to 6.17, the new provisions D and E, be rejected. Any discussion?
No further discussion for me.
Okay, so the question is on the adoption of the motion to remove proposed amendments to Rule 6.7, the new D and E. That those be rejected. All those in favor say aye.
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 All those against say nay.
Nay.
Okay, that motion passes. So D and E are rejected. Now we'll consider the proposed rule 6.27. Do I have a motion concerning the adoption of the proposed rule 6.27?
I will motion. I would motion to remove the proposed addition of Rule 6.27, informed consent in its entirety.
I'll second.
There's a motion and a second. Any discussion?
Only discussion is that I'll have, because I was actually in favor of third-party disclosure being in writing. I was also obviously in favor of, if an employing broker's on the other side of the transaction, that being in writing. I don't know if I guess the clause that I presented could still be helpful on third parties, for third parties. So I don't know if you guys want to consider that.
So
when
Erica, do you mean striking the entirety of the text as is and then insertion of a specific line?
No, it would just, it would leave it. Obviously, it wouldn't apply to supervision.
It would not apply to supervision.
No.
Okay.
Because those have been, well, now I'm a little confused, to be honest with you. It would just add that clause about supervision in it, that it's not, sorry, I have to pull it back up, but basically saying.
I just want to make sure I'm crystal clear on.
This is something that we could put in a commission position statement. It doesn't have to
And it
be
could.
here.
That's definitely an option. Let me just read what I had on the public forum again, and then we can kind of go from there. So the changes to this was first sentence. After client's confidential information, it would say to any third party. And then the client's informed consent would be in writing. It must be voluntary, specific, and made following the broker's full disclosure of the risks involved and the alternative options available. And then I propose that we add, for purpose of this rule, access to client documents or communication by employing broker or supervisory broker for the limited purpose of compliance review, internal auditing, quality control, risk management, transaction oversight, or statutory supervision shall not constitute a disclosure of confidential information. Such access is considered an internal function of the brokerage firm and does not require separate informed consent, provided the employing broker does not affirmatively communicate the client's confidential information outside of the designated brokerage structure or use such information to the detriment of the client for the benefit of another party in the transaction. Confidential information may only be shared with the employing broker to the extent reasonably necessary for supervision or compliance. The employing broker or supervisory broker shall not influence, direct, or attempt to guide negotiation strategy for either side of the transaction when serving in a supervisory capacity. So if we get rid of that, if we get rid of 6.27, perhaps this could go in a future position statement or something to that.
I appreciate all the work you did on thinking about that, but it's really lengthy and I would like to be able to look at it in writing and really read it. So I would say we look at putting that in position statement, next meeting, and we go ahead and just get rid of 6.27 as it is now.
Erica, I like a lot of what you have there as well. I would not put it in 6.27. I would remove it still, but I would like a copy of that if that can be sent over to me, and we can, I agree, look at some guidance there with the position statement.
And I do know Marcia has it. And so, yeah, we can definitely consider that as a position statement versus informed consent.
Perfect. Thank you so much for all your work on that.
For sure. My position again is I do think there's an issue with third-party consent. But and I'll kind of vote based on that. But that's kind of why that was created in that way, is that third-party informed consent.
I think we have a path.
Okay, so we have a motion. We have a motion and a second. Is there any other discussion?
I think just making sure that we have this added to our agenda for next meeting.
I agree with that. Maybe, yeah, put it as a commission.
Well, and as a point, well, I'll take the point after this. Let's finish this one up.
Yep.
So you have a motion and a second to reject 6.27. Can I get a vote? All those in favor say aye.
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 All those opposed say nay.
Nay.
The motion carries and the proposed rule 6.27 is rejected. Thank you. This concludes the rulemaking hearing, and we can now move on to your policy matters.
So I do have something I want to bring up here. Can we please add on CP 22 and CP 31 to the next agenda? I would have liked to have handled that today, but because it wasn't on the agenda, we were not able to do that. So I would like to make sure those are on there because they are referenced, these rules in them. So we need to make sure we take care of that next time.
And also, I want to add something to next meeting too, because kind of along the lines of this whole idea that, again, where I was saying I would have liked to see us restrict confidential information to third parties. Again, I have scenarios in mind, like builders, which are the seller, asking for contracts and stuff like that. Maybe it's part of, I don't know if this is appropriate, but maybe as part of the position statement, or maybe it's a new position statement. I think there's a couple of things that would be helpful for the industry. Number one, really protecting that confidential information. And also maybe a little bit of direction as to not to share confidential information unless it's explicitly necessary. So
Commissioners, I just want to kind of reiterate something from today. Regardless of 6.27 being adopted or not, the informed consent requirement still exists. So you don't get to just freely share your client's confidential information. And we can definitely work that into however you want to revise CP 31.
Thank you.
Okay, so next we're going to move into policy matters, and that'll be Director Waters.
So commissioners, earlier in the agenda was actually the public comment portion, separate from rulemaking. And we really didn't get a chance to see if there was any public comment related to items that were not on today's agenda. So if you could do that now, that would be best.
So meaning, is David still around, or?
David should still be here. The only one that ran away briefly was Melissa.
Okay. All right, Dave.
Thank you for checking, Commissioner.
Okay. All right. So we're going to ask now if there are any other, I thought we did public presentation of issues, not on today's, we did say that earlier, but does anyone else have anything to say?
Yes, so attendees, if you do have any issues that you'd like to bring to the attention of the commission, you may do so now. Speakers are requested to limit their remarks to 2 minutes unless additional time has been allowed by the commission. If any members of the public have any topics that they'd like to address at this time, please select the raise hand icon. And then we can unmute you. And we do have a hand here, commissioners. Anita, I have asked to unmute you, and you can address the commission.
Hi. First of all, I just want to say thank you for letting me attend this. This is my first time, and it's been very informative and very helpful. And I'm really impressed with the quality of questions and considerations that you are giving to these issues. The only thing I was going to add, which is not a new idea, is I personally had a lender disclose confidential information in the course of a transaction to the other agent, and it caused a very serious problem. So if there's a way to address that in your guidance for lenders, that would be helpful.
Thank you, Anita. Mr. Barber, I've asked to unmute you.
Hi there. And you guys are champs to work through all that. Thank you. Does this mean 5.3 will stay out of the forms for 2026?
Yes.
Okay. I'm trying to finish my class. Thank you.
All right. Let's see here. Not seeing any other hands at this time, commissioners.
Okay, Marcia, did you have did you want to move forward?
Yes, please.
Okay.
So commissioners, the first item under policy matters is recommended changes to the forms process. So the division took over drafting the forms changes this year. We provided you with a memo with some insights. We'd actually like to make, and I apologize, there's a dog in the background that is going crazy after a 6-hour meeting, but we would like to make the forms suggestion and participation process more inclusive to the broader industry rather than relying on 20 representatives to really kind of voice the broader perspective of over 51,000 real estate brokers in the state. So what we were proposing to do was have you give us direction on what you want modified. We will move forward, start drafting those changes. We will reach out to experts as needed. Then we will have stakeholder meetings, not that different from the one that we had for rulemaking, to gather the broader industry perspective on the proposed changes, incorporate the proposed suggestions as appropriate, bring those drafts to you, and then we would go through the non-rulemaking process as well to have you formally adopt them. We did a memo. The AGs also did a memo. I don't know if you want to go into executive session to discuss their concerns as well, but that is what we are proposing to do in 2026.
I did review everything, and pretty much upon review, the concerns I felt were articulated. I think the new policy would be beneficial for a couple of reasons. I like the idea of seeking expert opinion, which I think is a crucial step when especially dealing with complicated laws and scenarios and other just general real estate circumstances. I like the idea of allowing more stakeholder engagement because those are the people on the front line. And so it would be nice to be able to get that feedback. The one concern with that would be that feedback could be overwhelming, but that's just one of those things we have to test it out and see. We got a lot of feedback, obviously, on the rulemaking. I would imagine that contracts probably wouldn't be as extensive as the feedback was on that, which would make it a little bit more manageable. But that would be my only concern. And I support implementing these changes and at least trying it out for a little bit. And if they work, great. If they don't, we can always revisit it.
Okay, my concern is that Marcia just said that the commission will tell them what we want changed. And honestly, I personally, my expertise is property management, not sales. And I look to the forms committee and the experts there to tell me what have been issues and what they think should be changed. So from my point of view, I like having the forms committee because that is not my area of expertise. I like them doing it. I can review it. We can still have stakeholder input. We can decide, but I personally like having that process because I wouldn't know what to tell you to change.
May I ask a quick question? I'm sorry, Marcia. I just had a quick question because I thought that it's going to be the same process, right? That we did this year. Am I missing?
And you have done this for several years. The part is that you are directing us based on the global list, what to move forward and work on. You're not getting into the granular part of the drafting of the language. You're telling us, go forward and work on these forms based on the suggestions on the global list.
Okay, I got scared for a minute.
Okay, that's because what you said is we're supposed to tell you what we want changed. And it was like
that sounds a little better. Or better.
Historically, how many meetings per year did the forms committee have?
It would depend on the amount of legislation, but there was usually maybe four or five.
I'm sympathetic to some of the issues that you had for sure. But I'm just going to read from some of my notes that I had put together as I've been reviewing this issue. But, I know that for decades there's been a forms committee, and I was pleased because it was comprised of real estate practitioners from residential, commercial, property management, development, real estate attorneys that are specialists in these areas. And they have a really in-depth day-to-day boots on the ground knowledge of how these transactions work that I think is so very important. And you can correct me if I'm wrong, but it's my understanding that the meetings were regularly scheduled. Participants had time to present, review, dissect, gather feedback, brainstorm, debate, and collaborate. And very important to me, because I am located in a rural area, it had representatives from all over the state. It had urban areas, rural areas, large brokerages and smaller brokerages, making sure issues that concern consumers in all of these areas were not overlooked. I really feel if we lose this forum, we may lose a tremendous amount of detail and statewide consumer protections. As a commissioner, I had the expectation that before we moved forward with form changes, there was an assurance that each change had been debated, reviewed, and collaborated on by a larger group of industry professionals. So this is an extremely important part of licensees' day-to-day and a consumer's ability to have protection in their contract documents. So even though someone has an opportunity to publicly state their point in 3 minutes and submit it as well in writing, the committee discussion on these topics, the back and forth, and the further pencil sharpening to make it just right, that is what a committee like the Forms Committee does. And I think that that is very important. We would be missing that aspect of it if we dismantle that. So I really would like to continue the formal committee, understanding that there are issues that need to be addressed. We can add the stakeholder portion into that and continue to get feedback in that way. But I just would hate to dismantle that committee entirely. And I know we're not talking about doing it entirely, but I would not want to only do it the way we've done it this last year.
So Commissioner Doyle, have you watched the past recordings of the Forms Committee prior to this past year?
I did not, no.
So it isn't, I will tell you, there's a handful of active participants and there's a majority that is not very engaged as far as kind of moving forward different changes to those forms. So it's a handful versus, I mean, it's a 20 people out of over 51,000 real estate brokers is not really an accurate depiction of the industry, but all 20 of those were not always actively engaged. We did start recording those meetings several years ago so that the public is able to see them. But it wasn't quite the enlightened conversation that you have represented.
Okay, well, that's fair because I did not see those meetings. That has just been my understanding over the years of people that cross over the mountains, drive to make those. And now with being able to do them via Zoom, the input would be very important from the outlying areas if they're not able to attend and give more feedback than just 3 minutes on in-depth, detailed reasons why you might or might not want something. It's just my opinion on that I would like to be,
So I don't know that we could restrict them to 3 minutes, but this would definitely give them an opportunity to have a broader representation than maybe one broker from Grand Junction. We would get to hear from brokers that work in the resort areas, northwestern Colorado. I mean, you've also got the Eastern Plains. I don't recall anybody serving on the Forms Committee from northeastern Colorado. We would be hoping for a diverse group of practitioners to engage. And we're not saying that the existing members wouldn't be able to participate in the stakeholder process. I just think that this new process may build in some more efficiencies, some expert perspectives from practitioners that deal with a lot of consumer-focused issues, and then allow the broader industry to be able to participate in this process rather than just 20 people.
Yeah. And I wouldn't eliminate the stakeholder process. I would have that in addition to.
Yeah, I agree. And I think it's important to have a forms committee so that they can discuss. When we're only doing stakeholder input, somebody's getting 3 minutes and they're saying something, but there's no discussion. It's not like they're in a meeting and they're discussing pros and cons or verbiage. I think the discussion is what's really important. And I think that the committee, the forms committee, does that. They're meeting and discussing. So I think we could do both. We could have the forms committee, but we could also have stakeholder input. But I don't want just, I mean, we just did stakeholder input on this last stuff and we're just listening. People are just talking, but there's no active discussion and input and coming up with solutions. So I think the committee is actually very important for that.
Well, and the aspect I really liked about this is being able to kind of go outside of that committee a little bit and get that expert opinion. It sounds to me, and maybe you can clarify at least the way I'm envisioning this, which is kind of how it happened this year, is that, for example, Melissa did a lot of the, and maybe her team did a lot of the forms, and then from there, it would go to stakeholder, and then from there come to us. Is that the process?
This past year, we met with the forms committee twice. The challenges were they gave us direction to do changes at the first meeting, and then the second meeting totally reversed what they wanted done from the first meeting. So basically, we have 2 meetings, we accomplished nothing. We had questions about water issues on the seller's property disclosure. We sought out a water law attorney who's an expert in that area, and she represents consumers post-closing that have issues regarding water because it wasn't appropriately addressed during the transaction. She was a wealth of information. It was a little challenging because we brought her feedback back and the chair and vice chair kind of poo-pooed the information that she gave us. She was an expert though in water law. We sought out an expert about manufactured home lending. 2 different mortgage loan originators. They also were a wealth of information about that. I just think that you've got a forms committee. Some of those people have served on there since 1978. There needs to be kind of some fresh industry perspective, and it can't just be strictly from attorneys that represent real estate brokers and the industry perspective. We need to have some broader opinions on there. And like I said, they don't all participate in discussions.
Can we get some new people? If there are people who are participating, can we get some new people onto the committee? So we are doing something that's more diverse. So we have the committee and then we can also do stakeholder. We can do kind of a hybrid or a combination. So we've got discussion plus we have input.
So I think that even the stakeholder process can be more collaborative where there's back and forth. This time around, when we did the stakeholder engagement with the rulemaking, it was just to hear the industry opinions because several of them have been listening to these meetings. And I will tell you, we had a mix. There were 40 people that spoke at that stakeholder meeting. Some of them had to deal with the continuing education. It was enlightening how they were viewing the proposed changes. That was helpful to us. With the 6.17, 6.27 issues, nobody offered any solutions. So when you don't offer any solutions, I don't know how we can have a collaborative approach. Now with the forms, we would like to have a collaborative approach as far as what do you want to see changed and why. But you would be giving us the direction of, okay, this year work on the brokerage disclosures or whatever forms you pick out. And then we would be making this a more inclusive process rather than a hand-selected group of 20 people, some of which don't participate.
Well, my position kind of remains the same. I'm open to try a different approach with regard to how this was kind of laid out to us.
And this doesn't mean like, okay, we change it. Doesn't mean it's set in stone forever. We could change that again. It could come back up for discussion and see. I don't know.
If it doesn't work, then obviously
we tried it and
yeah.
Well, so why can't we combine them? Why can't we do a committee plus stakeholder and we get the best of both worlds? We get all that input. So why can't we do?
It's possible. I guess what I'm hearing from those that deal with it is it hasn't been as helpful. So I think the idea is just to try to see if this would be more helpful.
We get new people on the committee. We can get new people, replace people. It doesn't have to be people that have been there forever. We can do different people.
It would have been really, really nice if we still have 100 people on right now, but they were, listening to this to be able to want to be on these committees and do stuff, get involved.
Well, and that's kind of the point that I think too, is to your point, making sure that the stakeholders can be involved and have a say. Because again, I think those are the people out there doing the work. They're seeing the holes, they're seeing the problems. The people that are practicing. Not to say that people on that committee weren't, right?
Yeah.
But I definitely like the idea of actual stakeholders being involved. I like the idea that it's going to give an opportunity from everybody in Colorado, not just certain areas in Colorado. So what do we need to do though? I guess I will be honest, for some of these policies, I'm kind of confused on like what we do. So like, are we motioning for this to
It would be a motion to change the process.
change the process? Okay. Well, I'll just go ahead and throw, unless there's any more, well, I'll do the motion and we can have further discussion. But motion to approve the policy change as presented.
Well, second.
Any discussion?
I think we should do a combination. I think we should do a forms committee and stakeholder input to get the best of both worlds. I think we should do a combination.
Well, the motion on the table though is
I
accepted as
understand you asked
presented.
for discussion. I'm giving you discussion.
Right, but
I don't support the motion.
there you go.
So you've got a motion and a second. If there's no further discussion, you can take a vote.
So all in favor?
Aye.
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 Opposed?
Aye.
Aye.
So that passes.
All right, motion passes.
So next, commissioners, is the global list. And this is where you instruct us on what you want us to work on in 2026. I did notice that there was an error I wanted to flag for you. Based on the 5.3 issue that came up this year, we do need to look at the brokerage disclosure forms for 2026. It had been put in as 2027, which was my error, but we need to look at those in 2026 because the informed consent waiver language is in those forms, and that needs to be changed. But it's really up to you what else you would like us to work on.
I actually have some notes on this. I actually wanted to, I really want to make a motion that we table this, and I want to kind of understand what effect that would have if we table it for the next meeting. The reality is there's a ton of recommendations on that list. It was very lengthy, and really I had to focus on hearings and complaints and 6.17 and 6.27 that I really didn't put a whole lot of energy and time into this, but I think it deserves that. So I would like to motion that we table this for the next meeting.
Second.
Yeah.
Any discussion? Did anyone have a chance to really go through it?
I went through it and I have, some notes on quite a few of these, but I am more than happy to move this to the next one if we're able to, because we have a very long agenda still ahead of us.
Mhm. Okay, well, I guess we could take a vote. All in favor?
Aye.
Aye. Opposed? So moved. Motion passes. Thank you. I appreciate that.
So commissioners, Policy matter C was brought up in public comments last meeting, and it was voiced about concerns of brokers representing broker commissions as concessions in the MLS, and how that's not appropriate. We put it on your agenda. I did try to find an article that kind of speaks to this. I think the concessions really kind of coincide with property related issues that would benefit the buyer versus the commission is payment of the broker's compensation. But this is for you all to discuss.
Yeah, when I was kind of confused because I saw the art, but I just didn't really know. So the concern is agents using compensation, using the
Concessions.
concessions to address compensation.
I think the bigger issue is that they're trying to circumvent the requirements of the NAR settlement agreement, where broker compensations aren't supposed to appear in the MLS or other property databases.
And so they're putting I guess I'm trying to understand the issue. They're putting the compensation under concessions.
Correct.
And masking it to make it appear it's a concession, but really it's just a way to secretly disclose the compensation.
Correct.
Okay, so we just say, don't do it. I'm not sure what we have over that. I don't know that we have control of the MLS to do anything about that. We can say, don't do it, but that's not something we normally would discipline, is it?
Well, I think maybe what that licensee was requesting was just some guidance, whether it be in one of our bi-monthly publications or in a newsletter article, kind of put the industry on alert that a real estate broker commission is not the same as a concession.
I mean, I think the broker community knows that it's not a concession. I think that the people that are doing that are trying to like circumvent the system, as you said, and just trying to kind of sneak it in there, which is against the MLS rules for sure. Maybe it could be a mention that it's against most MLS rules. I don't know. How does that pertain to what we can discipline for?
Well, Marcia could write an article and put an article in the newsletter addressing it.
But are we able to even discipline for something like that?
Well, you don't enforce MLS rules.
Right. That's what I mean. So this is really, yeah. Article sounds fine. I don't think in the article though, we need to explain the difference because the broker community knows the difference.
Well, and
I
really,
think that
the MLSs are handling this. The MLSs are doing the discipline. It's against the MLS that's the issue. And the NAR, they're going after the MLSs that I don't know why we're involved, why we would be involved, and why we would do an article on this versus some of the other things we could do articles on.
There is a appraiser component, and we do regulate appraisers. It's a separate board, but if you are misrepresenting something as a seller concession, the way that an appraiser does adjustments for seller concessions is dollar for dollar. So if you misrepresent something and they can't catch that it's the real estate broker commission versus a seller concession for carpet allowance, that could have an impact on a value conclusion.
Okay.
I think it doesn't really hurt to throw it in the newsletter. As long as division staff has the time and the willingness to do it.
We can do that.
It doesn't hurt to tell people, even though they know.
They know.
You gotta repeat yourself, but if in the end it affects appraisers or value or something, then it's something that I guess it's got to be saying, hey, it's been acknowledged, like we see this. it's a no-no. You know it's a no-no. Don't be trying to use this little gray area over here to try to, you know, I guess get what you want, or I don't know how you put that.
Okay, so Marcia, you can do an article then, and we can move on to D.
Yes.
Do we need to make a motion or we just talk about it and do we need a motion on
we're
that
good.
one?
You know,
Let's
you're not
go.
really doing any action. It's just a fun
Okay.
task for me. So
Okay.
your next item was also raised at the October meeting, and you had asked that it be placed on your agenda for today. This was the issue of basically sellers directing brokers to misrepresent sales price in marketing materials, knowing that that lower sales price was not going to be accepted by the seller. It was more to generate interest. But like if you list a property for $1 and you get an offer for $1, that seller was not going to accept it.
Yeah.
From our standpoint, from the broker that's actively knowingly doing this, I think that represents possibly a violation of the license law for misrepresentation in marketing. But we had suggested that this be brought to you to get your opinion on it.
Because it was the homeowners or the sellers that were trying to encourage this behavior.
Yeah, and we have to say no.
Yeah.
Trust me, I have had sellers ask me to do a whole lot of interesting things. And I have no problem telling them, no, my livelihood is not worth this. And so I think I'm happy. I think that we can address it on to some extent, or do we need to? Because reality is, if a complaint was filed, it's possible that the commission is gonna discipline that broker for misrepresentation, irregardless if the seller told them to do it. The sellers will tell you to do a lot of stuff that we just cannot do. And a lot of times they don't know our barriers, our boundaries. So, but we have to be the professionals that can have those intelligent conversations and explain to the sellers or buyers what our limitations are, because we have a lot of limitations and restrictions and regulations that we have to navigate, and we have to be the ones to communicate those things over. So I don't know if it has to be, I love that they pointed it out. I don't know that we need to, I mean, I think it would be a great topic, for example, for like an annual update, right? Like I think it'd be a great topic for an annual update. But I don't know that we need to like recreate anything or
I don't
do
think we need to
anything.
create anything. If somebody does it, they can get in trouble for it. And so if
Yeah.
it's happening, they can bring it. Otherwise, we deal with it when we see it.
Because it definitely, I think, I agree that it falls under dishonest dealings in marketing.
Yeah, you can't do that in a banking setting. Yeah, you can't, try to get people all interested and then do a bait and switch on
Bait
them.
and switch.
And yeah, and so, then you've actually got people that are only qualifying in that price range. And the truth is then you have got a broker that's taking time and doing all of this extra work for no reason. That's like no broker wants to go show a house, show properties that the buyer doesn't qualify for, and take people's time. I mean, they don't have a chance for the house anyway. So I think the uh I think the broker shouldn't even approach that. I think the broker automatically should say, "Hey, that's, we can't do that. It's not just frowned upon, but it's not, it's dishonest."
Yeah.
So,
And and it does happen. I mean, I had that happen to myself and a client, where in this case it was a builder that would go in and lower the price, get y'all interested, and we go to sign the contract, and oh my gosh, the price went up. And they did that multiple times where we caught it. And it resulted in my buyer getting a very good deal on a home. But the reality is that does happen. And so I think it would be a good idea just to put it in front of people. I don't know that we have to do anything in terms of rules because the rules are already there, but we just put it in front of people so that they kind of know that's not an okay thing to do.
So we can include it in the ACU for next year.
Okay.
Not the one that's getting ready to be released, but the one that we put together in 2026.
Okay.
Okay, aside from CB 22 and CB 31 and the global list, are there any other items that you would like placed on your agenda for your next meeting?
Nope.
Okay. So I wanted, leading into complaint matters, Sarah Holleran is now the deputy director. Garrett left us to go work for a different state agency. So congratulations to Sarah, and Eddie will lead it off with his complaint matters.
All right. Good afternoon, commissioners. Okay. Your first complaint matter is audit number X 2025-79. The division received a consumer call raising questions about a transaction involving a named employing broker. The consumer was suspicious of the transaction because the broker's website had contradicting information. Unusual fees were requested, and his conversations with the broker raised concerns. The caller did not file a complaint, but the division opened an audit to review the operation of the employing broker named on the suspicious website. The audit determined the broker is not involved in the timeshare scam. However, the broker failed to comply with audit requirements by not providing all requested documentation during the audit process. Possible violations include 12-10-2171M, violation of any commission rule. Rule 6.25C must produce records for audit. Recommended discipline action includes diversion, $1,000 fine, coursework in brokerage administration, coursework in ethics, and a follow-up audit within 3 months. And you can ask myself or Auditor Andrew or any questions you may have.
Now, if I recall correctly, the respondent says he really doesn't do too much of the on the broker side, but he does something more, I guess, on the commercial lending side on that. Do we have any idea how many transactions he's even done in the past year?
I don't believe he did any actual transactions in the last year. I'd have to double check that. If he did, it was very small. He represented it as basically he does work on the other side, like you said, and then he'll do some referrals.
Okay.
Anybody have a motion?
I move to accept staff recommendation.
Do we have a second? Who seconded? Oh, Erica. Okay. All right. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Good afternoon. Matter B is complaint number 2025-352 et al. There are a total of 11. The division received multiple complaints totaling 11 from complainants regarding the respondent's brokerage. The respondent performs property management activities and has received allegations of misappropriation of rental proceeds to the complainants. The respondent acknowledged that he does not recall when the trust accounts were reconciled and provided a security deposit ledger that shows the total security deposit liabilities are $73,617.50. The respondent controls approximately $1,037,813.72 in the rental trust account, which is commingled with other brokerage funds. The respondent believes that he owes around $100,000 to owners and tenants being held in the trust account. Possible violations include 1210-217-1H, 1210-217-1I, 1210-217-1M, 1210-217-1Q, 1210-217-1R, 1210-217-1W, 1210-4041C, Rule 6.2, Rule 6.3, Rule 5.2, Rule 5.5, Rule 5.9, Rule 5.10, and Rule 5.14. And just a note that the respondent's license did show as active as of today. Disciplinary recommendations include public censure, final agency order, revocation, and a fine of $357,500 or max fine for 11 complaints. And investigator Geske can answer any questions that you may have.
I was just curious, is this also being referred to the Attorney General's office?
Yes.
Remind me, because I thought I wrote this down. This respondent closed that down and now does insurance. Am I right? Or am I thinking of something different?
No, you're correct, but he has always done insurance as well and has been licensed in both Colorado and Texas for real estate, but insurance as well.
Yeah, this was a very interesting situation. It seemed like maybe there's some memory stuff going on. It, kind of seemed that way, and I don't know, but clearly with the money that is owed, there's a lot of harm here. So I agree with the recommended discipline.
You want to make a motion then?
Yep. Motion to approve the disciplinary recommendations as presented.
Do we have a second?
I second that. One more question though. Is his license being looked at on the insurance side?
Let's see. I know that 2 of the cases were presented to you at the last meeting, and I'm not sure if that has happened yet. I'm not sure if Penny might be able to speak towards that. Otherwise, we can definitely refer it to the Division of Insurance.
They'll get notified as well of his revocation on this, so they'll be taking a look at this too. I'm guessing, correct?
I'm not sure if they will be, but I think we can refer it over to the Division of Insurance just to make sure that they're aware of it.
Okay. Yeah.
Sorry, my computer's locking up and I can't seem to access it, but I don't believe that we have a settlement. But yes, I think that, as Nicole said, we can actively go ahead and notify the Division of Insurance of our process.
Okay, so any further discussion? All right, so we have a first and a second. All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Okay. Investigative matter C is complaint number 2025-649. The investigation noted that the respondent did not properly draft or use compliant property management documents. Possible license law and violations were observed with the respondent's property management agreement, lease agreement, and the use of several outdated commission-approved forms. Possible violations include 1210-217-1Q, 1210-217-1M, 7.1 and 6.3, Rule 7.1, Rule 6.3. Disciplinary recommendations are coursework in brokerage administration, coursework in contracts, and diversion and a fine of $1,000. And again, Investigator Geske can help answer any questions.
I move to accept staff recommendation.
Hold on. We've got coursework and contracts. This is a property management one. I think we should have coursework and property management instead of coursework and contracts.
All right, so I'll modify. I move to accept staff recommendation with the revision of coursework from contracts to property management.
But he was using outdated forms.
But the forms were all tied to property management. There was the PMA and the lease and the brokerage duties and et cetera. So it's all property management forms.
And I don't know if I mean, you can always add property management in addition to contracts, or I'm not sure how much he'll get on those specific forms if it's not considered contracts.
I would change it to property management, not contracts myself, but.
Okay.
I agree with that.
The motion's out there. Any seconds?
Did you wait, just for formality, did you re-motion?
I did.
Yeah.
Okay.
Okay, any further discussion? All those in favor?
Aye.
Aye.
Okay, motion passes.
Investigative matter D is complaint number 2025-1340. The investigation confirmed that the complainants claimed that the respondent failed to provide mandatory disclosure documents to the complainant's buyers. The investigation also found that the respondent missed several deadlines, jeopardizing his seller and the buyer's interests. Furthermore, the respondent did not provide the Division of Real Estate with the required transaction documents. Possible violations include 1210-217-1M, 1210-217-1Q, Rule 5.21, Rule 6.2, 6.11, 6.24, 6.14D. Disciplinary recommendations are coursework in brokerage relationships, coursework in contracts, public censure, a final agency order, and a fine of $2,000. Investigator Gabarty can help answer any questions that you may have.
I think the only thing I would add to this is a coursework in ethics.
I have a note on here. Hold on, let me see. How many transactions does he do a year? Do we have any idea?
Uncertain. He wouldn't speak with me.
That's the one I was thinking. This is the one who didn't want to speak, have anything, and yeah. I thought the fine needed to be increased. And so when his license lapses, because I want to say it looks like it would lapse a couple different times and then he reinstates it. Is there any requirement for anything when he reinstates his license? Like, is there any type of coursework? Is there anything in there from when his license lapses? Because if I recall correctly, one was like a year or something like that.
I'm uncertain of that. So his license expires the end of 26. When he renews at the end of 26, he'll have to, I believe it's certify that he has taken all the continuing education to be able to renew his license. Is that what you're asking?
Yeah, okay. I felt like the fine should be higher. I don't think he complied with anything that you were asking for. Didn't wasn't definitely wasn't willing to work with the other broker through any of this. Really didn't want to work with anybody.
What do you
And
recommend for the fine?
still didn't disclose that he was related to the seller. I think yeah.
And he was
And he wanted to
signing
make his own
documents.
rules.
He was signing documents on behalf of the seller too, without.
Yeah, that was another thing I looked at that isn't that considered fraud?
No, in speaking with the seller, who he is related to, the seller did say that he did give the respondent authorization to sign on his behalf. So he was completely aware that the respondent was signing his documents.
And it was his brother, correct?
Correct.
Okay.
Did you have a recommendation for the fine, Bernadette?
Is there is there like certain amounts that I have to go by?
You can do $2,500 per, so you can increase it if you want. We got lots of room. What are you looking for?
I would go higher I guess the 2,500 on that.
Well, it's $2,500 per. I mean, you could go a lot higher. So is that all you want is 2,500?
If we could go higher, then go higher with it.
Okay, what are you looking for?
So 2,500 per.
Okay.
Because I don't know. I feel like we're doing this for a reason, and he wasn't willing to do even work with the investigator. I just
I agree with you, Bernadette. I mean, he was very dismissive of the regulations requirements for his license. He's had a previous CE audit where he was non-compliant, if I recall correctly on that. I'm supportive of that.
I just felt like it was just he wanted to make his own rules and had no regard for authority at all.
Okay.
You want to go 5,000?
Yeah, let's throw something.
5,000. Let's do that.
Can we throw coursework and ethics on there as well?
Yep. Someone want to make a motion?
I'll make a motion to accept staff recommendations with the revisions of adding additional coursework and ethics and increasing fine to $2,500 per violation for a total of 5,000.
No, there are a lot more violations than that. So just say the fine of increase the fine to 5,000.
Okay, increase the fine to 5,000. Sorry, I thought it was each violation and then the rules were a separate thing.
No, those are violations too.
Okay.
Okay, do we have a second?
Second.
All right. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Investigative matter E is complaint number 2025-195. The investigation revealed that the respondent provided real estate services for a transaction that subsequently closed, despite his license being expired at the time and his brokerage relationship with the buyer no longer in effect. Possible violations include 1210-217-1M, Rule 6.10C, and Rule 6.26. Disciplinary recommendations are coursework and contracts, a coursework and brokerage relationships, diversion, and a fine of $500. And investigator Gobardi can still answer any questions.
Okay, any discussion?
My only comment, I always, when we get these cases where people are practicing without a license, it just bothers me. And I usually want to see that fine a little bit higher because that's yeah, that's not okay. So I would recommend a higher fine of at least $1,000, which isn't that much higher, but.
He's been in business. He and his wife own the company, been in business a long time. He knows that the license isn't automatically renewed with dues. So that was a line. So I would say to increase the fine more. About 2,000.
Now this was the one, it had lapsed for 4 days?
No, it had lapsed for much longer than that.
2.5 months.
Oh.
Yeah. And, the thing is we're required to maintain our license and all that's involved with that.
Well, also using very old forms, not using current forms. So we've got multiple things going on that shouldn't be happening with someone who's been licensed as long as this person. So anyone want to make a motion? I think we should increase the fine to 2,000.
Move to accept staff recommendations with the modification of increasing the fine from 500 to 2,000.
We have a second?
Second.
Okay, any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Investigative matter F is complaint number 2024-28. The complaint alleged that the respondent purchased and assisted family members in purchasing investment properties under the guise of primary residence to secure favorable interest rates and lending terms reserved for owner occupants. The investigation found that several properties were purchased by the respondent or with the assistance of the respondent as primary residence, even though executed lease agreements were secured prior to the closing. Possible violations include 1210-217-1M, 1210-217-1Q, 1210-217-1C, 1210-217-1W, and Rule 6.20. Disciplinary recommendations are public censure, a final agency order, revocation, referral to law enforcement agency, referral to the Board of Mortgage Loan Originators for investigation, and a fine of $50,000 or max fines for 5 transactions. Investigator Peters can help answer any questions that you might have.
Yeah, this was an interesting one, but I agree with the recommendation, so I can motion to approve the disciplinary recommendations as presented.
Do we have a second?
I'll second.
Any further discussion?
I wanted to believe that it wasn't all like this, but looking at the dates and looking at that, got to agree with it. And so I'm in for it too. I agree with the.
Okay. All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
Commissioners, complaint matter G are case numbers 2025-1120 and 2025-1434. This was an investigation conducted by Rob Walker. He is here to answer any questions that you have. So these cases were combined because their allegations and the respondent were the same. Both complainants alleged that the respondent altered a commission disbursement agreement and fraudulently submitted it to Homestead Title and Escrow for a transaction closing. The respondent has vehemently denied the allegations despite what appears to be supporting evidence provided by the complainants. The disbursement agreement that the respondent sent to the title company had the same ID number that had been used on one of her previous transactions, and it also authorized the entire $9,800 commission to be disbursed to the respondent without including a Zillow referral fee or the brokerage firm's commission split. Also, both complainants provided metadata evidence that indicated the disbursement agreement provided by the respondent was created and modified 3 months after it was allegedly downloaded by the respondent. Possible violations include 12-10-217-1C, deliberate misrepresentation or false promise, 12-10-217-1Q, unworthy or incompetent practice, 12-10-217-1W, dishonest dealing. The recommendation is for a final agency order with public censure, revocation, and a fine of up to $7,500 or maximum fines. And like I said, the investigator is here to answer any questions that you have.
How long did we say? How long has she had her license? Wasn't it like 20 years?
I believe it was for a considerable length of time. My computer also was having issues, so I can't look at that up at the moment.
I kind of feel like somebody that's been in this business for that long, I don't know, like something there. She's not going to throw her whole career away, I think, on $9,000 and less than that because she sent the Zillow out. I don't know. I feel like there's more to this that we just like what she states in her story that it wasn't her. I don't know why. I mean, everything shows different. I don't know the system that they do. Anybody else know? Can any of that? Can somebody else have done that? I mean, I don't know.
I don't know their system, but just based on what was presented, she was a Keller Williams agent, and Keller Williams, I think all of them must have systems in place that when you submitted a disbursement authorization, it assigns a very unique, specific code or number. And so through the investigation, it was determined that the number that was on the fraudulent disbursement authorization was the same number that was on a previous disbursement authorization on her last or a previous closing. I don't know if it's her last closing, on a previous closing. And Her office testified, I believe it's her office, or someone from her office testified that that is not possible, that their system doesn't regenerate the same number.
Yep.
And then they also produced the actual disbursement authorization, which had a unique number. So I think unfortunately it was intentional.
And Erica, in addition to that, wasn't she either was terminated or self-terminated her employment?
Yes.
So,
Yep.
yes, this seemed like it was malicious to me.
Yeah, she had self-terminated, I think before.
Yes, maybe 3 days before.
Before, yeah.
And I
And
think that's exactly why the ID numbers match from the transaction, the correct transaction from 30 days prior.
and what I do know, because I once many about 20 years ago, was a Keller Williams employee or agent, not really employee. But what I do know is that they're based on what we saw in her disbursement authorization, if nothing else, there should have been some sort of split. And it was just kind of, I think that's what red flagged it, really. It's like one has all these splits, including your office, and then the other has no splits. It just was suspicious. And so I believe that this was fraudulent.
So, do you want to make a motion?
My only consideration is if the fine was hefty enough.
Well, it comes with revocation.
Okay.
The
Yeah, I
fine
guess so.
can't be any higher. At $2,500 a piece, there's 3 of them, so that
Gotcha.
fine is 7,500.
Understood.
So, someone want to make a motion?
I'll move to accept staff recommendation.
Okay, is there a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Complaint matter H is case number 2025-1167. It was alleged that the respondent affixed the digital signature of a client on an earnest money release form without her knowledge or consent. The evidence appeared to corroborate this allegation. There was a certificate of completion that indicated the seller's signature was affixed to the document in or around Paris, France on April 26th of 2025. The respondent was in Europe and in her response letter stated did not recall signing the document, but stated that it may have been executed unintentionally. The seller, whose name was affixed to the document, informed the complainant in an April 29th email that she was unable to access the form, nor did she sign it. She was most likely unable to access the earnest money release form because it had already been executed and uploaded into the e-contract system on April 28th of 2025. Possible violations include 12-10-2117-1C, deliberate misrepresentation, false promise, 12-10-2171Q, unworthy incompetent practice, 12-10-2171W, dishonest dealing. The recommended discipline is a final agency order, public censure, revocation, and a fine of $7,500 or max fines. And Robert Walker is the investigator. He's here to answer any questions that you may have.
I was eager to get your thoughts on this. I have my own hypothesis.
Is it possible, like at all, that it was accidental? I mean, is there any chance?
You have to go into software in order to sign this, so probably not.
I mean, if I was in Paris, I know she had another person designated as a signee to cover while she was on vacation. I don't know if she went in there, maybe inebriated and doesn't remember.
Yeah, that's true.
That was what I thought.
I thought she actually admitted that she did it somewhere in the investigation too.
Well, and let's see, wasn't it, I guess this was the one thing, and I'm trying to remember some of the details here. Wasn't it, her client was a seller, right?
Yes.
And the seller was releasing earnest money to the buyer. Is that right?
Yes.
Okay. So I guess my perspective, I don't know how this happened and it could have been intentional. I don't know, but I didn't I don't see her doing that Like there was no benefit for her to give the buyer the earnest money back, if that makes sense. There's no benefit to you know, or the sell, how I'm saying this all wrong. There's wasn't a benefit for the seller to sign that. Like she wouldn't benefit from that, I guess. Which makes me think it might have been an error, but I don't know how you make that error. Because there's 3 steps to sign a contract. If it was the buyer's agent that had done it, clearly there would have been clear motive as to why you would sign to give the buyer their money, their earnest money back. So I don't know. I think maybe it was unintentional somehow. Doesn't mean that it didn't happen and it shouldn't be disciplined, but I just wanted to kind of speak to that the benefit would have been more if she was on the buyer agent side to her. So that makes me think that maybe it was some sort of mistake. And I know that this contract software, if I'm honest, is problematic in general because it does allow people to sign when they are not the designated signer. Um, and this kind of speaks to, and mistakes can happen. It didn't seem like the seller was like super offended by it. And I think it should be disciplined. I just maybe am questioning the revocation side of it. I think something strong, maybe like a suspension, but I don't know if revocation is the right way to go.
I I think she signed it somehow intentional. I wouldn't revoke the license, but she should take courses in contracts and ethics. Um, and if she did do something, I think maybe, her back and forth is that maybe she got scared and eventually hid what she did. That's why I thought ethics. I said the fine was okay, but I wouldn't revoke her license on it.
Investigator Walker, can you let us know, and I apologize, I could pull up the file if needed, but what were there any other in her past years as operating as a broker, were there any other discussions?
She
I
had,
don't believe there was anything else. There was, I think, a probationary period when she first got her license, but I think that that had passed. So there's nothing prior issues with
Okay.
the
wasn't there
division.
something going on though with retaliation at the company of complaints and things? I thought there was something going on with that as well.
Yeah, I think that's something that she brought up because as soon as she got back in the office, she was fired. So I think she said that there's some retaliation on behalf of the management of her former company.
And I didn't really buy that because she was in France. Like
It appeared
she
she was the only one.
she signed it. Like
France.
she did sign it, right? It says she was in Europe. The IP address was in France. She somehow signed it. I don't know if it was by accident. I don't see the benefit of her signing it again, but which is why Lena, maybe it was some sort of error. But
Wasn't
I
she
would suggest a either probation or suspension.
wasn't she terminated from the company because of this issue?
Yeah, the complainant, who was also the owner of the company, said there were some issues, but this was the deciding factor in her being terminated. And I asked him if they were any sort of regulatory or issues with statutes or things like that. He said no, it was more kind of internal business decisions rather than, any
Regulatory.
legal issues.
Well, I agree with my fellow commissioners. I think revocation is maybe a little too much. I'm leaning more towards, I don't know, you said suspension or what was the other option?
Probation or suspension.
Probation.
Probation doesn't really do anything.
Yeah, I'm saying probably suspension though, because probation probably wouldn't be most appropriate in this situation.
What is the suspension term? What is it, like 3 months?
You can do more than that if you want.
Like 3 to 6 months, probably. I know anything beyond that seems,
And Bernadette, what were your recommendations for coursework?
Um,
Contracts and ethics.
Contracts and ethics, so that she can learn how to use those contracts, go over that, know it really well. And ethics, if it was that she did it on purpose, on accident, on if she got scared, lied, something like that. I would think those, I wouldn't be opposed to the suspension.
Do you
Okay.
think, I mean, I'm gonna be honest with you, suspension, I think, this is my problem with that. A 3-month suspension, this is such a slow time, right? Yeah, people could maybe not even feel that
Yeah.
in this market, right? Like a 3-month suspension. So I don't know. I think
I
it
was
needs to be a
thinking
little bit
6.
more than 3 months for sure, because again, 3 months in this market, it would be like nothing.
Especially over the holidays. So I was thinking 6.
Yeah, I agree with that.
Okay, I'm gonna go ahead and make a motion. A motion to approve staff recommendations with the exception of modifying revocation to a 6-month suspension and the addition of coursework in ethics and contracts.
Is there a second?
Second.
Second, sorry.
Okay, any further discussion? All those in favor?
Aye.
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 Any opposed? Okay, motion passes.
Righty, investigative matter I is complaint number 2025-1277, or that is the initial complaint. There were several other complaint numbers with this one as well. The respondent was a partner in a property management company that was formed in 2018. The initial complainant, the respondent's partner in the property management company, alleges that the respondent stole rents and security deposits in an amount upwards of $1 million. There are 19 total complainants, and all alleging various amounts of theft of rents and security deposits. Possible violations are 1210-217-1C, 1210-217-1H, 1210-217-1I, 1210-217-1M, 1210-217-1Q. And then there is a second page to this referral that I'm not sure supported along, but the violations do continue. So additional possible violations are 1210-217-1T, 1210-217-1W, 1210-404-1B, and then an additional violation of 1210-404-1B for failure to account in a timely manner for money received. The rules violations are Rule 5.2, 5.5, 5.9, 5.10, 5.21, 6.3B6, and Rule 6.25. Disciplinary recommendation is a final agency order, public censure, revocation, a fine of $712,000 and $712,500. And Investigator Riquet is here to answer any questions you may have.
Just a quick question. Is this one also being referred to the Attorney General? Just because I didn't see any notes about it, but obviously
It's a criminal case, it said.
It's been referred criminally, yes.
Okay. Well, I motion to accept the disciplinary recommendations as presented.
I second that.
Okay, any further discussion? All right.
I don't think we have words. It was a lot.
All those in favor?
Aye.
Any opposed? Motion passes.
Okay, item J, I will be recusing myself due to possible actual or perceived conflict. So if someone will just let me know when to come back, that'd be great.
Okay.
All right. Matter J is complaint number 2025-315.
The complainant purchased property which was listed by the respondent. The property had been under contract twice prior to the complainant's purchase. During the previous contract's inspection objection, the respondent received documentation from a septic company that there was an abandoned septic tank on the property, as well as a collapsed line in a second septic system. The respondent also received notice that there appeared to be a problem with access to a portion of the acreage conveyed with the sale. The respondent did not disclose the information from the previous transaction to the complainant during the complainant's purchase. Additionally, the respondent's license was inactive during a period of time when she was working on this transaction due to a lapse in her errors and omissions insurance. Possible violations are 1210-217-1M, 1210-217-1Q, 1210-404-1B, 1210-404-3A, Rule 6.26, and Rule 6.20. Disciplinary recommendation is a final agency order. Coursework in ethics, a fine of $5,000. And Investigator Hardy is here to answer any questions you may have.
Is there any discussion on this one?
Did this property sell?
Yes.
Was there a loss on it? From
Well,
what the buyer bought it for and what they had to sell it for?
I think so.
It hasn't sold subsequently.
Yeah,
No,
just sold the first time.
So it sold the first time, the first time, and so I looked at, because I did see it, they put some of the like what they had put it on the market for over how much time, and what they ended up buying it for, which I think was like 255,000, and then I didn't know if it had sold already and if they sold it for less than that 255.
I think they did have to, and forgive me if I'm forgetting, I didn't have that part of my notes out, but I thought, to your point, that they had to list it for way less because of the issue with the land. There's only a really small portion of land that is actually usable.
I think
Is that the part you're talking
like
about?
295. I think it was initially like at 295, and then they had to lower it to 255. And that's what the people that have it now, I think that's what they bought it for, was 255. But I wondered, since it's on the market, and they found out that that it was one of the people that originally put it under contract had and then backed out of it, was interested. That's how they found out about it. But I want to say I wondered if they sold it for less than the 255 that these buyers that the current owners have it for, if they had to take a loss on it. It kind of reminds me of the deception of one of the cases that we saw last meeting.
If I could just clarify, so the complainant purchased the property, then when they relisted it, they have it listed for more than they paid for it, but they have not sold it yet.
Okay, so they didn't take a monetary loss like that. The one from the last meeting, I think the people ended up having to take a monetary loss on the sale of the property.
Well, this one hasn't closed yet.
Right.
Yeah, this one hasn't, so we don't know.
Does anyone want to make a motion?
I would increase the fine on this one.
To what amount?
The 2,500 per, so that's what, 1, 2, 3, 4 of them.
Well, it's 6 of them.
Oh, because the other 2, okay.
But sometimes we don't do the first one, the part 4.
Actually 5.
So
usually max fines are come along with revocation, but
say that again.
Usually when we do max fines for every violation, that's on revocation cases historically, but to provide some context.
So if you want to increase it, we can increase it some, but probably not to the max. So do you have a dollar amount you want to do?
The 7,500 on that.
7,500? Okay. Okay, do you want to make a motion?
Yeah, motion to accept. There we go.
Staff
Motion to accept
recommendation.
staff recommendation with the amendment of increasing the fine to 7,500.
Okay, do we have a second?
Second.
All right, any further discussion? All right. Okay, all those in favor?
Aye.
Aye.
Any
Aye.
opposed? Okay, motion passes.
All right, investigative matter K is complaint number 2025-1318. On June 27th, 2025, the respondent was found guilty of stalking, emotional distress, in violation of 183602 CRS in Jefferson County, Colorado. The Division of Real Estate and the Colorado Real Estate Commission record of the conviction being reported by the respondent. Possible violations are 1210-217-1N, 1210-217-1P, 1210-217-1M, and Rule 6.23. Investigator Levy had to step away so I can try and answer any questions. We received an email this morning from the counsel of the respondent, and I just want to provide some quick updates. He said that the domestic violation evaluation has been completed October 16th. He has been in contact with probation and submitted a payment plan for the fines. Community service forms have been submitted, and the respondent's waiting to hear on where he will be placed. And he has completed all probation requirements to date. So just received that update this morning and wanted to pass it along.
My thoughts on this is if this particular gentleman poses a risk to public safety.
Let me see. This is the one he's on. Yeah, my notes were that his license should be, or wait, hold on. Make sure I'm on the right one.
Right.
Okay.
The stalking had to do
Yes, here it is.
with someone he knew. It wasn't just he was out roaming
Randomly.
around in it wasn't a public issue, it was a specific issue. So
my notes were that his license should be on probation with the probation.
I would agree with that.
I put that to accept the staff recommendation that it was an on again off again relationship that kept going back and forth, and he had a lot of letters of recommendation from people, and I put to accept staff recommendation on this one.
I agree.
He also didn't self-report. I put a little note about that.
Yeah, I saw that, and I think my understanding or my thought with that is that I think maybe it looked like he was waiting to find out because there were so many things that they were waiting on to figure out like what was going to happen with it, and so I feel like there was a little, maybe he didn't understand.
Well,
when
that's why the fine is 500, because normally
Yeah.
if it's something he was guilty of, it's 250. If he fails to report, then it's 500. So this is pretty standard with staff recommendation.
And when we do our, like, it's kind of similar to some of our other matters, like license matters. And we do generally, if they're on probation, what we tend to lean towards is making their license probation concurrent with their actual probation.
Yeah,
So
you're
since
right.
we typically do that, I would like to maybe just keep it consistent.
Okay,
Yeah,
you
that's
want
a
to
good
make,
catch. That should have been on there. So yes, I would include that in the motion.
okay, someone want to make a motion?
Yep, hold on one second. Okay. Motion to accept the disciplinary recommendations with the amendment what was it, 24 months?
Just to
Sorry,
make
hang on.
probation concurrent with licensed probation concurrent with his probation, criminal probation.
Okay. All right, so motion to approve staff recommendation to include probation concurrent with his, sorry, I can't even form a sentence anymore.
With his criminal probation.
So this, motion to approve disciplinary recommendation with the addition of probation to run concurrent with his criminal probation. Hopefully that.
Okay, is there a second?
I'll second.
All right, any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes. Okay, so we're now on to licensing matters.
Licensing matter A is an application, complaint number 2025-1912. On February 22nd of 2024, the applicant entered into a letter of reprimand with the New Mexico Real Estate Commission. The applicant was ordered to pay a $500 fine and complete 4 hours of coursework. All terms of the discipline have been completed. We do not have a recommendation as usual, and investigator Martinez can help answer any questions.
My concern with this is that it was a violent home invasion. Although I think it's been some time has passed.
I don't think you're on the wrong
That's
case.
the next one.
Oh.
Yeah.
You're on the wrong case. We're on polybutylene pipes.
Okay, let's go to that one.
Okay.
Okay.
So this one, there were not many recommendations and letters, and he wants to be an independent. I would say with having the past issues that I don't think I would approve him with as an independent. I would, if he wanted something, we could look at doing an associate. Thoughts?
Hang on, I'm trying to find my notes. So give me just 2 seconds. Sorry.
He's, is licensed, or he had stuff in New Mexico. Now he's looking at here. I think you should be under somebody so you can have direction and guidance on Colorado.
I agree with that. I agree with you.
So can we issue, as far as the license goes, can we approve it, but say that he needs to be an associate instead of independent? Are we able to
I
do
guess I
that?
missed that part somewhere in there. So yeah, I initially didn't catch that piece, but makes sense to me.
So are we able to do that? Are we able to approve an application, but say it has to be an associate broker?
With restrictions?
Yeah,
Yeah.
you could approve with restrictions and say, a high level of supervision for 2 years or whatever you'd like.
Okay.
Well, you gonna make that motion?
Okay, motion for an approval on the application with the restriction of an FA license with a high level of supervision for two years.
Second?
I'll second.
Okay, any discussion? All right, all those in favor?
Aye.
Aye.
Any opposed? All right. Motion passes. Now we're on to B.
Alrighty, licensing matter B is a preliminary advisory opinion. It's complaint number 2025-1266. On October 8th, 2014, the applicant was convicted of controlled substance possession, a class 4 drug felony. The applicant was sentenced to 4 years community corrections. This sentence was revoked and he was resentenced to 1 year at the Department of Corrections and a fine of $2,271.50. The applicant has completed the Department of Corrections sentence and has a $0 balance. The case is closed. On November 3rd, 2015, the applicant was convicted of a Class 3 felony robbery, aggravated possession of a real simulated weapon. The applicant was sentenced to 20 years Department of Corrections. That was vacated and then resentenced to 16 years with 271 days credit for time served and a fine of $511. The applicant has completed his Department of Corrections sentence and has paid the fine in full. The case is closed. On November 3rd, 2015, the applicant was convicted of burglary 1, assault menacing, a Class 3 felony. The applicant was sentenced to 4 years Department of Corrections. That was vacated, resentenced to 8 years with 197-day credit time served. All 3 of these cases run concurrent. And something I did want to clarify is that the applicant was paroled in April of 2024, and as of April 2025 has fully completed their sentence. Investigator Quintana is not here, but I can attempt to answer any questions.
The only concern I had obviously was the frequency of, there's a few things that happened, although nothing's happened in the last 10 years, I think.
Well, he was in jail.
Although he was still incarcerated, right? But
Yeah.
so, clearly nothing happened while he was incarcerated. But I guess the main concern I had was some of the types of offenses, like the robbery, wasn't there burglary? Yeah, burglary, robbery. Like those are very concerning for like industry stuff. And then the fact that he was just paroled recently. So it just felt like there hadn't been a ton of rehabilitation time. So that was really, I don't know how to get around that, but those were really my concern. It would be nice for him to have had a little bit of time for rehabilitation. But at the same time, I know I read all the personal statements and recommendation letters. So I don't know.
Is it possible to put some, I don't know, boundaries around a positive opinion with a time frame that at least 12 months need
He would have to do an application later. This is just a preliminary opinion.
I'm just wondering, like, if we can give him some framework of 12 months being back in the ability to make your own decisions, not being incarcerated, and if he can go 12 months without any major issues, we would lean towards a positive opinion.
So he was paroled in April of 2024. That's what, a year and a half ago.
So like in April 2026, it'll be 2
years.
years, which I think
which is like total of
feels
like
a little bit better. There's been a little bit more time. You can kind of demonstrate like I'm in a much better place. I kind of struggled with that one.
I struggled with it was some violent crimes. He's been incarcerated. It's been about a year and a half that he's been out, and he during his parole, there was no trouble or anything, so he would have went back. So no trouble. Letters of recommendation were fine. I guess if he wants to look to apply and when he hits 2 years, I wouldn't be opposed to that. Looking at maybe more of a positive after it's been 2 years. I mean, we're getting close, but it's what, 5 months away?
I just had a lot of pause on this because 2 of the convictions were highly applicable to what we do. I mean, he was in residential properties with access to homeowners' belongings and then chose to burglarize that and physically attack the residents of the home on the invasion or home invasion. I'm just concerned because of the clear association between the convictions and what a licensee does on a day-to-day basis.
Understood, but it was over 10 years ago.
I'm just telling you what gives me pause on that. We have
No,
a lot
I
of
think
that are older, but they are not directly associated with what we do and what our clients do.
Maybe I can help out on this one. If you recall, the timing for the conviction, for assessment of conviction, starts either from the day of the offense or from the day of release from incarceration. So if you look at it from that standpoint, that is still a very ripe conviction offense.
So we can look at day of release.
So does
Well,
someone?
then I think if that's the case, and we all are giving pause to it, so maybe we give right now a negative opinion.
Okay, you want to make a motion?
Yeah. Motion to give a negative opinion on the motion to give a negative preliminary advisory opinion.
Okay, is there a second?
Did we want to put any notes in there that
I know that
like
we were told
reapply or apply?
I know we were told in the past that they recommend they review this meeting to hear some of our commentary and conversation as to why. So I don't know if we need to put it in here, but I think it is just a little ripe, and I think if he allows himself just a little bit more time to acclimate and to, you know, which it sounds like he's on the right track, and if he just kind of continues on that path and reapply when there's a little bit more time, I mean, it just feels very, very soon.
Okay.
Since
Autumn,
it
were
was
you doing a second
2024.
or were you just asking a question?
I was just in the notes section. If we could provide something helpful, like, maybe come back after your 2 years of probation has lapsed. Then we can give you another opinion.
Yeah, we direct them to this recording, so.
Okay, perfect.
Yep.
Thank you.
So we need a second.
I'll second.
Okay. Any further discussion? All right, all those in favor?
Aye.
Aye. Any opposed? Motion passes.
Licensing matter C is complaint number 2025-1383. This is also a preliminary advisory opinion. On June 26, 2025, the applicant was convicted of misdemeanor harassment. The applicant was sentenced to a 2-year deferred judgment. The deferment started on June 26, 2025 and is still ongoing. On June 26, 2025, the applicant was convicted of violation of a protection order, a misdemeanor. The applicant was sentenced to a 2-year deferred judgment. The deferment started on June 26, 2025 and is still ongoing. There is no recommendation, and I can answer any questions you may have.
On this one, my notes were a negative opinion, but it was mainly because he's still dealing with the probation.
Yeah, mine too.
Same.
Okay, someone want to make a motion?
A motion to give a negative opinion for preliminary advisory until such time that 2-year deferment has come to fruition.
Okay, is there a second?
Second.
All right, any further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes. Now we are on to ESP matters.
Okay, I'm going to make this easy, hopefully. Matter A, I am going to pull. Feel like you need to get a little more information pulled together before I have you review that one, so it'll likely be on your next agenda. Matter B is a violation of a final agency order. They have failed to comply with that. So we are seeking, or we are recommending that we seek a violation of 1210-217-1M, which is violating the order, fine of $2,500, public censure, final agency order, and a revocation in this case. And although this individual's license is currently expired, they remain within that period of automatic right to renewal, so it is still within the jurisdiction, and it appears that this individual doesn't really have any interest in maintaining their license by disregarding the regulation.
And they have not been communicating, is that right? Is this just
They were for a while, and then it has stopped. It has completely stopped.
Okay.
It was an ongoing battle to try to get them to comply with an earlier order. So there was communication. It has been sporadic, but as of late, there's no more communication.
Okay.
Does someone want to make a motion?
Motion to accept the staff recommendation for discipline.
All right, do we have a second?
I'll second.
Any further discussion? All those in favor?
Aye.
Aye.
Okay, any opposed? Okay, motion passes.
Okay, the next one is referring to case 2024-2242. This is also a violation of a stipulation that was signed in May, agreeing to both a fine and completion of coursework, and they have done neither. They are currently, they inactivated their license, and under those circumstances, we sometimes offer that we will stay the coursework and have it due upon a reactivation, but they are again disregarding the order. The stipulation that they signed says that if they do not comply with the order, then the next step is formal discipline. So we're recommending a final agency order, public censure, a fine of $2,500. Typically, we do a 30-day suspension and to continue until compliant. That's what we're recommending.
Any discussion, or does someone want to make a motion?
Motion to accept staff recommendation as presented.
Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
That's all I have for you. Thank you.
Thanks, Penny. All right, we had a AG matter on the schedule, but we already talked about forms process. So do we need to go into executive session for that, or are we?
No, we already approved it.
Yes. I know, I'm just asking.
Yeah.
Okay. Then we are good to go unless anybody has anything else.
One thing, I hope that our next several meetings are not 8 hours.
That would be nice.
Yes.
That would be very nice. So, okay. Do I need a motion? We just adjourning.
No, you need a motion.
Okay, someone want to make a motion?
Motion to adjourn.
Okay, do we have a second?
Second.
Okay. All those in favor?
Aye.
All right. Happy holidays,
Happy
everybody.
holidays, everyone.